Huh?
Executor petitioner is suffering from cancer, my
Huh.
lord. It's a probate non-contentious, my lord. Let it be appear at top,
It
my
is
lord.
not in the list.
No, my lord, it is not in the list. Let it be appear in top someday, my lord.
Top, it will not. Let it come in the list. Let us see.
My lord, cancer, my lord, suffering from cancer, my lord. That is the difficulty. Otherwise, my lord, I have other matters in list, my lord. I would do not mention, my lord. Usually.
Ready?
Yes, ready. Non-contentious.
Monday. Top mega.
Application, my lord. Application for probate. My lord, may I have my lord's leave to my lord short serve and move an application tomorrow, my lord. This is in connection with the suit which is coming up tomorrow, my lord. My lord, with all the interlocutory applications, my lord, there in the list. My lord, had passed this order, my lord, directing all the interlocutory applications to come up in the list. My lord, I have had to file this application urgently, my lord, seeking amendment of the plaint and impleadment of additional parties, my lord, against whom, my lord, we need extension of the order already passed by, my lord. My lord has already granted us an ad interim order. Subsequent to this, my lord, we've come to learn of certain other assets of the trust. It's a public and religious trust, my lord. I need the order, my lord, to be also extended to cover those additional parties, my lord. They're banks. Banks with whom, my lord, the trust has fixed deposits, which the defendant is now trying to dispose of. My lord, will kindly grant me leave to short serve and come up tomorrow, my lord.
What will happen if the short service also? How?
Yes, my lord. My lord, tomorrow the other applications are coming up, my lord. We'll try and press it, my lord. My lord will adjudicate, my lord. My lord, if it can only be short serve and come up tomorrow, along with the other applications, since the suit is already coming up. Obliged, my lord.
Allow the plaintiff to file. Allow plaintiff for the plaintiff.
Plaintiff.
Allow the plaintiff to file this application today with the short service to the defendants.
Obliged.
My lord, another, my lord, regular probate matter, my lord, of 2022.
My lord, I'm mentioning for listing of 2 commercial suits under the heading undefended suits, my lord. The respondents have not filed the written statement within 120 days, my lord.
Have you obtained report?
My lord.
Have you obtained report?
My lord had passed an order to this effect, my lord.
Already passed.
Yes,
so
my lord.
The case is not, when the matter is fixed for undefended suit, witness action, it is not fixed.
My lord, it has not been fixed. I'm mentioning for fixing the matter, my lord. For listing of the matter.
When the date is fixed.
My lord, there is no date of the suit,
No,
my lord.
if this court fix the cases for the undefended suit, this court is fixing for the witness action. How it has
My lord, it has not been fixed for undefended suit, my lord. I'm mentioning for fixing.
To be mentioned, Meleo.
Grateful, my lord.
Yes, next. Call the list.
My lord, I appear for the defendant in this matter.
I appear for the plaintiff, my lord.
Yes. Possibly a date correction is required, my lord, in the order. A date correction, my lord. Lordship had fixed it on 11th of June. My lord,
it is 16?
It's a typographical possibly error.
11 June.
Yes.
And if I remember it correctly, Lordship had said, my lord, 2 p.m.
2 p.m. 11 June 2 p.m. में देखो है and क्या CSCOM 343 and the matter is listed as to be mentioned for correction in the order dated 13th March 2025. By an order dated 13th March 2025, this court has fixed the matter on 6th June.
11th June, my lord.
11th June 2025 at 2 p.m. But inadvertently, in the order dated 13th March 2025, in the last line, the date is recorded as 11th March 2025 instead of 11th June 2025. Accordingly, in the order dated 13th March 2025, in the last line, the date shall be read as 11th June 2025 at 2 p.m. instead of for witness action instead of 11th March 20.
Grateful, man.
This order may be incorporated. Order dated 13th.
Item number 2. Lord, I appear on behalf of the defendant. Lord, in an undefended suit, my lord, the witness of the plaintiff is in the box. My lord, by your lordship's last order, my lord, extension was granted, my lord, to file the report today. My lord, a very short extension is required, my lord, because the witness is in the box being cross-examined. About 70 questions have been asked. My lord, I hope to finish it within, my lord, 2 sessions. I think 2 sessions would be enough,
Undefended suit, so many dates.
My lord,
when the original commission was appointed, when the first date of the
commission started 23rd September, the second sitting.
The examination took some time because I had to ask a lot of questions on each and every document. There were various invoices signed by various persons, so I had to prove each and every signature.
Plaintiff witness number 1, it's going on.
Yes.
Only one witness.
Only one witness.
Cross-examination is going on. It will
till September. Wow.
We are apologetic, my lord.
So-and-so suffering for the plaintiff, so-and-so suffering for the defendant. The matter is listed as to be mentioned on the prayer made by the counsel for the defendant. It is submitted by the learned counsel for the parties. The examination in chief is going on.
My lord, the cross-examination.
Cross-examination of the plaintiff witness is going on, and as such, the prayed for extension of time to file report by the learned commissioner. Considering the submission made by the counsel for the respective parties, time to file report by the commissioner extended for a further period of 4 weeks.
4 weeks.
My
4 weeks
lords.
will be over.
My lords.
Within 4 weeks, let the matter appear on, and the commission is directed to file report. Commercial matter
Yes.
by
Commercial.
29th of April 2023.
Deeply
This is
obliged.
the matter on 25th of
Great.
25th, 29th. This is the matter on 29th. Yes.
My lord, I beg to appear defendant number 7.
I am appearing on behalf of. I'm appearing for the plaintiff, my lord. I am to file my written notes. My lord, the notes are on its way. It's getting stitched. My lord, I am praying for a short 5-minute passover. I shall hand over the note and file it.
What about the other?
My lord,
My lord,
they have the defendant numbers 3, 4, 5.
last occasion, my lord.
They are the main applicant. The
You
other
will be
defendant-
filing today.
I am
na?
filing today, my lord, in 5 minutes, man.
My lord, one thing may I clear, my lord? My lord, if my lord takes up my lord's order dated 9th of August 2024. My lord, I raised the point that writ of summons nahi hona okhane. Eta ber koro please.
Ah.
The writ of summons, my lord, was not lodged by the plaintiff, and my lord, we are unable to, my lord, to file the written statement. My lord, they said, my lord, they will take steps for lodging my lord writ of
Yes.
summons.
My lord,
They have not
we are
yet-
in the process of filing an application for extension of time to lodge the writ of summons. My lord, since this application was pending, my lord, we shall file it before the next date, my lord.
My lord, they have not taken any steps in this suit.
My lord, they had already.
So-and-so suffering for the plaintiff.
My lord, today is not the date for making all these
So-and-so
submissions.
suffering for the defendant number 7, comma defendant number 3, 4, and 5, comma defendant number 8. ये देख कर देना. Counsel for the plaintiff has filed the written notes of argument. Let the same be kept with the record. CAV.
My lord, kindly record my submission with regards to my lord writ of summons. My
My lord, my learned
Come on
friend is
the
not
next- come on the
appearing in the
next day
G1.
only for filing written notes of argument.
This has been fixed only for filing the
Come on
written
the
notes.
next
My
day,
learned friend
if
is
they
not
will file an
appearing in G1.
application, you raise objection,
G2.
consider it. Yes.
My lord, kindly seize the order. My lord, the confusion, my lord, which has been created. Possibly we should have come and sought a correction in one line. My lord, my application and the prayer which was there in my application was for extension of time to file the written statement. That is my prayer. I am carrying the application. Now, lordship kindly comes to internal page 2 of the order.
Yes.
My lord, at the top, my lord, the third line. Defendants could not prepare the written statement, but the defendants have prepared the written statement and affirmed the written statement on 25th February 2025. That is within the outer period of 120 days. And as such, he prays for acceptance of the written statement. My lord, two modalities lordships usually follow. Either it is, my lord, a leave granted by the court, recorded on the fiat, or, my lord, an order of the court. My lords, in the same page, if your lordship sees the third last paragraph, this court is of the view that one opportunity should be given to the defendant to file the written statement, subject to payment of cost of.
The second paragraph, London Council raised no objection submitted, though the defendants
Have not
the
filed.
return within the 30 days, but have filed the return within the outer period, and as such, the same can
My
be
lord,
accepted.
My lord, this is their submission.
Correct.
It is not, my lord.
Correct.
My submission was, which is also in my application, that I have annexed the affirmed copy of the written statement. It is within the my lord, outside the 30-day period, within the 120-day period. Therefore, I was seeking leave.
Then heard the London Council for the respective parties.
This court finds that though defendants have not filed written statement within the period of 30 days, but have affirmed the written statement within the outer period of.
And file the same in the department with the
My
leave
lord,
of
this sentence in the order is, my lord, if your lordship reads the next line, this, because this lordship had, my lord, in the operative part of the order, lordship has recorded this, but lordship has also thereafter recorded that one opportunity should be given to the defendant to file the written statement.
Correct.
This was, my lord, granted because, my lord, my written statement was affirmed on 25th February. Outer period of 120 days was expiring on 12th of March.
That is the problem. Advocate on record or telling something, giving some advice to you, because my memory is so high. What is going in the court, I keep the memory.
It should have been, my lord, I should have come and got it
Not
corrected, my lord.
on that day, you have taken the instruction from your advocate on record. Your advocate, no, yes, it is filed.
My lord, subject to, my lord, correction, my lord. It was, since my application was there with the, my lord, prayer for extension of time to file the written statement. My lord,
Because in none of my judgment, if the affidavit is affirmed, I am not allowing unless it is filed. Merely affirmation of the written statement it is my judgment. Merely affirmation of the written statement cannot be said to be the
correct.
The written statement filed in the department.
No, my lord, here lordship allowed it because it was, my lord, affirmation and filing was happening within the 120-day period. My lord, the affirmation and the filing was happening within the 120-day period, and lordship's order is of 7th March. My lord, 12th of March we paid the cost, and 12th of March we submitted the written statement accepted by the, my lord, department.
Problem is that the process also of the court is very difficult. You file one place, the come to scrutiny some other place, acceptance for some other place.
That's
that is
the very difficult thing.
That is also difficult.
But
You filed in the department accepted, shown the this.
It's easier if lordship's officer endorses it after the application is allowed. So, my lord, there is no confusion with regard to the, and since, my lord, the date is mandatory now, my lord, beyond a particular period, my lord, it cannot be accepted.
One matter, my lord, there is a lot of controversy regarding this before the division. On the 120th day, it was allowed by the learned single judge. The other side preferred an appeal saying that the master summons have been taken out after 120th day. So therefore, the learned judge could not have allowed my application. That was their case because there was no application or written statement within the 120th day. My lord, my advocate on record through his clerk affirmed affidavit saying a lot of things. My lord, three affidavits filed, 2-3 reports from the master. Ultimately, we were saved because it is not appealable order. Ultimately, we got saved because it was not an appealable order. But, my lord, this is a flaw in the department. What is happening, my lord, when we are taking out a master summons, that scrutiny is taking some time. And there is no record in the department to show that on this date I have given the master summons to the department.
See why the scrutiny is taking time. I also don't understand because just 2-3 years before I have taken the determination. Scrutiny of the department is only to see the procedural aspect.
Exactly.
Not the not the averment.
Exactly. But they are going into it.
But it is the averment has been corrected by the department.
And they must have a register, my lord, where it should be recorded that on this date I have given the master summons.
It has come, it has been notified, it has been done.
So if it is shown that I have given them the master summons after 120 days, I go out.
Very different.
My lord, kindly, my lord, lordship's internal page 2, lordship has correctly recorded that opportunity should be given to file the written statement. My lord, the confusion was created because.
However, my lord, this today it has come because of GA3. Oh, but this also takes on record my affidavit in reply in GA3.
GA3 hai. GA3 is fixed today.
It's
not on record. It is not in the list. Huh? Hai? GA3 hai. So suffering for the plaintiff, so suffering for the defendant. The matter is listed as to be mentioned. With regard to there is some confusion for acceptance of written statement.
I take responsibility for that
confusion. The order dated 7th March 2025. Full stop. By an order dated 7th March 2025, this court has accepted the written statement on the ground that the defendant though has not filed the written statement within the period of 30 days, but has affirmed the written statement on 25th of February 2025, that is within the outer period of 120 days. And this court has also recorded that the same has been the same is filed in the department with the leave of this court. But when the written statement, in terms of the order dated 7th March 2025, when the written statement was filed, it was found that the written statement was not filed in the department as recorded in the order dated 7th March 2025. And as such, the department has not accepted the same and placed the matter before this court. Consider the submission made by the counsel for the plaintiff, counsel for the defendant, peruse the written statement. This court find that by an order dated 7th March 2025 has accepted the written statement. And the written statement was affirmed within the 120th days, and the 7th March 120 days was over.
My lord, 120 days was over on 12th of to expire on 12th of March. So pursuant to your lordship's order.
And 7th March 2025, the period of 120 days was not over. Accordingly, the department is directed to accept the written statement.
Very grateful, my
lord. The order dated 7 March 2025 is modified to the above extent. Yes. Affidavit in reply filed by the plaintiff in connection with GA3 of 2024.
Yes, ma'am.
Be kept with the record.
Well, let this order be treated as part of the order of 7th of March. Otherwise,
recorded.
Well, apologies for the, my lord, inconvenience caused. My lord.
Okay, next.
My lord, in this matter, I appear on behalf of defendant number 3.
Yes.
Should I appear on behalf of the defendant number 1? This is my application, Your Lordship, to add further ambiguity to the issue. Lord, I'm sorry to interrupt my learned friend, but there's no application which is appearing today.
Defendant number 1 handed over a receipt.
It is appearing. GA2, I believe. GA2 is appearing. I believe GA2 is. It was subject to correction. Report to be furnished. Lord, as to see as to.
Yes, have you obtained the report? You are for the plaintiff. You are for the plaintiff. Have you obtained report?
1 and 2, my lord, the report I have.
And my lord, I appear for defendant number 3, my lord. I pray for some time to file my written statement because I have received all the papers on 27th January.
Yeah.
The complete.
Yes. Payment. No, this court has directed defendant plaintiff prays for time to obtain report from the defendant to ascertain whether the other defendants have received the writ of summons or whether they have entered at appearance or filed written statement. So many defendants are there. Plaint ka hai?
4 defendants. Lord, report in respect of 2. Lord, by Your Lordship's earlier order, Lord, defendant number 4 was permitted to file its written statement about taking.
I appear for the defendant number 4, my lord.
Who is for the defendant number 1?
Lordship, I appear on behalf of the defendant numbers 1 and 2.
And 2? You are appearing. 3?
My lord, I appear for defendant number 3.
4?
My lord, I appear for the defendant number
4. So 1 and 2 service is there. What about the 3 and 4?
Lord, 3, my lord, report we not been able to obtain, my lord. 4 has already filed.
4?
Lord, 4 has already filed.
Written statement.
Number 4, my lord, there was an order passed upon an application being moved. Your Lordship was pleased to grant leave to file written statement.
It was admitted on 18th February, my lord.
Written statement. And what about the 3?
My lord, whatever my instruction is that I have received illegible copies of the annexure.
When you entered appearance?
Today is the first day I'm entering appearance.
Writ of summons, when the writ of summons was served?
As per the instruction, my lord, I have received the writ of summons on 7th October 2024. But my lord, I have already sent them a letter stating that there are no annexure mentioned. The complete plaint was not served upon me. And I have received the complete set of the plaint on 29th January.
And what about the defendant number 5? Performance defendant?
Lord, not appear.
Not served. So
To To that, my learned friend has accepted the letter as well.
Lord,
That
that letter is there with us. Lord,
Yes.
they had written to us saying that 5 or 6 pages they were not there. Lord, annexures. Lord, after that, on 14th January, Lord, we've served a complete copy of the plaint along with the annexures there too. Lord, which were missing. Lord, may I hand up a copy of the letter which was received by my Lord, which we have forwarded the written statement, the complete copy.
Yes. 14 January you received.
yes,
Yes.
I received it on 14th.
You have not filed the return statement.
Not yet, my lord. I shall file it within time.
Application.
There is no application. And what is your telling? What is your submission?
Your Lordship, I appear on behalf of the defendant number 1 and 2. Lordship, my application is to cast further ambiguity in the point of acceptance of written statement. Your Lordship, I'll take Your Lordship. My point that I've taken in my application is I have received the plaint.
Which
But
application you filed?
Lordship, GA2.
GA2 का है?
Lordship, the point that I've taken is it's a law point. So I was served with the plaint, but Your Lordship, apart from the plaint, under the Commercial Codes Act, they are also required to serve the statement of truth and affidavit of documents. I was not served with that, and I wish to show it to go through the provisions and show Your Lordship that this is mandatory under the Commercial Codes Act. Only the plaint was to be served in the original side, Your Lordship, no issues. But after the coming of the Commercial Codes Act, the language of the statute itself states that it is mandatory for the statement of truth and affidavit of documents also to be served with the plaint.
Correct.
Lordship, since I have not been served, it's a
Have you
defective service.
have you informed the other side?
No, Lordship, we filed an application.
When you receive the plaint?
Lordship, on sometime in November 2020.
So after the November, when you file this application?
Lordship, this application was filed on March.
March.
So I have entered appearance in January. So this is a point of law. Your Lordship may hear me, Lordship, subject to whatever falls from your Lordship.
Lord, I wish to use an affidavit to this, Lord, because the report of the Lord, the website shows otherwise, that all of the affidavits were served under Order 11. Compliance is there. Lord, will kindly turn over the page. Lord, each of them 14th August 2024, my lords, all of it has been served. So, my lord, kindly permit me to use an affidavit and bring this on record. Because, my lord, the office of the department confirms that all of it has been served.
So may I be clear?
Sense appearing for the plaintiff. Sense appearing for the defendant number 1 and 2. Sense appearing for the defendant number 3. Sense appearing for the defendant number 4. None appears on behalf of the defendant number 5. Police. The counsel for the defendant number 1 and 2 have filed an application being GA Com 2 of 2025, praying for extension of time.
Lordship, it's on that
What is the prayer?
Lordship, my prayer.
Praying for a direction upon the plaintiff to serve the copy of the statement of truth, affidavit in terms of Order 11 Rule 1 of the CPC, service of all documents along with the plaint. Counsel for the plaintiff prays for time to file affidavit in opposition in connection with GACOM 2 of 2025. Let affidavit in opposition be filed within 2 weeks. Reply, if any, there to be filed within a week thereafter. Full stop. Counsel for the defendant number 3 submits that after receipt of the writ of summons from the plaintiff, the defendant number 3 found that some of the documents were not legible, and accordingly the same was informed to the learned counsel for the plaintiff by a communication. And on 14th January 2025, the legible copy of all the documents have been served to the defendant number 3. Counsel for the defendant number 4 submitted. Defendant number 4 already filed the written statement in terms of the order passed by. Counsel for the plaintiff submitted. He will take appropriate step for service of writ of summons upon the defendant number 5 within bracket. Service. Where is the service of defendant number 5?
Lord, we'll check, Lord, whenever Lordship makes it
Counsel for the plaintiff submitted. Then counsel for the plaintiff submitted. He will take appropriate steps whether the writ of summons was served upon the defendant number 5 or not. If it is not, writ of summons was served upon the defendant number 5 or not. If not, the plaintiff will take appropriate steps. Full stop. Considering the submission made by the counsel for the respective parties, let the matter appear on 11th April 2024.
Grateful. Grateful.
Now, under the heading new motion. Yes, next.
Number 8. My lord takes up item number 8, my lord. May I file the written notes in item number 3? The written notes in item number 3. I've already served the others. Item number 8, I'm appearing for the petitioner, my lord. In this matter, my lord, on the previous occasion, on 11th of March, there was a direction for the Superintendent of Police Tirupati and officer in charge Tiruchenur Police Station to appear before this court through virtual mode, my lord, and at 10:30. But my lord, on that occasion, the matter could not be taken up at 10:30, and my lord had directed the matter to reappear today. My lord, according to my lord's direction, I have served copies. I have served the order by speed post on 12th of my lord, on 12th of March itself. The order of 11th March I had communicated, and it was received at least at the second address, my lord. It was received yesterday at 9:34 a.m. With regard to the first address, my lord, it was out for delivery as on 9:22 a.m. yesterday, my lord. And my lord, I believe the officer in charge is.
To whom it was served?
My lord, it was served.
Superintendent of Police, Tirupati, Andhra Pradesh.
My lord, it was served on the officer in charge. It was served with regard to the superintendent of police. It shows out for delivery as on 9:22 a.m. yesterday, my lord.
Where?
My lord, will kindly come to the second last page. My lord, rather the third last page. The consignment receipts are there. My lord, will see. The consignment, the postal acknowledgement receipts. My lord, the first one is not legible. I have verified from the second document in the list. The original is. The second document is EW 184364209. My lord, this is the last page, 4209. That was to OIC Tiruchenur. My lord, that is the officer in charge. My lord, that was received at the last page. If my lord takes up, that was received yesterday at 9:34 a.m. Item delivered to addressee. And my lord, if my lord takes up the previous page, my lord, it is indicated.
How the postal service is delivered in the late hours?
Not late, my lord. It is in the morning. 9:32 a.m. My lord.
Yes.
My lord, AM. It's a 24-hour clock, my lord. My lord, and on at 9:22 a.m. it was out for delivery insofar as the superintendent was concerned, my lord.
That is not served.
My lord, I till now it was not updated. I have taken this printout as of last evening. It was not updated as on that time, my lord. It is not updated till this morning, my lord. I have checked, my lord. And my lord, I had issued the notice at 12th of March at 6:49, my lord. The order was passed on 11th of March. The very next day, I have put it out for posting, my lord. And this is also indicated at booked on. My lord, will kindly see the second column in the box at the top. My lord, booked on 12th of March 2025, 1849. So my lord had immediately taken steps. I believe one of the officer in charge is virtually present before my lord.
Present.
And my lord, I have also.
Is present. Yes.
Yes, my lord. I am officer in charge of East Police Station, sir. That is not Tiruchenur Police Station, sir. The respondents are not residing in the Tirupati, sir. They are a native of Nellore district, sir. They are moving around states, sir.
So you are not having the mobile numbers of the persons. You cannot locate the persons where they are.
The mobile numbers all are changed, sir. changed, my lord. We are searching, sir, searching, my lord.
How much time you required for execution of the warrant?
My lord, 1 month necessary, my lord. 1 month, please give me time, my lord. Yes, my lord. He is not residing in Tirupati, my lord.
The warrant is still with you?
Yes, my lord. Yes, my lord.
So I am extending the warrant, time of warrant for execution as and when they will arrested, produced before this court.
Please, my lord, submit, my lord.
So you should not take the plea that the warrant has been returned to the court without the execution.
No, my lord, we will pursue, my lord. We will serve, my lord.
My lord, may I only indicate one thing for my lord's benefit in terms of the documents which have been submitted by the other contemners, the contemner number 1, 2, and 4, they are running a hotel in Tirupati under the name of a different company, my lord, not the Sudalagunta Sugars, which is the contemner company. But these directors, they have been running a business from that particular area as well, only for my lord's benefit, because that may help in the.
What is the name of the where Tirupati?
In Tirupati.
What is the name of the hotel? Which page? आप लोग citizen का है? What is the name of the
submission?
Yes.
Milata, in Tirupati, they are having hotels, Milata, but since 5 years they are closed, Milata.
Yes, yes.
Closed, Milata. Hotels are closed, Milata. Closed, Milata.
Okay.
Closed and sugar factory also.
It was Sudalagunta Hotels Limited, Tirupati. That is the name of the company, my lord. Page 44, annexure.
So and so appearing for the plaintiffs. So and so appearing for the alleged content number
5, 6, 7, and 8.
5, 6, 7, and 8. Police. The officer in charge Tiruchenur police station is Tirupati, Andhra Pradesh is present in person, present through virtual mode, and submit that after receipt of the warrant from this court, the police of Tirupati has tried their level best to locate the contemners, but they are not available in the said district. And the officer in charge of the Tiruchenur police station, Tirupati, pressed for a month time to execute the warrant and to produce the contemners before this court. Police. In terms of the submission made by the officer in charge Tiruchenur police station, Tirupati, from Andhra Pradesh, time to execute the warrant issued against the alleged contemners is extended for a period of 1 month from date. The officer in charge Tiruchenur police station is directed either to produce the alleged contemner after the arrest before this court. If they are not been able to arrest the accused persons and the contemners, the officer in charge shall file a detailed report before this court on आज कितना तारीख है?
Today is 18th March.
On 22nd of April 2025. As regard the appearance of the superintendent of police Tirupati, Andhra Pradesh, the date has not been communicated to the superintendent of police, Tirupati. Accordingly, the plaintiff is directed to take appropriate steps for informing the next date of hearing to the superintendent of police, Tirupati, Andhra Pradesh. If the communication is received by the superintendent of police, Tirupati, Andhra Pradesh, he will submit the detailed report on the date fixed.
And my lord may also direct, once the superintendent is served, my lord, he may pass necessary instructions for enforcing the warrant on
Pass appropriate report.
Very well, my lord.
Police.
But may I take back the original copy
Yes.
of the letter, my lord?
Take.
I have supplied a copy. Much obliged.
My lord, I appear for the plaintiff, my lord, in this matter. This is for presentation of plaint, my lord. The only leave I am seeking, my lord, it's a money recovery suit. My lord, the leave I am seeking is under clause 12 of the latest patent. My lord, this is the transaction was, my lord, the plaintiff was to supply, my lord, chemical resins to the defendant. Unpaid price of, my lord, goods sold and delivered. My lord, the cause of action which has arisen within, my lord, is in paragraph 5, the agreement. Then, my lord, my bank account, plaintiff's bank account were credited. My lord, the bank account is within, that is in paragraph 7 of the plaint. And a balance confirmation was issued by the defendant, which was also received, my lord, within. That is at paragraph 8. Then, my lord, paragraph 11, part payments were received within jurisdiction. And thereafter, they had, my lord, issued a check for the balance amount that got dishonored. The intimation was also received within jurisdiction. Now, so far as, my lord, outside, my lord, jurisdiction, that cause of action, my lord, supplies were effected from outside. That is in paragraph 5. My lord, the meeting that happened, my lord, where, my lord, they agreed to pay in November 2020 in paragraph 14, my lord, I have stated that happened, my lord, outside the jurisdiction. And, my lord, the check that was, my lord, issued, that which got dishonored, that was drawn from a bank account which is outside jurisdiction. So, my lord, I am seeking leave under clause 12 of the latest patent. My lord, only one, my lord, issue. We had applied for the court fees. I have received the court fees of 50,000. Kindly permits me, my lord, or grants liberty, my lord, to file this in the department, my lord. This is the original court fees.
The plaintiff has filed the present suit for present suit praying for a decree for a sum of rupees 1,62,10,328 along with interest at the rate of 24% per annum. Counsel for the plaintiff submitted the part cause of action arose within the jurisdiction of this court and part cause of action arose outside the jurisdiction of this court. Accordingly, the plaintiff has prayed for leave under clause 12 of the latest patent. Counsel for the plaintiff submitted the plaintiff has also purchased the court fee
of 50,000, my lord.
Rupees 50,000, and he prays for leave to file the same in the department. Heard the learned counsel for the plaintiff peruse the plaint. This court find that part cause of action arose within the jurisdiction of this court and part cause of action arose outside the jurisdiction of this court. Accordingly, leave under clause 12 of the latest patent is granted. The plaintiff is also granted leave to file the court fee of rupees 50,000 in the department in course of the day.
My lord, since the file has to go down, 1 day will be required. By tomorrow, my lord, if it can be done.
On or before 21st of March 2025.
21st of
And the department is directed to accept the court fee. Court fee if the plaintiff is and the department is directed to accept the court fee. Full list. The plaintiff is admitted subject to scrutiny by the
grateful man.
Next.
Okay.
Yes.
My lord, I had started citing Brolia.
Yes.
Lordship would kindly consider it.
कल एक जजमेंट दिया था
2021 2S.
Yes.
Which Lordship would kindly consider paragraph 147.5. That's
153 of completed.
153 had completed.
Yes.
Now 153, then Lordship would kindly consider 154.2.
154.2, yes.
scope of judicial review and jurisdiction of the court under sections 8 and 11 of the Arbitration Act is identical but extremely limited and restricted. The general rule and principle in view of the legislative mandate clear from Act 3 of 2016 and Act 33 of 2019 and the principle of severability and competence is that the arbitral tribunal is the preferred first authority to determine and decide all questions of non-arbitrability. The court has been conferred power of second look and aspects of non-arbitrability post the award in terms of subclauses 1, 2, or 4 of section 34(2)(a) or subclause 1 of section 34(2)(b) of the Arbitration Act. Rarely as a demurrer, the court may interfere at section 8 or section 11 stage when it is manifestly and expressly certain that the arbitration agreement is non-existent, invalid, or the disputes are non-arbitrable, though the nature and facet of non-arbitrability would, to some extent, determine the level and nature of judicial scrutiny. The restricted and limited review is to check and protect parties from being forced to arbitrate when the matter is demonstrably non-arbitrable and to cut off the deadwood. The court by default would refer the matter when contentions relating to non-arbitrability are plainly arguable, when consideration in summary proceedings would be sufficient and conclusive, when facts are contested, when the party opposing arbitration adopts delaying tactics or impairs conduct to arbitration proceedings. This is not the stage for the court to enter into a mini-trial or elaborate review so as to usurp the jurisdiction of the arbitral tribunal, but to affirm and uphold integrity and efficacy of arbitration as an alternative dispute resolution mechanism. The Lordship would kindly consider paragraph 233. This is for the supplementing judgment. It starts at page 122. The Lordship would kindly consider paragraph 233.
Paragraph
233 at page 160. 233.
Yes.
From the aforesaid discussion, we can conclude that the defendant has to establish a prima facie case of non-existence of valid arbitration agreement, wherein it is to be summarily portrayed that a party is entitled to such a finding. If a party cannot satisfy the court of the same on the basis of the documents produced and rather requires extensive examination of oral and documentary production, then the matter has to be necessarily referred to the tribunal for full trial. Such limited jurisdiction vested with the court is necessary at the pre-reference stage to appropriately balance the power of the tribunal with judicial interference. The amendment to the aforesaid provision was meant to cut the deadwood in extremely limited circumstances, wherein the respondent is able to expressly portray non-existence of valid arbitration agreement on the documents and the pleadings produced by the parties. The prima facie view, which started its existence under Section 45 through Shined through case, has been explicitly accommodated even under domestic arbitration by the 2015 amendment with appropriate modifications. Before we part with this aspect, it was extensively argued before us that the test for the court is to see whether a party is able to establish a good arguable case for establishing the existence of the arbitration agreement. However, the statutory language under sections 8 and 11 emphasizes on the threshold requirement for a party for establishing the opposite. No doubt, the aforesaid approach may have merits. However, if the good arguable case standard is integrated for a party requiring to show non-existence, then the same would amount to judicial activism. Such attempts to integrate alien formulations into the Act, which has already suffered sufficient judicial subjectivism, needs to be dissuaded. So, my lord, I will come to the latter paragraphs. 153 and 235, particularly, makes it clear now the case is the reverse. Not that I have to establish there is an arbitration agreement, there is a good arguable case. Whoever opposes has to establish that arbitration agreement does not exist. Now, my lord, paragraph 240. On the very next page at the bottom.
240?
40.
Yes.
Courts, while analyzing a case under Section 8, may choose to identify the issues which require adjudication pertaining to the validity of the arbitration agreement. If the court cannot rule on the invalidity of the arbitration agreement on a prima facie basis, then the court should stop any further analysis and simply refer all the issues to arbitration to be settled. In fact, my lord, even 238, 239, my lord, plus 238. At the cost of repetition, we note that Section 8 of the Act mandates that the matter should not be referred to arbitration by an arbitration by court of law unless it finds that prima facie there is no valid arbitration agreement. The negative language used in the section is required to be taken into consideration while analyzing the section. The court should refer a matter if the validity of the arbitration agreement cannot be determined on a prima facie basis as laid down above. Therefore, the rule for the court is, when in doubt, do refer. Moreover, the amendment to Section 8 now rectifies the shortcomings pointed out in Chlorocontrol's case with respect to domestic arbitration. Jurisdictional issues concerning whether certain parties are bound by a particular arbitration, whether group company doctrine or good faith, etc., in a multi-party arbitration raises complicated factual questions which are best left for the arbitral tribunal to handle. The amendment to Section 8 on this front also indicates the legislative intention to further reduce the judicial interference at the stage of reference. Then the last bit, 244. Next bit. Before we part, the conclusions reached with respect to question 1R, 244.2. Usually, the subject matter arbitrability cannot be decided at the stage of Section 8 or 11 of the Act unless it is a clear case of deadwood. For the court under Sections 8 and 11 has to refer a matter to arbitration or to appoint an arbitrator as the case may be, unless a party has established a prima facie case of non-existence of valid arbitration agreement by summarily portraying a strong case that is entitled to such a finding. The court should refer a matter if the validity of the arbitration agreement cannot be determined.
So that is only 244 second line.
Yes.
That is to be seen.
That is. Yes. Now, my lord, only one more authority I would cite. The lordship would kindly, in this judgment would be, yes, kindly just consider yes, lordship would kindly take up page 119 once.
Of this judgment?
This judgment. 119.
Yes.
Now, 119, paragraph 149, lordship would find an English judgment in premium NAFTA has been referred to. Now, I would, my lord, rely on the last bit of that judgment, some other parts of the judgment.
Yes.
I consider paragraph 7, page 5. One accepts that this is the purpose of an arbitration clause. Its construction must be influenced by whether the parties as
paragraph
7.
7. Yes.
Whether the party, if one accepts that this is the purpose of an arbitration clause, its construction must be influenced by whether the parties as rational businessmen were likely to have intended that only some of the questions arising out of the relationship were to be submitted to arbitration and others were to be decided by national courts. Could they have intended that the question of whether the contract was repudiated should be decided by arbitration, but question of whether it was induced by misrepresentation should be decided by a court? If, as appears to be generally accepted, there is no rational basis upon which businessmen would be likely to wish to have questions of the validity or enforceability of the contract decided by one tribunal and questions about its performance decided by another, one would need to find very clear language before deciding that they must have had such an intention. Then, my lord, paragraph 13. Page 7. In my opinion, the construction of an arbitration clause should start from the assumption that the parties, as rational businessmen, are likely to have intended any dispute arising out of the relationship into which they have entered or purported to enter to be decided by the same tribunal. The clause should be construed in accordance with this presumption unless the language makes it clear that certain questions were intended to be excluded from the arbitrator's jurisdiction. As Longmore Justice remarked, if any businessman did want to exclude disputes about the validity of a contract, it would be comparatively easy to say so. This appears to be approach adopted in Germany. Then, my lord, the quoted portion. There is every reason to presume that reasonable parties will wish to have the relationships created by their contract and the claims arising therefrom, irrespective of whether their contract is effective or not, decided by the same tribunal and not by two different tribunals. So, when the plaintiff is urging that, look here, these are the disputes which are to be excluded from the purview of the arbitration tribunal, this high standard they have to meet, at least at this stage.
No, if you come to, there is every reasons to presume that the reasonable parties will wish to have the relationship created by their contract. The claims arising therefrom respective whether their contract is effective or not decided by the same tribunal and not by the two.
Not by two different tribunals.
So it would be better
if there is a
it would be better the party wanted to maintain the relationship, go for the mediation.
5, 6, my lord, 5, 6, 7, paragraph 7.
No, I understand, but the court which you
that is also, my lord, the effect of the commercial course. That's the intention, but lordship was much better. That is all, my lord.
That's all. Thank you. Yes, Mr. Mitro, you got time. How many judgment? 5, 6.
Me? No.
What?
Innumerable. I can tell you, Lordship, 1, 2, 3, 4, 5, 6, 7, 9. No, my lord, I shall go into the judgments later on. Judgments, my lord, as your lordship is aware, my lord, it fits into the cases, my lord. Let us see, my lord, what is the case. Now, my lord, I don't think that I would be wrong if I say that, my lord, a Section 8 application is practically in the nature of a demurrer application. Now, kindly look into the plaint once. My lord, kindly come to, my lord, page 26 of the application, where, my lord, they have annexed the plaint, of course, without the annexure. I would possibly be required to refer to the annexures also, but kindly come to page 26.
Of the application?
Of this application, yes. Well, kindly come to page 30. I am omitting, my lord, the earlier paragraphs. Those are, my lord, the description of the parties. Kindly come to, my lord, page 30, paragraph 8.
Yes.
The plaintiff states that on 17th May 2023, the defendant number 1 through the defendant number 2 had awarded a job work order to the plaintiff number 1 for providing logistical support to the defendant number 1 for the purpose of transporting its consignment at its plant, and was provided a job to transport 15 numbers backup roll of dimension in nature having a width of such and such, and the approximate weight is about 45 ton, and was scheduled to be delivered by July 2023. The job work order was issued by the defendant number 2 in favor of the plaintiff number 1 on 17th May 2023 from the office at such and such, and was received at such and such.
Yes.
Then kindly turn the page, kindly come to paragraph 11. The plaintiff states that on 30th August 2023, the plaintiff number 1 had received an email from one Rupam Sharkar of the defendant. He is the defendant number 4, madam. And the said email was received by the plaintiff number 1 at its office at 51 Vivekananda Road, wherein it has been alleged that one of the vehicles of the said plaintiff number 1 has been detained at the gate of Bokaro Steel Plant as a number plate of the said vehicle was stickered. Now, my lord, printed copy ache.
Yes.
No, ache. Kindly come to page 43 of the plaint. Sorry.
Yes, 43.
Yes.
August 30th.
30th August.
Yes.
As Messrs. JCC has received information, the number plate of the vehicle arrived plant gate today with number such and such has been found tampered. It seems the vehicle has been changed during the course. CISF has, page 43, plaint. CISF has detained the vehicle and investigation being carried out. If it is substantiated, severe action including discontinuation of license of the driver, vehicle registration, action on the owner of the company, etc. as applicable may be initiated for violation of motor vehicle rules and plant safety norms. We have reiterated several times to adhere to the motor vehicle rules and MORTH guidelines while in transit, which cannot be compromised at any point. It is instructed once again to follow the above, etc. Now, this is the first mail which was received. Now, kindly come back to the petition, the plaint. Or, my lord, if your lordship is pleased to follow from this, my lord. Kindly come to paragraph 12 of the plaint.
Yes.
The plaintiff states that on 2nd September 2023, the plaintiff number 1 had received another email from the said Rupam Sharkar of the defendant number 1, and the said email was received by the plaintiff at its office at such and such within the jurisdiction aforesaid, wherein it has been alleged that the vehicle could not enter the plant till date due to tampering of number plate. But kindly come to page 44.
Yes.
The vehicle number such and such could not enter plant till date due to tampering of number plate as reported. Contractual action has been taken in this case. Kindly take note. Contractual action has been taken in this case.
Yes.
ওটা ভুল হয়েছে has been হবে. Further, the real time status of
contractual action as deemed to be taken or as has been taken. Deemed to be taken.
Really do not know. I thought that has been as deemed to be taken in this case, my lord, possibly. I thought it would, my lord, he wanted to mean as has been taken in this case. Further, the real-time status of other vehicles need to be updated immediately. The photograph of the loaded vehicle along with number plate photo, the concerned persons are to be instructed to inform on urgent basis. Now, kindly come back to my lord, paragraph 13. page 10 of the plaint.
Yes.
The plaintiff states that on 2nd September 2023, the plaintiff number 1 sent an email to Rupam Sarkar of the defendant number 1 narrating the facts and sequence of the incident. I shall come to that mail, my lord, later on. May I place the other paragraph? After receiving the said mail, on that day, that is on 2nd September 2023, it was further intimated by the defendant that the said vehicle could not enter the plant. The email dated 2nd September 2023 issued by the sale was received by plaintiff at its office such and such. Now kindly come to page 45 and 46.
Yes.
45 is the response of the plaintiff, and then 46,
To Rupam Sarkar.
yes, 45 and 47. To Rupam Sarkar, dear sir, with reference to the mail, we wish to share sequence of events with our finding. Vehicle number such and such loaded at port with 2 units since the puller could not enter the port premises due to paper issues. The vehicle detaches 4 axles and the puller outside having registration number such and such joins back and reaches at Cell Bokaro plant on such and such. The vehicle was not allowed inside the plant due to the tax papers not showing active online, and the puller is detached and returned for some other job. The puller number such and such again joins the axles detached at the sale plant. The driver, in order to match the sale requirement,
Change the puller number.
yes, change puller number with such and such and tries to enter the plant, who was then found by CISF personnel and the driver was taken under custody. We get the information on this through mail from your office on such and such, that such an event has taken place, and we inquired this from the vehicle owner, who in turn informs us the complete incident. This was the, basically this was the response. My lord, it's nobody's case that, my lord, the goods under contract were tampered with or anything. There was a dispute regarding the vehicle number. Now kindly come to page 47.
Fix it. 11.
Should I stop?
Census suffering for the plaintiff, census suffering for the defendant. Counsel for the defendant has concluded his argument in connection with GA Com 3 of 2024. Counsel for the plaintiff has argued at length, but due to paucity of time, hearing could not be completed. Matter appear on 21st.
Yes, any time, my lord, if
How much time? 1 hour?
maybe, my lord, yes.
है खाली है ना कब कल नेक्स्ट वीक देखो नेक्स्ट 25th March 11:30 25th March 11:30
Interim order sir extend করে নিন 21 তারিখ ওখানে কবে হবে 26 স্যার interim order 21 তারিখ অবধি
Oh, the interim order is till 21st, my lord. Can it be
the
extended?
counsel for the plaintiff submit the interim order is going to expire on 21st of March 2025 and prayed for extension of the interim order. In view of the submission made by the counsel for the plaintiff, the interim order granted earlier is extended till 28th of March 2020 or until further order.
Okay.
সাড়ে 12টার এটা দেখে হ্যাঁ শুরু তো করবে
Yes.
Yes, my lord. My lord, I had, my lord, made, my lord, extensive submissions, my lord, on the facts. My lord, 2 or 3 things, my lord, I wish to, my lord, draw your lordship's attention to. My lord, kindly come to, my lord, the petition. My lord, before that, my lord, may I just seek one indulgence? My lord, when your lordship fixed the matter that day, my lord, I didn't realize another matter was getting fixed elsewhere. My lord, we'll do the matter. My lord, kindly give me leave in case that's being called on for my learned junior to, my lord, take over. My lord, kindly come to, my lord, page 605, my lord, annexure G. No, petition. 605. Sorry. Of the reply. My lord, kindly, my lord.
Page 603 of the application?
No, of the
Opposition.
reply, my lord. Come on. Reply only.
605,
my lord.
Yes.
My lord, kindly see, my lord, this is ICICI Bank.
Yes.
My lord, this was, my lord, my client is Arvind Mehrotra. My lord, he held a savings account.
Yes.
Now, my lord, the mobile number and email ID, my lord, is of the deceased. My lord, he used to, my lord, operate. My lord, this is, which is why we say, my lord, in ICICI Bank, where approximately 9 crores has gone out, my lord, is as per his instructions. And that chart your lordship set out in your lordship's order as well, to which I shall come. Now, my lord, kindly come to. Yes. And my lord, that it's the email ID of the deceased, my lord, is also evident from the income tax returns, my lord, which we have given. It's all mentioned there.
Yes.
And my lord, Truecaller, my lord, gives his number, which we have, my lord, but it's not my client's number. My client knew, my lord, his phone number. Now, my lord, page 591. My lord, my lord, the insurance premium, my lord, which had been paid. Lordships will find, my lord, this insurance premium, my lord, is, my lord, a total amount of 1,05,473, which I had, my lord, shown, my lord, on, my lord, the last occasion.
Yes.
And, my lord, according to, my lord, and this I must point out, my lord, respondent number 1,
yes.
My lord, huge amounts, my lord, were, my lord, payable by me, which, my lord, had been, my lord, to, my lord, my lord, deceased. But, my lord, kindly have a look at page 592.
Yes.
My lord, of, my lord, the reply. As discussed, please find attached the final profit and loss report of shares trading of 2023-24 and year-to-year profit overall and accrued commission statement of myself. Hope you find the same in order. I will withdraw only in November, December, as I will need some funds at that time. Now, my lord, this is written. Lordship will find on 9th of April 2024.
Yes.
Now, the profit and loss statement summary I have given at 593.
Yes.
My lord, only 12,98,248
Yes.
was receivable for 23-24. And, my lord, and this is the summary, my lord, of, my lord, Kirti Lunia himself.
Yes.
My lord, final profit and loss and accrued commission statement. This is the commission statement. Now, my lord, 594 onwards, my lord, are, my lord, the transactions.
Yes.
My lord, which are, my lord, provided, my lord, here. Right up to, my lord, 604. And, my lord, none of this, my lord, is part of, my lord, what has, my lord, been taken out by him. These are separate transactions completely. And it's his case, my lord, that this was 12 lakhs, which we'll collect in November, December of the end of the year. My lord, he died, my lord, in, my lord, June, on 12th of June. My lord, after, my lord, confirming this statement.
Okay.
Now, my lord, one other fact, my lord, is, my lord, kindly come to, my lord, page, affidavit in opposition, my lord, page 99. My lord, where, my lord, the monthly expense schedule, my lord, has been annexed to the affidavit in opposition.
99.
Yes, my lord. Of the affidavit in opposition, annexure E.
Yes.
My lord, this is kindly see, my lord, school fees of the child, tuition fees, travel, etc., electricity bill, maintenance charges, tax, so and so, so and so. Total comes to, my lord, 1,64,640. Now, my lord, this is the monthly statement. Now, kindly have a look at page 100. My lord, this was the order of the division bench. Now, my lord, without prejudice to the rights and contentions, the parties agree that the appellant number 1 may be permitted to withdraw a sum not more than 24 lakhs from the account bearing so-and-so with Standard Chartered Bank, save as aforesaid ad interim order of injunction shall continue. So, my lord, this 24 lakhs was taken out. So, my lord, this 24 lakhs is there, sufficient to meet, my lord, our monthly expenses. Yes. My lord, for, my lord, close to, my lord, over 1 year, my lord, from, my lord, the date, my lord, which was 3rd of October 2024.
So this has been taken out?
Yes.
Yes, withdrawn.
Yes, withdrawn. My lord, there, my lord, she has this money with her. We are not touching it. She is operating. My lord, now, my lord, page 93 are, my lord, the insurance money. My lord, which is, my lord, to come in. And, my lord, the specific case, my lord, is, my lord, in para 4F of the affidavit in opposition, that, my lord, insurance money, my lord, cannot be touched. Lordship will find page 8 of the affidavit in opposition. My lord, kindly take last 5 lines of that page, part of paragraph 4F. Such policies were protecting us financially to ensure our well-being and day-to-day survival after demise. Such insurance money is immune from being injuncted, attached, and cannot be taken away from us under any circumstances.
Yes.
And, my lord, this list, according to us, my lord, is incomplete and doesn't reflect, my lord, the correct situation, which your lordship will find, my lord, if your lordship comes to page 66, my lord, of, my lord, the petition. 1 minute. My lord, 66, my lord, at page 68. Sorry, my lord, page 68. My lord, annexure row, this is, my lord, the correct position.
68 of
the petition, my petition, my lord, GA1, volume 1. This is what they've given in the opposition. My lord, we had given this, my lord, in the petition itself. Where is the chart? Now, my lord, kindly come to page 66.
Yes.
Now, kindly note, my lord, I'm giving, my lord, ICICI Bank,
yes,
my lord, the position. Now, from ICICI Bank account of the plaintiff, my lord, kindly see the top of the chart. 8 crore 95 lakhs 50,000
yes,
gets transferred to the deceased ICICI Bank account.
yes.
Same branch. Out of this, my lord, five crore 83 lakhs 50,000, my lord, is transferred to, my lord, the Standard Chartered Bank account of the deceased. My lord, annexure D is mentioned there. Annexure D, my lord, we've given, my lord, the full particulars of, my lord, this transfer.
Transactions.
Yes, your lordship will find that, my lord, at page, my lord, 48. My lord, with dates, my lord, how, my lord, they have, my lord, gone. Page 48. Full details, my lord, are given.
Yes.
Now, my lord, if your lordship comes back to 66. Now, my lord, out of this 5 crore 83 lakhs, 5 crore 18 lakhs 96,021, my lord, have been transferred in the manner indicated in this chart. Now, my lord, kindly take 94 lakhs 50,202 given to defendant number 1, the wife. And they're all happening, my lord, within a day or two of each other. We've given the dates, my lord, in the annexures. That's annexure D1, page 50. My lord, I'm just giving it as an example. My lord, kindly see. My lord, April 3, 2023. My lord, is the first date. And my lord, in D, my lord, the first date is January 14, April 6, 21. Then, my lord, kindly see, my lord, April 20. Yes, my lord, kindly come to page 49, item 39, my lord. April 3. 18 lakhs goes into that account.
Yes.
My lord, 1 lakh goes to, my lord, the wife. First entry at page 50.
Yes.
My lord, that's how, my lord, we've linked, my lord. Then, my lord, 38 lakhs 50,000 goes into an account maintained by the minor, in the minor's name. My lord, 4 lakhs goes into an HUF. Then, my lord, 37 lakh 50,000, my lord, goes back again, my lord, to the ICICI bank account of the deceased. My lord, 1 crore 30 lakhs is, my lord, paid to Verdun Construction LLP. My lord, these are for immovable properties, flats. Then, my lord, loan taken, my lord, from Standard Chartered Bank, 76 lakh 12,000 is utilized to clear that liability. Then, my lord, there is, my lord, some unknown bank account from the bank statement we can't quite make out. My lord, annexure D7, my lord, that it has gone, my lord, to, my lord, 20 lakhs to this unknown bank account, my lord, of the deceased. Then, my lord, various payments of, my lord, 1 crore 18 lakh 33,000 have been made, which are in D8. My lord, kindly see, my lord, they are all, my lord, for either travel, credit card, and, my lord, the summary, if I may give your lordship, my lord, the credit card summary is, my lord, a total of 24 lakhs 45,163.
Correct.
My lord, there is, my lord, a breakup of that. My lord, in the next row, the lordship will find D8, my lord, particulars are given, credit card 24 lakhs. Next row, my lord. Then Standard Chartered Bank securities, my lord, his investments. Then, my lord, insurance, 27 lakhs 68,192. 4 lakh 40,000, my lord, for travel. Interiors, my lord, is 5 lakhs. Vishaka Sudeep, my lord, some, my lord, we don't know, my lord, it's some, my lord, and 2 lakh 62,500 is event planner for birthday parties. Now, my lord, there is, my lord, another, my lord, portion of 3 crores 12 lakh. My lord, kindly come to the top at page 66, right hand side.
Yes, yes.
3 crores 12 lakhs. Now, my lord, what happens? My lord, directly, my lord, defendant number 1, my lord, gets 1 crore 54 lakhs 25,000. My lord, defendant, and my lord, that's at page 58. My lord, I've given, my lord, the full details. My lord, this is, my lord, during the period March 14, 2023 to just before he dies. My lord, May 31st, 2024. Then, my lord, 7 lakh 50,000 to, my lord, his son's account, Raki's account.
Rakhi Bachche.
Yes.
Page 59.
Then, my lord, 50,000 defend number 3. Then 25,000 defend number 4. Then Banthia family, my lord, he's paid 40 lakhs. 25 lakhs to defend number 4 and 25 lakhs jewelry. My lord, kindly have a look at page 64.
So whether these all amounts are lying in the
No, these have been utilized. What they have, my lord, is what they are expecting from insurance. What is lying, my lord, with, my lord, the banks. My lord, none of the banks have filed an affidavit, but, my lord, I don't know, my lord, if any bank has communicated with the court and indicated how much money, my lord, is lying with them. Now, my lord, kindly have a look at 64. This jewelry is not, my lord, make believe. My lord, kindly see, my lord, 25 lakhs has gone to, my lord, jewelry. My lord, Savan Sukha Jewelers and Kalyan Jewelers, both, my lord, very, my lord, well known. And, my lord, page 590 of our affidavit in reply, we have indicated, my lord, how in the tax returns, my lord, jewelry has been shown. And, my lord, jewelry value shown, my lord, is, my lord, 2,72,16,220. Affidavit in reply, page 590. Volume 4, my lord, of the affidavit in reply. Now, my lord, this at page 66, I'm sorry.
Yes, continue.
Now, my lord, at page 66 of the petition, my lord, with the diverse payments of 60,69,000, my lord, we have, my lord, tax 12,75,000. My lord, 66 we've given. Amazon Pay 50,000. Credit card 28,82,210. My lord, self 2,77,000. My lord, home enterprises, my lord, 10 lakhs. Marble 5 lakhs. And my lord, insurance 84,280. So, my lord, this is, my lord, how, my lord, the entire asset base, my lord, has been built up. Now, my lord, two important points, my lord, legal points as far as this matter is concerned.
So these are the which period? 1 year period?
Correct, my lord. It's happened, my lord, in, my lord. Correct. My lord, it's over a 3-year period, but maximum transactions, my lord, have taken place over the last 1.5 years.
Whether in the return, income tax return?
He is to prepare my returns. I stated that also. Wholly trusted. My lord, now what is important is, what is very important, my lord, is he is, my lord, was my employee. My lord, he being a trusted man, my lord, he started, my lord, with, my lord, my partnership firm, High Tech Air System. My lord, acquired confidence of all the partners, and, my lord, acquired my confidence. Is to sit, my lord, right, my lord, in the next room, had access, my lord, to all my lord, accounts. Now, my lord, in this position, and, my lord, he did, my lord, filings, everything. Now, my lord, what is important is, my lord, he was, my lord, in a fiduciary relationship with me. That's what I sought to, my lord, establish. And in any event, my lord, these are all, my lord, taken out, my lord, without my consent. Third, my lord, alternate argument, even, my lord, if it were taken out, my lord, without my consent, my lord, it is, my lord, something, my lord, which he is to pay me. At the highest, he can claim it as a loan, because there's nothing to show, my lord, that he had, my lord, this, my lord, that I owed him, my lord, all this money. Now, my lord, if, my lord, I'm right in my submission, my lord, that he was in a fiduciary relation to me, my lord, I can, my lord, trace, my lord, the funds, my lord, into, my lord, wherever he has parked them. And this is, my lord, just one case I'll rely on. My lord, that is, my lord, the Abdul Razak case. My lord, it's reported in I got it. My lord, All India Reporter, 1964, Andhra Pradesh, page 522. My lord, I'm giving a Manupatra copy, my lord, because it was easiest to read from there. My lord, paragraph 5. My lord, paragraph 5, it's print page 5.
Yes.
In this case, now, my lord, kindly just above para 5, the question that falls for determination in this case is to what extent are the respondents liable for an account in law, and whether the terms of the preliminary decree can be so construed as to give relief by making them liable to account for income derived by the substituted buses and for their return of value. In this case, there is absolutely no doubt on the findings in the preliminary decree as confirmed by the judgment of the High Court at Madras. So and so that the respondents were not bona fide purchasers without knowledge of plaintiff's title, and that first defendant was in a fiduciary position, namely the minor plaintiffs, and was running the buses as a trustee for them, and therefore he was accountable to them for all profits made by him, whether directly or secretly. In the circumstances, all those persons who, with knowledge of title of the plaintiffs, intermeddle or acquired properties without any bona fides, are in the same position in respect of accountability of the plaintiffs in relation to that property, just as the first defendant is. Then, my lord, section 88, my lord, is referred to. Kindly come to, my lord, after the section. The principle, however, my lord, second sentence, the principle, however, is quite clear in that a person who is in a fiduciary position is bound to protect the interests of another person and who takes advantage of the same and makes profit or derives benefit or acts in any manner adverse to the interests of that person, he would be liable to that person who holds the benefit as a trustee of that person whose property had utilized or against whose interest he has utilized or against whose interest he has acted. The principle embodied in the section is wide. It embraces all cases of dealings entered into by the person under the circumstances in which his own interest may be adverse to that of the beneficiary. This section also was held not to be exhaustive and is wide enough to cover cases of those transferees who had taken the property with notice of the transfer or defective title. That's, my lord, the person who was the agent or in a fiduciary relationship. And then, my lord, kindly come to the portion, my lord, of Levin on practical treatise on law of trust. My lord, next page. At page 730, it was laid down that the rule that where a person mixes his own private money with trust money, the court will disentangle that account and separate the trust from the private money will equally apply in the case of a person occupying a fiduciary position as a factor or agent, and is even applicable to the case of person borrowing money for a specific purpose for which it was. So, my lord, merely because it gets mixed in his bank account, my lord, it can be entangled. And, my lord, if he's in a fiduciary relationship. Then, my lord, kindly come to, my lord, page, my lord, 7, print page 7.
Yes.
My lord, after, my lord, the court, my lord, of the law court judgment.
Paragraph?
My lord, it's continuation of para 5, my lord.
Yes.
It's quoting, my lord, from, my lord, the, my lord, Madras High Court decision. Then, my lord, with this statement of law, we respectfully agree. In this case, also the first defendant set up a false claim to the property of the minors, and a day before the suit was filed, with notice that it would be filed, he transferred buses to second, who shortly thereafter in his turn transferred it to third. The finding that 1, 2, 3 acted in collusion with one another to deprive the plaintiffs of the one which would give rise to an application of the principle adumbrated above. In law, therefore, the plaintiffs would be entitled to follow the first defendant's property in whosoever hands it goes, provided those persons had knowledge and notice was the property was that of the plaintiffs, and all those persons would be accountable to the plaintiffs. We have little doubt that the respondents are not only accountable for profits made out of the specified buses, but also as to what has been done with those profits. And if any property has been purchased out of it, the plaintiffs would also be entitled to the property and income made up. So, my lord, tracing, my lord, is, my lord, fully, my lord, permissible, my lord, in, my lord, such a case. Now, my lord, section 88 is set out there, my lord, so I'm not placing it, my lord, separately. Now, my lord, the next case, my lord, is, my lord, that insurance money you cannot touch. My lord, I'm afraid, my lord, that is, my lord, not the correct position in law. My lord, kindly take 1998 6 SCC 253, my lord. What is? Okay. আমি যেতে পারবো না, আমায় যেতে হবে শুভ ধ্রুবকে পৌঁছে। My lord, the most important point is, my lord, insurance money, irrespective of who the nominee is, who receives it, my lord, part of the estate of the deceased. Because nomination, my lord, does not, my lord, do away with the law of succession. Kindly come to para 26, my lord, at page 264. Para, my lord, 26 at page 264.
Yes.
My lord, applying the test as laid down in Hodgson's settlement to the present case, prior to the assignment, deceased clearly had an interest in the life insurance policies. Now, my lord, here yet assigned, my lord, the life insurance. Even after the assignment, had the assignees disclaimed their interest in the policies, the benefit under the policies would have resulted to the deceased or his representatives. Therefore, it cannot be said that the deceased never had an interest in the life insurance policies for the purposes of 34(3) of Estate Duty Act. The amount under the three insurance policies is therefore liable to be aggregated with the general estate of the deceased. So, my lord, under estate duty, even if you had an assignment, because the assignee could always assign it back, it is continues to be treated as estate. Then, my lord, in view of the above, the other question as to whether debts under the three policies should be paid out of the general estate of the deceased does not now survive. In the premises, we hold that amount under the three life insurance policies forms a part of the general estate of the deceased, and that the amounts under three life insurance policies have to be aggregated with the general estate for the purpose of determining the rate. Appeals are dismissed. It's part of, my lord, the general estate. Now, my lord, there's another case, my lord, 2015, 16 SCC, page, my lord, 46. My lord, which reiterates the same thing. My lord, I'm not troubling your lordship with that. I'm just, my lord, citing it formally. But most importantly, my lord, 2024, 4 SCC, my lord. Four SCC 642, my lord. My lord, nomination, my lord, does not really help.
Yes.
My lord, kindly see, my lord, at page, my lord, paragraph 40 at page 660.
Yes.
My lord, it forms part of the estate and is subject to the law of succession. And my lord, if tracing, my lord, is followed, my lord, whatever is inherited, we can go. And in any event, we can go against the estate. Now, my lord, apropos, my lord, our reliefs, we are claiming, my lord, we are seeking confirmation of the interim order, my lord, which has been passed, subject to the modification which has been made, my lord, by the appeal court. And that, my lord, I, my lord, rely on, my lord, just one case, 2021 6 SCC 418. At, my lord, para 41. My lord, even, my lord, if, my lord, here I claim it, my lord, on the basis of fiduciary. So therefore, my lord, they are in the possession of a trustee. My lord, which is the strongest case. My lord, one can have, my lord, two, my lord, attached to the property because it's really mine. But, my lord, even if I were wrong there, kindly have a look, my lord, at para 41. Having regard to the above background, wherein there is urgent need to reduce delays in execution proceedings, we deem it appropriate to issue few directions to do complete justice. These directions are an exercise of our jurisdiction under Article 142, read with Article 141 and Article 144 of the Constitution of India, in larger public interest, to subserve the process of justice so as to bring to an end the unnecessary ordeal of litigation faced by parties awaiting fruits of decree, and in larger perspective affecting the faith of the litigants in the process of law. All courts dealing with suits and execution proceedings shall mandatorily follow the below mentioned directions. 42.7. In a suit for payment of money before settlement of issues, the defendant may be required to disclose his assets or note to the extent that he is being made liable in a suit. The court may further at any stage in appropriate cases during the pendency of the suit, using powers under 151, not Order 38, Rule 5, demand security to ensure satisfaction of any decree. Now, my lord, your lordships, at the ad interim stage have already held, I have a prima facie case. Their affidavit, my lord, it does nothing to improve their case. In fact, according to us, my lord, it shows, my lord, that a false case, my lord, has been done. Okay. And therefore, my lord, the interim order should be confirmed. And here, my lord, that same security, my lord, should be available. My lord, the documents, my lord, with regard to, my lord, how property has been bought, etc., the dates, my lord, they're all in the annexures. You can give a short note, my lord, in the linking, my lord, all the pages. My lord, those are my submissions.
Thank you.
Well, may I start, but as far as dealing with the cases, I'll require another day. Or if it commends to my lord, I can start straight on the next day and finish it.
If you want to start, you can start.
Only, I just wanted to say that this is not an execution proceeding. So order 38, the last, of course, that case I'll consider. My order 38, rule 5, no pleadings, that I am running away from anywhere. And basically, one of the litigant, when seeking interim orders, now it's the after affidavits, your lordship will consider how was he diligent over his rights from 2021. He has given this person, according to himself. I don't know what my husband was working. He was working in a firm. He has given this person all his OTPs, all his passwords, mobile phone is his, etc. He doesn't disclose his own IT returns. My learned friend has not disclosed. He hasn't disclosed the ICICI bank account from which this money is going. So according to him, some of the transactions were valid and pick and choose, some are not valid. So there's no prima facie case either that this money, the only thing my learned friend has to concentrate on is the ICICI bank, 8 lakhs, 8 crores, 50, 30, 53 lakhs, etc. was taken out.
Yes.
It was unauthorized.
Yes.
He himself in his petition is saying that I was authorized to deal. There's nothing, there is no fraud on the bank. That's for sure. There is no fraud on the bank. He's saying that these transactions, I have not authorized him, but other transactions I have authorized him. Now, what the other transactions are, we cannot say. So I was saying that we should call upon them to produce these documents. Now, in the reply, my learned friend has disclosed all my details because my husband's computer is with him. So he has access to all my income tax records, etc., which they are showing, my lord. And all this tracing, obviously, a lot of hard work has gone into it, but it's not necessary. He has to first get over the hurdle that these 1, 2, 3, 4, 10 transactions, which were taken place in my bank, from my bank in ICICI, were unauthorized. There's no details. It's just one paragraph on that. He has taken it. I have not given consent. And then the history and dragging my laundry in public, like everywhere, because they have my records.
So what is your justification with regard to the transfer of this account?
Yes, we have said that my husband used to work.
Distributed to the other accounts.
Distributed is really not an issue. Once, if the money has legitimately come to my husband, he can distribute it as he likes.
Correct.
And there's no, all the money is there. Right now, your lordship has granted an injunction. We have modified it. The 24 lakhs was the money I received, as the wife received, from my own insurance. It had nothing to do with this. So therefore, the Honorable Court, he didn't go into the merits. We agreed 24 lakhs at least give her. There's a question of survival here. Just the daughter and her mother is there, and no bank accounts they could operate. So 24 lakhs they have given. Now that was the reason why it's irrelevant, that we were allowed to use it. Now my monthly expenses I've shown is 1,60,000. So right now I have the money. So I can survive for a few months. But after that, again, I'll have to ask for if the injunction is not vacated. Now, I will be asking for vacating of the injunction. There are several parts. One part of the injunction restrains LICI from paying the money. Now, that, my lord, will see section 60 of the CPC. This cannot be done. Once the money has come into my account, again, it's debatable. I'll show case law that once the money has come into my account, also it can't be attached. Section 60, my lord, will see first. Property liable to be attached, liable to attachment and sale in execution of a decree. Now, section 60, it says, my lord will come to the provided. Provided the following particulars shall not be liable to such attachment. So, KB, all monies payable under a policy of insurance on the life of the judgment debtor. Now, of course, my learned friend has proceeded on the basis that I am already my husband is already a judgment debtor. Be that as it may, all monies payable under a policy of insurance.
Where from you reading?
KB, 60. Section 61 and subparagraph KB. Your lordship has?
All money, yes.
All monies payable under the insurance policy on the life of the
Life
judgment
of the
debtor.
judgment debtor.
So the judgment debtor, if he has an insurance policy,
Yes.
that cannot be, because the insurance policy is really the public policy behind it is that the money under the insurance is for the benefit of the his dependents. So that has to be protected at any cost. Even the law recognizes that. Now, as far as the insurance policies are concerned, a chart has been shown, page 68, I think, of the petition was shown to my lord. Page 6. Yes. Yeah, of the petition, which is equivalent to 93 of my AO. So my lord will see, compare this with page 93 of my affidavit opposition. So there are three Bajaj Alliance. We have
Page affidavit opposition.
Page 93. So Bajaj Alliance has been included. I have not seen that.
Yes.
But that's my learned friends have, their client has access to my details. So you all should see Tata AIA Life Insurance.
Yes.
That's about 2 crores. This we have received. The first 4 we have received. LICI, we have not received any of these. But because of the injunction now, we will also not receive. So I will definitely be asking for vacating this part of the injunction automatically, because this is money payable under a insurance. Once that money comes in, it becomes a part of the estate. It's arguable. And I have also got cases to show that even when it comes in, if it can be identified that this was the money I got from the insurance, that cannot be attached. Now, what has happened here, of course, what my learned friend says, I bow down to that, that it becomes a part of the estate. But the insurance policy is, I create an insurance policy where my wife and daughter are beneficiaries. I die, that money comes, that money is for the wife and daughter.
Correct.
So, but in law, it is treated as, because wife and daughter are considered the nominees, then it will be the heirs will be entitled to it. Now, in this case, they are also the heirs. So they will be entitled to this money. So this money, does it remain as the money of the deceased, or does it become the money of the rightful heir or nominee?
When this LIC was purchased,
those details are given in between 21 and 20 and 24. And the earlier one, the wife's one was earlier.
But the premium, etc., that we will be paying prior to the alleged fraud.
That is the wife's one,
No,
24.
even the husband.
But
he's paying-
I have not got the details, my lord, offhand. I'll give that to my lord. It's a pertinent question. As far as the 24 lakhs, I remember I was in the appeal court, but we settled it the first day itself. At least we got a via media order, so she could survive. But there we had shown, my lord, that we have made premiums even before the first date that the allegation that was made against us. So it was probably some of them were subsisting from before.
correct. That is
Yes.
required to be seen.
So now what my learned friend submitted.
If the insurance is prior to this.
Yes. So, but what my learned friend also submitted is that out of this alleged money, now I'll show why this alleged, I'm saying it's alleged, out of this alleged money that comes into my account, I have paid the premiums. As my husband had paid the premiums. Now, merely if I lend some money to my friend or I pay the insurance premium for him, I don't become the person who pays it is not entitled to the insurance. That's no argument. It can become a part of his estate. If you have a claim against the estate, you can get the money. But who pays for the premium does not make that person the beneficiary to the thing. I wanted to clarify that. But only one point I'll make, and I'll come back the next day with the cases. The point that I want to make, my lord, is page 90. My learn and the case in the petition is that I have unauthorizedly withdrawn these monies from the account. So in our opposition, we say that my husband used to work in the share market, used to buy shares, etc., and he used to get a commission. So in my AO, I have shown a WhatsApp note. No, page WhatsApp. AO. Page 88. I'm sorry, page 88 of the affidavit opposition. I was showing it just now.
Page 88.
There's a WhatsApp, it's a big.
Page 88, the money, income tax.
Yeah. It's a key দেখছো? Right. Yes. I'm sorry, man. Page 98. It's
Yes,
the
page
folded.
98.
এটার সঙ্গে ওই পেজটা দাও 605. So here the WhatsApp notice is from the husband Kirti. We have touched gross profit of 206 lakhs till now in equity business. Net interest is so much. Target for 31st March is 225 net interest. Even after my commission, your net retainage should be approximately 190 lakhs. So out of this 225 lakhs, 190 you'll be getting. So this is just one WhatsApp message I could just give. So they, in answer to this, in the reply, where they have given all these documents, it's our fault, my lord. We should have prepared a supplementary to this reply. We haven't done it. So I'm not saying, my lord, Junior had asked, but the fact is that we haven't prepared her. We don't have any more documents. So anyway, we'll come to that. Now compare this with in page 592, which my learned friend showed today, a letter from Kitty too. This confirms that he was getting commission.
Yes.
Now, this is not the case in their plaint or the petition that I used to get, that my husband used to get commission. As discussed, please find attached the final profit and loss report of shares trading in 23-24 and the year profit overall and accrued commission statement of myself. This my learned friend just showed.
Correct.
And he said that if this statement has come, it's only about 12 lakhs. But the case has completely changed now, their case. They never said in the plaint that I used to sell shares and get commission. He said that he was my trusted man. He looked after everything. There are a lot of, but basically, once they're in the box, once the plaintiff will go in the box first, he'll have to explain to my lord, how is it that for 4 years, such a large sum of money has gone? And you're saying that my learned friend's answer when your lordship asked that was, he was my accountant. But if someone has to sign, accountant doesn't sign the statement, his own personal IT return, he'll have to sign it and he can see, and and if he is not a diligent litigant, as we would say, he has to await the trial. And you cannot, to make a prima facie case, what is the meaning of this? Has he explained that this commission, which parts were his commission, which parts were not his commission? And the whole accounts from 2009, my husband has been working as the accountant of a partnership firm. That partnership firm is not made a party. The other partner is not made a party. He said he used to work in my partnership firm, but he became so trusted to me, I let him do all. Did he get a salary for doing all this work for all these years? Nothing is explained. He's not entitled to any salary. He's just doing it out of love and trust. So there are a lot of factual issues also that I want to point out, but this is the basic point, is that we made out a case that we used to get commission. So now it's a triable issue whether my husband has siphoned off this. And unless the entire statement of accounts as shown by them, they have to show. It is unbelievable that a person will not know 8 crores has gone. He might be very rich. I can understand that sometimes we don't pay attention to our accounts, etc. But 8 crores over 4 years. And then when the person dies, the wife is saddled with it. Maybe it's written in a very dramatic way. It's like the young family gets a windfall, they go and blow up the money. That is the impression that has sought to be given. But if this money was earned, if it is not reflected in my income tax, that's my problem with the income tax that I will have if my husband has disclosed it or not. It's not that the plaintiff is doing some public duty to recover the tax. We will call upon them to produce their income tax to show what they have and what is the expenses they did and the other shares that has been, for which alleged commission has accrued. These details, my lord, we will be entitled to in the suit to call for these details. So prima facie, I wanted to say that we do have a defense. My lord will give us one opportunity to at least go into the facts and figures and the law as far as insurance is payable. As far as the section is, the ones I haven't got, I'm quite confident that we will be entitled to that money should come in any event. That money should not lie with LICI. that is to come. And as far as the money that I've got, if I can identify it and show that this is about 4.5 crores has come in through this life insurance, that, my lord, should be kept apart and I should be allowed to use it till the matter is decided finally. And finally is that even 2 immovable properties, which according to me cover this. So they have got an injunction of far more monies than required. So that breakup I want to give, my lord. And if it is...
You did details of the assets.
Yes, the details is they've got, there's an injunction on the 3 properties. That property, if the valuation I can show it covers, then at this stage, it's a question of survival for this young family, my lord. So some monies I will have to ask for this. And then the suit has to be heard on merits, my lord. My lord will give us one opportunity. At least a week from now, I'll get ready. Any day after a week.
Suffering for the plaintiff, suffering for the defendant. Counsel for the plaintiff has concluded his argument in connection with GA1 of 2024. Counsel for the defendant has argued quite some time, but due to procedural time, counsel for the defendant could not complete his argument, conclude his argument. Accordingly, case is adjourned. Let the matter appear.
But may I suggest tomorrow, the 2 p.m. matter tomorrow may not be heard because the defendant has
Mr.
taken
Ghosh required 1 week time to settle the account. Because you have given the bundles of account to Mr. Ghosh so that he can settle it.
So the subsequent transactions may be for tracing. If the money wasn't within my account, that may have been necessary. But if the first transaction is not shown to be authorized, the flow doesn't flow into the other.
Date hai kya? क्या तारीख है? 19, 18, 28. अभी 11:30 सुबह कौन वाला रखा था? 28 को. 28 at 11:30.
30th.
28.
Yes.
At 11:30. Interim order is still the 28th.
Huh?
Interim order is still the 28th.
28, na?
Yes.
Come on, 28.
Right.
28th of March at 11:30.
Kindly makes it parted. Lordship has heard it. Kindly makes it parted.
Fixed matter already parted.
We never know what happens when.
Otherwise, if at all, if any, then all the things will go with me.
Yes.
If it give.
But if it is possible, could it be at 12 o'clock instead of 11:30?
Why?
But Mr. Mukherjee may have.
No, Mr. Ghosh will argue. You take note of it. For the Mukherjee, if required, I will.
Grateful. Grateful.
Yeah, better go.
11 is I appear for the plaintiff. I'm the respondent in this application.
Lord, I am for the defendant.
Viral. Yes.
My lord, I am for the defendant, my lord. Your lordship will recall, my lord, this is the matter, my lord. Foreign company or Indian companies, my lord.
Item 11.
11.
Yes, my lord.
I'll
This
have to
is-
file an affidavit.
My lord, this is that matter, my lord. I was arguing, my lord. Group of companies involved,
Yes,
my lord,
yes,
a foreign
yes,
company, my lord.
Uh-huh.
This is an application I filed, my lord, GS6, my lord, for addition of party of the Netherlands
First,
company.
that may be concluded, then
Section 8 must be concluded.
Section 8 will be concluded, then your addition of
My lord, I
party will
have
be
issued
taken into
section 21 notice as well, my lord. My lord,
21 notice.
yes, yes.
After last day's hearing, they have issued everything. 21 notice, this application.
So you do one thing, you withdraw this, let that may be
No, my lord.
matured, then you come.
My lord, may I
But
make,
the action you have taken, let that be matured first.
my lord, may I make a
Otherwise,
submission?
all the thing will be immature.
My lord, my learned friend, my lord, obviously use an affidavit to this application, my lord.
I
By
have,
that time, the 30 days will be over on the 21.
Then they will file an application for appointment.
11.
Yes.
No, 11 I can't. It's the international arbitration
Supreme
clause,
Court.
my lord.
Supreme Court.
International clause arbitration,
They
my
don't
lord.
want to stay in
My lord,
Calcutta. They want to travel to Netherlands, to Supreme Court, everywhere.
my lord, I will show one clause from the contract, my lord. They are not entitled to recover money. They are entitled
Very
to
well.
recover goods
we'll
only, not otherwise, my lord. Only the Flint, Netherlands, my lord, can claim money from me.
So that's why on the last date,
Yes,
that's
yes.
why I'm asking you for telling that the main person is there.
Yes,
So
my
why
lord.
you are going with him to come to the arbitration?
Yes, so because of the hints, my lord, we suddenly woke up, my lord. My lord.
That's why this court.
All thanks to your lordship, my lord.
That's why the court never open the mouth. Only take notes of this.
Now, my lord,
Sensation suffering for the plaintiff, sensation suffering for the defendant. The plaintiff has filed the defendant number. Defendant, na?
Yes, my lord.
Defendant has filed the present application being GA Com 6 of 2025 for addition of party. Counsel for the plaintiff prays for time to file affidavit in opposition. Let affidavit in opposition filed within 2 weeks. Reply, if any, there to be filed within a week thereafter. Please the matter on 21st April.
My lord, one small submission, my lord. My lord, that section 8 application, my lord, is fixed tomorrow, my lord, at 2 p.m.
Come on that. We'll
Yes,
see to
okay.
that.
My lord,
The only
I
thing is
don't
that
want to my lord's list to be disturbed because my lord, this application, my lord, interlinked with the said application.
Okay, come tomorrow.
We'll
What is the time?
2 p.m., my lord.
Okay, come tomorrow. We'll see.
Yes, my lord.
But only one thing, if your lordship could keep the point of maintainability open, because they want plaintiff, this Netherlands to be added as a co-plaintiff in the suit.
Co-plaintiff?
Co-plaintiff. That is why I kindly keeps the point of maintainability open.
Maintainability of the present application is kept. So what will happen tomorrow? So that is
Tomorrow, my lord, that is, my lord,
Has
we
to
can
be
argue, but my lord, it will still depend on
Still
the result of this application.
Okay, then we'll see. Okay, come tomorrow. We'll see.
Right. But the lordship has kept the point of maintainability open. My lord. Grateful.
Point of maintainability of this application is kept open. Okay.
My lord, affidavit of service, my lord.
Affidavit of service filed by the defendant be kept with the record.
But that some pages of this application are illegible.
Inform
Lordship,
them.
yes, my lord, I shall inform. My lord, they will.
Inform? Yes, yes.
Grateful.
Grateful.
Number 12. My lord, I am for the plaintiff.
12, no, 13.
In this
11,
moment,
12.
I'm led by Mr. Ghosh.
Hmm.
And I'm led by Mr. Sudeep Ghosh in this matter for the defendant.
Item number
12, lordship.
12. 12 is different. Acha, uska hai.
So would probably recall my lord for amendment of written statements. Made an application for amendment of the written statements, lordship. They filed the opposition, my lord. I would hand up, my lord.
You are appearing for?
The defendant, lordship.
Yes. You filed this application?
Lordship.
For amendment of the written statement?
Lordship.
Yes.
My lord, I'm just handing up the reply, my lord.
That's
Other
why
side
I
and
reply, my lord. Give it on Monday.
What reply? Repeated.
Actually, this is the original brief is lying with the advocate and it's not well. Yes, not.
My lord, I won't stand in the way then.
Sensation suffering for the plaintiff. Sensation suffering for the defendant. Counsel for the defendant has filed affidavit in reply in connection with GA Com 5 of 2025 after serving the copy to the learned counsel for the plaintiff. Let the same be kept with the record. Counsel for the plaintiff prays for time. According cases adjourned. Let the matter appear on 4th April.
What's it? 4th of May.
4th April. Next.
I appear for the plaintiff
Under the heading adjourn motion. 4th April under the heading adjourn motion.
But I appear for the respondent, the plaintiff in the suit. This application, my lord, I don't know, are you moving it?
Yeah.
Yes.
Lordship, I'm appearing for the applicant defendant. After we filed this GA4 application, we got an instruction from the client that the related counsel and the advocate on record shouldn't be proceeding on this matter because he's expecting a changeover.
But in any event, it has become infructuous. And the ground is for rejection of plaint for non-service of the writ of summons in the proper manner. Lordship has already decided that in the earlier application that this possibly was prepared before your Lordship passed the order. Are you withdrawing it?
So what do you want? Only adjournment?
Sir, I got a clear instruction that
You're not got the clear instruction.
I mean, we don't have it in our hands anymore. So it's like was the instruction that we have got.
What can be done?
Are you the advocate on record? No.
No.
But then we are not supposed to move it, right? So that's why. We are not supposed to move it, my lord.
So what can be done?
I would pray for dismissal.
So why you are
as habits
appearing?
become infructuous.
What is the application? What is some?
The application, they say that the plaint should be rejected because the writ of summons has not been lodged or served in the proper manner. But after this was filed, Lordship has passed the order by which Lordship has held that writ of summons was served on the defendant and the time has expired to file the written statement. That really decides the issue whether writ of summons
Where
was.
is that order?
I am not carrying
Okay, I am adjourning it.
Right.
Concession suffering for the plaintiff.
Almost makes it a not today when it when
not
appear
today.
Friday.
Not today, not today.
Grateful.
Testamentary.
For the petitioner, your lordship.
For the caveator number 2 and
Your lordship recollects this matter. We had filed an application where the caveats previously lodged were discharged, your lordship. Thereafter, caveator number 2 and 3 came in place, who are a third party, my lord. And on the last occasion, your lordship was of the view that since they're third party and they are stepped in the shoes, they cannot be entertained, your lordship. And what I have been instructed, my lord, on the last occasion, they were relying on some document. They were to file a supplementary affidavit, my lord. We have not been served with a copy of
Have
this.
filed.
my lord. Thank you. My lord, a copy.
So the copy.
My lord, on the last occasion, my lord, kindly comes to page 8.
Yes.
My lord, this is the letter which has been, which, my lord, we have received, which we have found in the file, which was handed over by the legal heir of the testator, my lord. My lord, this is the letter.
Who are you?
My lord, I am the caveator number 2 and 3 who has purchased
What is
the
the
property.
relation? You are the purchaser of the property in question.
My lord.
Correct. And she is the executor of the will.
She is the executor.
Correct. So what do you want now?
My lord, this letter in which the testator himself, he says that he was not in a correct state of mind when he had prepared the will, my lord. My lord, page 8.
Yes. Who is the petition herein?
My lord, the petitioner is my wife.
No. Who is the petitioner?
The petitioner herein is the
the petitioner is the wife of the legal heir.
We are the executor, my lord. We are the petitioner, your lordship. Who
What is the name? Anupam Biswas.
Yes, your lordship.
In favor of my grandson, Srimati Sriman Pijat Bhaduri, during which I have What is the date of the will?
My lord, the date of the will is 13th July 2012, my lord.
This is as per your letter. This is also
13
13
July
July.
2012, your lordship.
13 July.
Yes, your lordship.
But who is the executor here in the will?
My lord, there are two executors who have been appointed in this will, my lord.
I said grandson Sriman Prijat Bahaduri.
Yes,
is
your
the
lordship.
niece. He's a nice boy of, and he's very much influential and yes, is also respected now, I think. Yes, then thereafter whether it was revoked, not revoked. So it has to be proved. So how you will be affected?
My lord, I have already purchased.
Who are the legal heirs?
Your lordship, the legal heir was the son, my lord, who had filed a caveat. There is no other legal heir, your lordship, and that caveat was discharged, my lord, by your lordship's order. And the beneficiary, yes, the beneficiary is the grandson, your lordship.
Sujay Baduri.
Yes, yes, my
Sujay
lord.
Baduri released and discharged.
Yes, your lordship.
And the Pali, wife of Susanto. She has given no objection.
Your lordship, with regards to this, if your lordship recollects that we had made a publication, she was not to be found. Later we came to know perhaps she is no more. There was a paper publication also in this matter. There were previous applications we had filed. She was not to be found, my lord. We had also pleaded that in the application, my lord, we had filed previously, wherein we had sought discharge
Okay,
of
then you deal with the supplementary. Then I will
She
decide.
does not have any locus also.
No, that's correct. But problem is that she is relying upon one document. You deal with this.
My lord, we shall do the needful.
Has to be decided.
My lord, we shall do.
So and so applying for the executor, so and so applying for the caveators number 2 and 3. Police caveator number 2 and counsel for the caveator number 2 and 3 have filed a supplementary affidavit disclosing certain document, disclosing one document after serving the copy to the learned counsel for the executor. Learned counsel for the executor press for time to deal with the said document. Let affidavit in opposition to the supplementary affidavit be filed within 1 week, 2 weeks.
Within 2 weeks, your lordship.
Within 2 weeks, reply if any there to be filed within a week thereafter. Leave the matter on ये कब है? मंगल होता है, बुध को होता है, बुधवार, Monday, Tuesday, 22nd April.
Grateful, your lordship.
My lord, on last occasion, your lordship is pleased to direct me to file my affidavit in support of caveat. This is my affidavit in support of caveat. It's already served up on learned advocate on record on
5th of March 2025.
Have you received?
Yes, lordship, on 7th of March.
7th of March 2000. Since my lord, it is
Inspection.
consensus.
Has the caveat full sense appearing for the petitioner? Sense appearing for the caveator or caveatrix? Caveator?
Caveator.
Caveat.
Yes. My lord, I file an application to recall the probate and your lordship was please dismiss their allow my application and then direct me on 12 February to file my affidavit in support of caveat.
Correct. Yes, caveator though.
Yes.
Not the caveatrix. क्या बोला? Sense appearing for the petitioner, sense appearing for the caveator. Caveator has filed affidavit in support of caveat after serving the copy to the learned counsel for the executor. Let the same be kept to the record. As the caveator has filed affidavit in support of caveat, the PLA proceeding is to be treated as contentious cause.
Yes.
Full stop. The department is directed to assign the testamentary suit number.
Yes.
Testamentary suit number and to place before this court testamentary suit number. Full stop. The parties are directed to complete the discovery and inspection of the document within 2 weeks.
2 weeks.
My lord, better through 3 weeks.
Why?
My client is out of station, my lord. So I need some time.
Within 3 weeks.
3.
Full stop. Full stop. Affidavit of documents be filed within a week thereafter. Full stop. In the meantime, the parties are also directed to exchange their suggested issues. Full stop. List the matter on 22nd April 2025 for framing of it. Testament is 25th of April 2025 for framing of issues.
Grateful.
Don't you want
My application for grant of letter of administration without will. My lord, Devraj Kapoor, my lord, he died intestate on 6th of June 2004. My lord, his heirs are, in paragraph 2, his wife and 2 sons. My lord, if my lord will see the affidavit of assets, this is only with regard to shares.
Who is the executive? Who is the who is the deceased?
Applying
Devraj Kapoor.
Devraj Kapoor. His wife has filed this petition, my lord.
Damayanti Kapoor is the wife.
Damayanti Kapoor.
Where is the legal layer?
My lord, paragraph 2, wife and 2 sons. Both sons have given their consent.
Wife, both are given consent.
Yes, both have
So why
given
it is
consent.
complete?
One of the son was abroad. My lord will remember, my lord had allowed us to file the affidavit of consent, though it was not apostille. We have filed that.
Where is the affidavit?
My lord, both have been filed. My lord. One was filed at the time of filing of the
Kapoor.
Hemant and Devan Raj.
I have no objection. And another one?
Devan Raj. Devan Raj.
Damayanti Kapoor.
That was filed, my lord, in the department on 5th of December after receiving the leave from my lord.
Acha, this consent.
Yes.
I have no objection. Yes, then where
So
is the
this is,
affidavit? Of
pertains only to shares, my lord, which are worth around 11 lakhs. My lord will take the affidavit of assets, page 4.
Page 4.
4.
Page 4 of
Affidavit of assets.
affidavit of assets का है? Anatosh? Affidavit. Shares.
Yes, ma'am. Only shares.
11,62,000.
Yes.
There's no other property.
There is no other.
So appearing for the petitioner. The petitioner has filed the present application for grant of letters of administration of the property and credits of the deceased Devraj Kapoor, CAPUR, के नहीं होगा, Devraj Kapoor, who died on 6th of June 2004, leaving behind his wife Damayanti, Damayanti, Damayanti Kapoor, who is the petitioner before this court, comma, 2 sons, namely Devan Raj, DEVAN, Devan Raj Kapoor and Hemant Kapoor. Full stop. Counsel for the petition submitted. Both the sons have filed their affidavit of consent stating that they have no objection for grant of letters of administration to the petitioner to the estate of the deceased. Full stop. Had the learned counsel for the petitioner perused the death certificate of the deceased Devraj Kapoor, who died on 6/6/2004. This court also perused the affidavit of consent filed by both the sons, wherein it has been categorically mentioned that they have no objection for grant of letters of administration to the petitioner. Considering the above, this court finds that there is no impediment for grant of letters of administration to the petitioner as stated for by the petitioner to the property and the credits of the deceased throughout the Union of India. The department is directed to issue letters of administration to the petitioner, to the property and credits of the deceased throughout the Union of India, subject to furnishing personal bond of rupees 10,000 with one surety.
My lords, in item number 22, I appear on behalf of the petitioner. My lords, in this matter, I am praying for an accommodation. My lords, the petitioner was partly deposed on the last date of hearing, my lords. That is on 17th of February, my lords. Thereafter, on 18th, he has suffered a stroke, my lords, brain stroke. He was hospitalized. My lords, if I may be permitted to hand over the relevant medical documents. My lords, I was praying for
As per the prayer,
accommodation of 4 weeks, my lords.
Sense appearing for the petitioner. Plaintiff. No, petitioner. Sense appearing for the petitioner. As per the prayer made by the counsel for the petitioner, the case adjourned 2 weeks after. As per the prayer made by the case is adjourned, let the matter appear on 8th April.
Grateful, my lords.
23, this is my application for grant of probate to the last will and testament to the Chandranath Chakraborty. My lord. The will is appearing at page 11.
General citations issued.
Yes, my lord.
Citations issued. All have come forward.
No, my lord.
Yes, where is the will?
Page 11.
What is the name of the testator? Chandranath Chakraborty.
Yes.
Yes. Where is the name of the executor?
Executor, paragraph.
Paragraph?
Executrix.
Mosumi
Muchoti.
Mutsudi. Yes. What is the date of the will, sir?
Date of the will is on 19th February 2018.
19th February
2018.
2018. When he died?
He died on 19th of August 2020.
20? Where it is?
Lord, can you take page 10? The death certificate I have access.
2020.
Yes.
When you filed the application? 24. 2020. Where is the legal heirs?
My lord, he left behind his wife. She also died on 7th of November 2023.
Wife also died?
Yes.
So, no legal heir?
My lord, legal heir, there is only.
They were issueless?
My lord, they are issueless. My lord, kindly take page 3, paragraph 5.
Sister.
Sister.
Sister of?
Sister of the testator.
Testatrix.
Testator.
Testator.
Yes,
The property belongs to testator?
Yes,
Yes. What about the attesting witness?
my lord, kindly take page 9.
And she has given consent?
Yes.
Or she is the petitioner? Who is the petitioner?
Citation has been issued.
Who is the petitioner?
Not the petitioner.
The executrix.
Petitioner is the need of the...
Citations were issued?
Yes, ma'am.
Where is the no caveat?
Certificate has not been filed.
No caveat certificate है? No caveat है? You're not obtaining the no caveat certificate?
No,
not informed to the department?
Kindly give me 15 days time, I'll collect. Kindly give me 15 days time, I shall collect it.
Sense appearing for the petitioner. Counsel for the petitioner submitted the petition has complied with the order dated 11th of September 2024. 2024. He submitted the publications have been made and citations were issued, but has not obtained the no caveat certificate, accordingly placed for 2 weeks time. In view of the submission made by the counsel for the petitioner, case adjourned. Let the matter appear on 8th April 2025.
Lord, I appear for the petition, Lord.
Yes.
In respect of a will executed by the deceased on 11th of September 22, and
He expired, my lord, 6th of December 2023.
Testatrix, Kanika Roy.
Joint testator and testatrix, my lord.
Testator and testatrix.
My lord, page 4, my lord, both of them, they are also the petitioners herein.
No. The testatrix, what is the name of the testatrix?
Testatrix is Konika Roy. And testator is
Gitanjali Roy.
Gitanjali Roy is the deceased.
Gitanjali is the deceased. She is the testatrix.
She is the testatrix. Sorry, sir.
She is the testatrix.
Correct. The executor is Kollan Roy and executor is Konika Roy.
Testatrix Gitanjali. Where is the name of the executor and executrix?
Kanika
Roy and
page
Kalyan.
3, paragraph 4, my lord.
Kanika
They
Roy
are
and
the
Kalyan Roy.
son and daughter of the deceased.
Kanika Roy and Kalyan Roy.
Konika Roy and Kollan.
Both are the petition before this court. They have filed the application.
Yes.
Okay. What is the date of the will?
The date of the will is 11th September 2022.
11 September 2022. Okay. When he died, both died, when she died?
6th December 2023.
Where is that?
In the petition, I have
no, death certificate?
Death certificate will annexure C.
6th December 2023.
Yes. And her husband predeceased her, my lord. His death certificate is also annexed.
Where it is?
Annexure A is the deceased death certificate. Annexure B is the death certificate of
Kalipadda Roy.
Yes, her husband.
Kalipadda Roy.
Yes.
Kalipadda Roy is the husband. Yes. Who died on?
They died on 6th December 23.
25 years ago. Where you got the date?
No.
Date of death of the Kalipadda?
Kalipadda.
As per the Panchayat certificate, died 25 years back.
Yes. That is why death certificate is not available. So Panchayat certificate.
You are telling the date. That's why you're asking where from
No.
the date of the death.
Date of death is not there.
Then where is the legal years?
The legal years, the names are there. Konika and Kollan are there.
These are the only two.
They are the only
There is no other
No.
legal years. Sorry. Appearing for the petitioner. The petitioner has filed the present application.
The petitioners both have filed it.
Appearing for the petitioners.
Petitioners.
Petitioners have filed the present application for grant of probate of the last will and testament dated 11 September 2022 of the testatrix Gitanjali Roy.
Yes.
Counsel for the petitioner submit that. Petitioners submit that. The testatrix has executed her last will and testament by appointing the petitioners as joint executor and executrix of her last will and testament in presence of two attesting witnesses while possessing good health and fit state of mind. Counsel for the petitioner submit that the testatrix died on 6th of December 2023 and the husband of the petitioner was predeceased to the husband of the testatrix was predeceased to the testatrix. Full stop. The testatrix died leaving behind two legal heirs who are the petitioners before this court. Petitioners and the executor and executrix of the will. Two legal heirs. Petitioners and executor and executrix of the will. Full stop. Consider the submission made by the counsel for the petitioner produced. Counsel for the petitioner submit that the attesting witness of the will has also. They are also attesting witness.
Yes, they are also attesting witness and giving the consent.
Counsel for the petitioner submit that the legal heirs are also the attesting witnesses of the said will, and they have also affirmed the affidavit stating that the testatrix has executed a last will and testament in their presence. Consider the submission made by the counsel for the petitioner produce the original will, death certificate of the testatrix, certificate issued by the Gram Panchayat Faludi Gram Panchayat, Purba Medinipur, wherein it is certified that the husband of the testatrix Kalipadda Roy died 24 years ago. 25 years ago. This could find that The petitioners are the executor and executors of the said will, and they are the attesting witnesses of the said will.
Yes.
And as such, attesting witness of the said will. In their affidavits, they stated that, and both have stated that the testatrix has executed her last will and testament in their presence while possessing good health and fit state of mind by appointing them as executor and executors of their last will. Considering the above, this court finds that the petitioner has proved the will and is entitled to get the probate. To get this probate, the department is directed to issue probate of the last will and testament dated 11 September 2022. 11 September 2022 on compliance of all formalities. PLA 234 of 2024 is disposed.
Lord, may I submit one thing? This order need not be drawn up.
The department director not to drawn up and complete.
Grateful. Grateful.
My lord, I'm appearing for the petitioner in this suit, matter, my lord. We have received change in this matter, my lord. We have filed the Vakalatama last week only. I'm seeking for 2 weeks time to take appropriate steps, my lord.
As per the prayer made by the counsel for the petition, the case adjourned for 2 weeks. Release the matter on 21st of April 2025.
Much obliged.
Next.
Lordship, I appear for the petitioner in this matter. An application for grant of probate. Your Lordship, by an order dated 13th of January, had directed us to
publication of the notice in the English, Hindi, and Bangla.
Special citation.
Done.
Upon one Jadab Dasguru, that has been done. The affidavit of compliance has been filed, Your Lordship.
But have you obtained any caveat certificate?
Lordship, we have been
After the
informed
publication,
that
any
no caveat certificate has been issued, but a copy of the same.
No caveat certificate आया? मॉड में थोड़ी है डिपार्टमेंट नहीं करेंगे ना.
Very well, Your Lordship may kindly keep the matter. After a week, we'll obtain a copy of the no caveat certificate if it is not.
नहीं इन लोग गया नहीं होगा. Sense appearing for the petitioner. Full stop. Counsel for the petition submitted. The petition has complied with the order dated 13th January 2025 by publishing the notice in the English daily newspaper as well as Bangla newspaper. Where is the affidavit of compliance?
Lordship, it has been filed. It is a part of the affidavit dated, affirmed on 5th of March 2025.
Affidavit compliance है? नहीं. Complied with the order written by publishing the notice in the English and filed affidavit of compliance. Let the same be kept with the record. Counsel for the plaintiff petitions raised for 2 weeks' time to obtain report from the department whether any caveat is lodged or not. When we have the submission made by the counsel for the petitioner, the case is adjourned. Let the matter appear on 22nd April.
Obliged.
Next.
27.
May it please, my lord, I appear for the executor, my lord. Application for grant of probate of the will of the testatrix.
Argument.
Yes, my lord. Because, my lord, your lordship I had to prove the will by way of, my lord, attesting witness. Attending witness, I'm sorry. The attesting witness, both the attesting witness have died, my lord.
Where is the will?
Lord, the original will is there, my lord. It's not paginated.
Exhibit?
Yes, the page.
Not exhibited.
Yes, my lord, it has been exhibited. On the last day, my lord, I have proved the signature. The attesting witness has proved the signature, my lord. I'm sorry, the thumb impression. Your lordship will find in the deposition, my lord, which is there before my lord.
No, well, it is not exhibited.
That day, Lord, it was. Will, my lord, was not exhibited, my lord. The signatures were identified, my lord.
Signature is also not identified.
Yes, my lord, with the red pencil. It was not marked on that day.
No.
Lord,
No mark.
your
No.
lordship had directed, my lord, the.
Where is the deposition?
I have the copy. Your lordship needs a copy. Direct to the. Your lordship may kindly sees question number 19. 18 to 19, lord. I'm sorry, 18 to 21. The thumb impression of
correct. The mark is there, but there is no identification there.
a marking of the exhibit is not there, but identification is there.
No. If it is not exhibit, how you can take the...
But I'll have to prove. This is not a technical error.
No.
It was identified by the attesting witness on that day.
That's correct, but it has to be exhibited, sir. Where is your witness?
Lord, the witness is not here
On.
today. Yes.
What is the address? Government employee.
Lord, he's from Calcutta, but today he's not before my lord.
Come. Bring the. I will recall the witness. That is because there is in the deposition also not there. In the will is also not there.
I'm sorry, my lord. Deposition.
Deposition. The exhibit mark is not
Exhibit marking is not there. The marking, the identification of the.
It is also mark. कौन था यार इसका एग्जिबिट नहीं हुआ? Only one witness to examine?
Only one witness, my lord. Only one attesting witness. Attending. I'm sorry.
And where is the explanation of delay?
Explanation of delay is at paragraph 5 of the application for grant of probate, my lord. 13. Paragraph 13 at page 5. This is what, my lord, the explanation is, my lord, that the original was misplaced. Then, my lord, after we found it, we had filed the application for grant of probate. And moreover, my lord, the second attesting witness had died in the year of 2020.
Okay. So what can you call your witness to recall this?
For marking?
Marking. Has to be.
Very well, my lord.
Consensus and suffering for the petitioner. Full stop. The petitioner has examined one attending witness to prove the signature of the testator or testatrix?
Testatrix.
Signature of the testatrix as well as the attesting witnesses. But full stop. It is fine from the record during the examination in chief of the plaintiff witness and petitioner's witness, comma, the signature of the attending witness, attesting witness and thumb impression of the testatrix were marked with the red pencil, have been encircled with the red pencil as well as the blue mark. But it was not exhibited. According to counsel for the petitioner, prays for recalling of the witness to mark the signatures of the attesting witness in the said will. Accord. Full stop. He prays in view of the submission made by the counsel for the petitioner. Case is adjourned. When he will come?
Any day, my lord. Any day.
Let the matter appear on 8th.
8th.
8th April?
8th April.
Or after 22nd April?
Next week any day.
Huh?
Next week any day.
25th.
25th of March. Extremely grateful.
I am for my lord the petitioner in 20. I am for the petitioner in 28 and for the defendant in 29. Will of the same testator, my lord, two wills. My lord, on the last occasion, your lordship passed an order on February 21, 2025. Your lordship kindly sees the order once.
PLA is not in place before this court. According to Department Director to record the PLA number with PLA 23 before this court. Yes.
So, my lord, in the item number 29, we have filed our affidavit in support of caveat. It can be converted to a testamentary suit. Item number 29. But, my lord, item number 28, they have filed their caveat. They have served the caveat on 4th of March. I just want to point out one thing before your lordship, that is Rule 25 of Chapter 35, my lord. May I read it out? Where a caveat. Rule 25 of Chapter 35, my lord. So, my lord, your lordship kindly keeps in mind that they filed it on the 3rd of March. It says, my lord, where a caveat is entered after an application has been made for the grant of with or without the will annexed, the affidavit or affidavits in support of shall be filed within 8 days of the caveat being lodged. That's the 8 days rule, my lord. Only thing is they did not file. And my lord, but we have filed in the other matter. That matter can be converted to a testamentary suit. But this matter, your lordship will decide, my lord, 8 days have lapsed. Now,
that is in item number
28,
number?
my lord. I am the PLA number 323 of 2022. I am the
no caveat.
petitioner. Caveat has been filed. No affidavit.
No affidavit in support of caveat.
8 days have lapsed.
And with regard to T20 already.
We have filed our affidavit. Only thing, other thing, my lord, on the last occasion, perhaps, my learned friend said that they are going to withdraw the appeal, which they preferred from the order of revocation of this court. I do not know whether they have withdrawn the appeal.
But I don't know why these people, they take everything for granted. That it's surprising. And they come and ask us to argue before them that I have a right. What do I say, Miller? My affidavit in support of caveat is not ready, is out of time. I have no explanation for that, nor have we withdrawn the appeal. Miller, all I can pray
also not withdrawn the appeal.
I have given instructions. They say that daughters, this, that. I really don't know as a counsel, what should I, how will I assess the court?
The only thing I can say, man, to avoid multiplicity of proceeding, let
Yes,
them
yes,
be bound by a time.
Once I have said that
Let
I
them
will
be bound
withdraw it.
by the time.
But Millard, this attitude of taking orders for granted, Millard, is something which is, I don't know how it gets imbibed in these people. Millard, give me 2 days time, Millard, if it commences to your lordship, Millard, but I don't have any explanation for that. Either the affidavit comes within 2 days or Millard, your lordship will grant that probate. There's a limit to everything.
Yes.
Millard, give us 2 days time, Millard, if it commences to your lordship, Millard. This is the last time I'm coming in this.
So instance appearing for the petitioner in PLA number 323 of 2022. And so appearing for the caveator. The counsel for the petitioner submit that though the caveator has lodged the caveat, but have not filed affidavit in support of caveat within the prescribed period as prescribed under law. Full stop. The counsel for the full stop. The counsel for the petitioner appearing in 300 PLA number 320 of 2022.
Well, 323, I am the petitioner.
Correct.
Yes.
The counsel for the petitioner appearing in PLA number 323 of 2022 submit that the caveator has filed the affidavit of affidavit in support of caveat. Affidavit in support
in 320 of 2018.
323. Caveat. Full stop. Counsel for the petitioner in PLA number 323 of 2022 submits that if a week time is granted, he will take appropriate steps for withdrawal of the appeal.
Yes, I have once I have submitted that, it will be done.
Referred by the caveator, prepared by the petitioner. Who has filed? Samir Kumar Gupta. Who has filed the caveat appeal?
Appeal has been filed by
it has
been filed by Ramji Singh. Ramji Singh.
By the petitioner. Petitioner in PLA 323 of 2022.
320 of 2018.
23, you are the petitioner.
23, I am the petitioner, where they are the appeal.
क्या बोला? Three, if a week time is granted. No, 320. 320. If time is granted, you will take appropriate step for withdrawal of the appeal preferred by the petitioner in PLA number 320 of 2020.
Would it be Lordship's pleasure to record that on instructions I'm submitting that I will withdraw the appeal?
On instruction, counsel for the
Otherwise, they will hold me
320 on instruction submit that within a week he will
বলা
take
যায় না ভাই আমার তো ক্লায়েন্টের অবস্থা
Full
দেখছি
stop. Yes, what about the caveat?
Caveat affidavit.
Full stop. Huh? Affidavit in support of caveat, you will file or not?
Yes, I will file.
When you will file? I am giving a last chance within a week, otherwise I will proceed. The counsel for the caveat in PLA number 323 of 2022 phrase for a week time to file affidavit in support of caveat. For the interest of justice, as a matter of last chance, time to file affidavit in support of caveat is extended for a period of 1 week from date. It is made clear that within a week, if the caveator failed to file the affidavit in support of caveat, the PLA being 323 of 2022 be taken off for hearing without the caveat.
Yes. One thing will be Lordship pleasure
Without the affidavit
pleasure
in
to
support
direct
of
the department since everything has been filed in PLA 320, it can be transferred to a
Come
testamentary.
1 week if the both will otherwise. If it is not, then I will segregate it.
Well, I'm sorry,
This is the matter.
grateful man. I
After a
tender
week,
my
man, this is the matter on कितना तारीख है 18 25 1st of April 2020.
Grateful man.
Next.
But I'm sorry.
Yes.
I apply for the petition.
Special citation publication issued.
All departmental procedures concluded, my lord. Maximum court fees have been deposited. Maximum court fees has been deposited, and all departmental procedures concluded. Paper publication made. Thereafter, affidavit service filed, and department issue no caveat certificate, which is in paper your losses, my lord. Only my lord, probate to be granted. It is my PR, my lord.
Only probate is required. That's all.
Yes.
Where is the will? Where is the will, sir? The case of probate.
Yes. Letter of administration.
Letters of administration. With will or without will?
No, my lord.
Huh?
No.
Without will. Yes. Tell that. What is the name of the deceased?
Solil
Chatterjee. Salil Kumar Chatterjee. Yes. When he died? Salil Chatterjee, 7th May 2021. Where is the legal heirs? Details of the legal heirs of the Salil Chatterjee.
Adityanan Chatterjee is only shown.
Where it is? Where is the requirement in the application, sir? Yes. What about his wife? He also died 16 and he died on 2021. Where is the affidavit of asset?
It's 36. Derivative asset.
What is the total amount? 16 lakh foot. What is the total amount? Supreme for the petitioner. The petitioner has filed the present application for grant of letters of administration of the property and credit of the deceased Salil Kumar Chatterjee throughout the state of the West Bengal. For the counsel for the petitioner submitted, the deceased died on 7th May 2021, and the wife of the deceased, Pani Chatterjee, was predeceased to the deceased, who died on 16 November 2016. The deceased died leaving behind only one son, namely Aditya Narayan Chatterjee, who is the petitioner before this court. Would the counsel for the petitioner submit that? Why Aditya Narayan has not come forward?
He is living in UK.
Where is that attorney?
Yes, ma'am. President, an extra 48 minutes.
Huh?
Power of attorney minute, 51.
Huh?
Final power of attorney.
No power of attorney is here. हाँ? पेज 51 है ही नहीं यार, 5 पेज का पिटिशन है. Affidavit of competence, general. क्या बोला? Submit that. Submit that. Full stop. The counsel for the petition submit that publications they are made and citations were issued, but none has come forward for raise any objection for grant of letters of administration to the petitioner. Accordingly, the department has submitted no caveat certificate on 1st March 2023, stating that no caveat has been entered against the grant of letters of administration. Consider the submission made by the counsel for the petitioner, peruse the death certificate of the deceased and the death certificate of the wife of the deceased. This court finds that the deceased died leaving behind only one son, who is the petitioner before this court, and prayed for grant of letters of administration. This court finds that there is no impediment for grant of letters of administration. Accordingly, the department is directed to issue the letters of administration to the properties and credits of the deceased throughout the state of West Bengal, subject to furnishing bond of rupees . What is the total cost? Bond of rupees 1,64,00,000. What is the total assets?
Amended assessment.
1,64,00,000.
36. Payment.
1,60,00,000 कितना होगा? 1.5 लाख का, 10 lakhs with 2 securities.
Page 15
with 2 securities.
Total. Page 16.
PLA number. Yes, next.
What do you want? My application for grant, in this matter, my lordship had called upon the registrar to produce the book, the register.
Argument?
Yes. But I shall only indicate the certified copy of the will and the affidavits of consent, along with the affidavit of the attesting witness. Lordship will have.
Where is the will?
The will is at the certified copy of the will is at page 16.
Exhibit B.
Exhibit B.
Will is exhibited.
Yes, the certified copy was exhibited.
Exhibited.
Yes, yes.
Yes, exhibit B is the will.
Question 4.
What is Exhibit A?
Exhibit A, I will tell you. The Exhibit A is the police complaint, because the original will was lost. But the witness will kindly see the deposition.
Yes, exhibit is the general diary.
Yes, the general diary.
And exhibit B is the will and signature of the attesting witness.
Yes.
Where is that?
And exhibit C is the original, the authorization received from the
signature. B1 is B by 1 is
B1 is the signature
of the testatrix.
yes, B by 1 is the signature of the testatrix.
Testatrix. And B by 2 is also testatrix. What is the name of the testatrix?
The testatrix name is
testator.
Ashish Kumar Borua. This is the testator, and the name of the attesting witness was given the who is one of the attesting witnesses.
The signature of the attesting witness has not been exhibited.
Yes, because it was a certified copy, so the attesting witness signature was not there. The actual signature was not there.
B by 1. Where is the evidence?
Kindly see question 35.
Question 35?
Yes. Question 35.
Yes.
Question that's the last question here. Lordship has marked the will as Exhibit B and the signatures of the testator as Exhibit B1, B2, and B3. There were 3 signatures of the testator on the certified copy.
Is the attending witness?
No, there was an attesting witness who has given his.
Is the attesting witness?
No,
Who is he?
Who is one of the deponent? The deponent is the executrix.
Is the executrix?
Yes. Deponent is the executrix, and Anushree Bonik, who is the executrix, and there is an affidavit from the attesting witness. The signature of the attesting witness who could not be identified by her because the certified copy of the will did not have.
The attesting witness affidavit is there.
Yes, it is there.
Attesting witness was alive.
Yes, but page 27 is the affidavit of one of the attesting witnesses.
Page 27.
Yes.
Swati Sengupta.
Yes. She is one of the daughters of the deceased.
There is no will.
Sorry?
There is no signature in the will.
In the certified copy. That is why she herself said that I cannot identify this because it was there in the original will, but that's lost. All the legal heirs have also given their respective consents. And in fact, on the Lordship sees the second day's deposition, second day's evidence. Lordship had called upon the registrar who had come and produced the book in which one of the will was.
Yes.
The book itself was produced. And question 4, he had compared and found the contents to be identical and accurate.
Yes.
So one of the certified copy of the will, although one of it's in case of a will, there is no presumption of genuineness, but one of the certified copy of the will has been proved in accordance with the Evidence Act, one of section 68.
No, that on that the provisions of that Registration Act. No.
Yes, I had shown. But this is the West Bengal registration filing of true copies rules. Well, it must be there in your Lordship's records. Well,
Yes.
It's there. But kindly sees that this true copies rules. Rule 3, 4, and 5. Rule 3 says every document that is presented for registration shall be accompanied by a true copy. prepared in the manner specified in these rules. Such copy shall be furnished by the person presenting the document for registration. Then Rule 4 lays down the procedure in which the true copy is to be prepared by the copier. And Rule 5.2 and Rule 5.7. These are the two provisions I'm relying on. 5.2 says each copy shall be exact reproduction of the original document, but it need not be a facsimile copy. Everything appearing on each page of the original document, including the signatures, shall be faithfully copied in the copy. 5.2.
Yes.
And 5.7, I shall indicate this endorsement. The preparer of a copy shall draw 2 centimeters line at the end of the copy and enter the words copy prepared by and sign after this entry. But all these compliances are there in the certified copy of the will which has been produced.
Where is the explanation of the delay?
My lord, yes. Kindly takes paragraph 7 onwards. In fact, 6 onwards. This is the residential property, the portion of which has been bequeathed upon the testatrix, upon the beneficiary, which is the executrix as well. She was not aware of how to apply because she was already in possession. Paragraph 7 to 11, and thereafter the will was misplaced, and that explanation has been given.
Concession suffering for the petitioner. The petitioner has filed the present application for grant of probate of the last will and testament dated 4th October 1996 of the testator Ashish 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 Kumar Barua BRU alias Ashish Kumar Barua KR. Full stop. Counsel for the petitioner submit that the testator during his lifetime has executed his last will and testament by appointing the petitioner as sole executrix of his last will and testament. Full stop. The testator died on
7 September
2006, leaving behind. Where is the legal heir?
Page 7, if your lordship takes of my application, these are the details of the legal.
Leaving behind 6 legal heirs. That is the mother.
In fact, it would be 5 legal heirs. The wife had predeceased the testator. It would be 5.
5 legal heirs. That is the mother, Nalini Barua, now since deceased, daughter, Swati Sengupta, who is the petitioner. She is the petitioner.
No, she is the attesting witness.
Swati Sengupta, Anushri Banik.
She is the petitioner.
The daughter of the daughter, the petitioner before this court, and the executrix of the will, Srimati Madhumita Barua Banerjee, daughter, and Sri Arunganshu Barua, son. So none has come forward.
But everyone has given their consent.
All the persons have filed their affidavit of consent stating that they have no objection to grant probate of the last will and testament to the petitioner. Full stop. The counsel for the petitioner submit that the original will was not traceable, has been misplaced, and accordingly, the petitioner has made a complaint. Where is that?
At page 15.
Has made complaint to the exhibit A has made complaint to the
question 12, exhibit A.
To the officer in charge, Jadavpur PS, on 28th May 2022.
It will be 30th May 2022. 28th May is when the will was found to be lost.
30th May 2022 by a GD number 2139 dated 30th May 2022. Full stop. As the original will was not in the hand of the petitioner, accordingly, the petitioner has proceeded the matter to prove the will in the solemn form. Accordingly, the petitioner has been examined as PW1.
Yes.
PW1. And during her examination, she has categorically stated that she could not get the original will, and accordingly she had made a complaint to the concerned police station, and this complaint has been marked as Exhibit A, and the signature of the witness / petitioner is marked as Exhibit A by 2.
A by 1, and the endorsement of the police station is A by 2.
कौन है एग्जिबिट करता है यार? डॉक्यूमेंट एग्जिबिट कौन करते हैं? See? A by 1, and the seal and signature of the concerned police station, wherein the GD number is marked as Exhibit A by 2. A by 2. Police. The will dated
on 4th October 1996.
The will dated 4th October 1996 is a registered will. Accordingly, the petitioner has relied upon the certified copy of the registered will. But during the examination of the petitioner, it is found that in the registered will, there is no signature is appearing with regard to the attesting witnesses. Accordingly, the petitioner has identified the signature of the attesting witness in the Xerox copy of the will, which is been encircled as blue ink. As the certified copy which the petitioner has relied upon is not contain the signature of the attesting witnesses in the last page, and the said certified copy is the photocopy of the register maintained by the office of the registrar. Accordingly, this court has issued subpoena to the District Sub-Registrar Jalpaiguri for production of the original.
Question 4. Question 3 and 4.
Questions
3 and 4 of the deposition of 11th March.
Original book number 3, page number 70, volume number 1, page number 73 to 76, document number 19 of 1996, dated 2nd December 1996. Accordingly, the District Sub-Registrar Jalpaiguri has sent the original book number 3 before this court. Full stop. The witness has identified the original register along with the certified copy which has been provided to the petitioner, and submitted that the Exhibit B, which is the certified copy of the will, is the copy of the original register maintained in the office of the District Sub-Registrar, Jalpaiguri. Full stop. This court, full stop. The counsel for the petitioner submit that the will was registered in the year 1996, and at that point of time the registration has been done in accordance with the West Bengal registration within bracket filing of true bracket close rule 1979, in which the registration of the document has been provided. The counsel for the petitioner relied upon rule 3, 4, 5 within bracket 1 and within bracket 2 and rule 7 of the said rule, which reads as follows. इसको करना कॉपी, ये 3, 4, ये ठीक है, यहाँ से लगा प्रिपरेशन ऑफ कॉपी, ये और ये सेट आउट कर counsel for the petitioner further submit that this court find that the will is dated
4th October 1996.
4th October 1996, and the testator died on 7th of September 2006, but the petitioner has filed the present application in the month of March 2023, but the petitioner has explained the delay, why the petitioner has not immediately filed the application for grant of probate of the said will. This court find that the petitioner has explained the delay for not filing the application for grant of probate in paragraph 7 to paragraph 11 of the present application. This court satisfied with the explanation made by the petitioner as to why the petitioner has not filed the application immediately after the death of the testator. Full stop. Concerning the submission, full stop. Concerning submission made by the counsel for the petitioner, produce the certified copy of the will, evidence of the petitioner, evidence of the official of the district sub-registrar Jalpaiguri, produce the certified copy of the will and the copy of the complaint made by the petitioner before the concerned police station, wherein she has lodged a complaint with regard to loss of the original will. Considering the above, this court finds that the petitioner has proved the will and is entitled to get the probate. The department is directed to issue probate to the petitioner on compliance of all formalities. PLA number so disposed of.
Grateful.
My lord, only Inocos per my lord, in matter, one matter, my lord, only my citation to be issued.
Which matter?
My lord, 185 of the monthly list, my lord.
185 monthly list, how it can be? You could have mentioned in the morning, it will come in the list. Come morning, mention it, it will come in the list, then we'll see.
My lord, item number 35, I will not be present next week, so it can be taken up in the next month 7.
Item number 35, record karo. Item number 35, as per the prayer made by the counsel for the petitioner, the case is adjourned. Let the matter appear on
7th,
8th.
7th or 8th, 7th.
Let the matter appear on 8th of April.
My lord, under extremely constraining circumstances, I am mentioning, my lord, a matter. My lord, the suit was fixed as undefended, my lord, and my lord had appointed a commissioner for recording of the evidence. My lord, I am appearing for one of the unfortunate defendants, my lord, who intends to file a written statement. My lord, it is prepared, my lord, and it is ready to be affirmed, my lord. It will be done today. I have taken out an
when the case is fixed?
My lord, the commissioner is today, my lord. Even if my lord makes one observation, my lord, I will go and pray for adjournment before the commissioner. My lord kindly gives me leave to file with short service.
For what?
Master summons, my lord. So the application is made returnable because my lord.
What application you want to?
Application for condonation of delay of 45 days in filing this application for
commercial suit?
Not non-commercial, my lord. Non-commercial. I am saved, my lord. But even then, my lord, written statement, my lord, is ready. My lord kindly grants me leave for.
Push for the other side. Bring the other side. We'll see to that.
My lord, will may I come back before my lord rises,
Correct.
my lord, before 4:30?
Come.
I'm extremely grateful.
Come with the other side.
I'm
We'll
extremely
see to
grateful.
that.
Lord, of 24th of January 2025, Lordship will find, my lord, if I may read from the second paragraph, counsel for the plaintiff submits that in spite of order passed by the appellate court dated 23rd December 2024, the defendant has not deposited the amount in terms of the order passed by the appellate court. Now, my lord, may I just assist, my lord? There was an application filed by them in respect of which, my lord, they wanted to, my lord, file, my lord, the written statement beyond the statutory period. Lordship had dismissed it. An appeal was preferred. In the appeal court, Lordship, my lord, they were not entertained to that extent. But, my lord, an order was passed. If they deposit a substantial amount, then, my lord, Lordship would hear them. The matter came back to my lord. Lordship extended the time to put in the money, and, my lord, for them, and thereafter file the written statement, not complied with. That's, my lord, recorded. My lord, in the second paragraph, counsel for the plaintiff submits that instead of depositing the amount in terms of the order passed by this court, which was subsequently modified by the appellate court, defendant has filed an application praying for revocation of clause 12 and for returning of the plaint. Then Lordship sees on none appears on behalf of the defendant. This was the third or fourth occasion, my lord. None has moved the application filed by the defendant. Counsel for the plaintiff has drawn the attention to this court that the prayers made in the plaint and submitted that no leave was ever sought, my lord. I don't know why they filed that application. Lordship has recorded the prayers. Now, my lord, kindly sees the last paragraph. Neither in the prayer nor in the plaint order passed by the learned master any leave was granted under clause 12, and as such the revocation does not arise. Considering the same, my lord, the application is misconceived and dismissed. By an order dated, this court had already dismissed the application filed by the defendant, my lord, as I said, my lord, and had filed prayed for time to file written statement. Accordingly, chance to file written statement is closed by the order, because, my lord, that honorable higher division bench's order as well as my lord's order was not complied with. Now, my lord, we have been, now, my lord, it's a, my lord, a summary suit, lord. This is a summary suit, my lord. So, my lord, I need to only, my lord, prove my claim. I was only saying this, my lord. I am filing my judge's brief of documents, my lord. Lordship may appoint a commissioner, my lord, because there is no other side here. My lord, I can finish off, my lord, the evidence and come back.
The witness is not present.
Today he is not there, my lord. But, my lord, I have some difficulty, my lord. Kindly fixes the commission, my lord. I'll, my lord. My judge's brief, my lord, may I file? And, my lord, I can come back after 2 weeks, my lord, before my lord, for the final arguments, my lord. This my lord, suit can be disposed of now. I filed the judge's brief, my lord. Simple money claim, my lord.
Yes.
Anybody can be appointed, my lord.
Consensus and suffering for the plaintiff. The matter is fixed today for witness action on behalf of the plaintiff. Police stop. Counsel for the plaintiff has filed judge's brief of document and submits and prays for appointment of commissioner for recording the evidence of the plaintiff witness on commission. At the learned counsel for the petitioner and plaintiff. Yes. Yes, madam, you can. How many years you are having the practice? Can you do? Help her?
Yes, yes, of course.
Since appointed as commissioner for recording the evidence of the plaintiff's witness on commission. The remuneration is fixed at rupees 15,000 per sitting, and the remuneration shall be paid by the plaintiff to the commissioner. The commissioner is directed to inform the date of recording the evidence of the witness of the plaintiff on commission to the assistant registrar of this court, so as to enable the office to produce the document at the time of evidence of the plaintiff witness on commission. The commission is directed to complete the evidence, complete the recording of the evidence of the plaintiff witness within 4 weeks. Within 4 weeks, and to file report before this court. The commercial matter?
Yes.
Commercial, my lord.
On 28th of April 2020.
Only prayer that I have, my lord, is after that, kindly fix a date and time, 5 minutes matter, my lord, decree can be passed, my lord, a suit can be disposed of for argument, my lord. Any day, lordship, in small case, my lord, and the suit will be disposed of. One will be knocked off of my
Let the
lord.
commission be complete. I will,
But that's on
I
28.
will take no problem. No problem. I take
Then
not
again, I have
you
to come
file
and
the-
mention, my lord.
File the return notes up, then I will dispose of it. Time will not permit. No.
But I am promising any day in April, any day. I will file my written statement also on 28.
ये कब होगा?
Written notes.
कोई 345 है अप्रैल में?
মে স্টার্টেও হবে, কোনো অসুবিধা নেই।
29th at 345.
29th রাখবি না মেতে রাখ, কারণ ও 28th দেবে, 29th মে যে কোনো একটা দিন দাও না, মে আমি ওই জন্য আমি আর নট 345, একটু আগে। দিস ক্যান বি ডিসপোজড অফ। হ্যাঁ,
5th of May at 345.
345
345 only. You will not get any date.
My lord's list is too heavy. Grateful, my lord. Grateful.
क्या बोला? Filing of the report on 28th and for argument, if any, on 5th of May at 345.
Great.
You give your name and phone number.
I appear for the petitioner defendant, my lord. 13
one?
days delay.
Item number?
15. 13 days delay, my lord, in filing written statement.
30 days delay.
1-3, my lord. 13.
13 days delay.
Yes, my lord.
13,000 rupees.
27 January date of
When
summons.
you received?
27 January 2025. I was
That is
supposed to file-
objecting.
Not in every matter, my lord, to reaffirm, my lord, how my lord innocuously he presses his prayers, thereafter nothing remains to submit. So, my lord, so my lord, there is not much to my lord object. Lordship, in fact, has already accepted the written statement from me.
Yes.
But let it be contested that this should be expedited.
Yes.
As you
That
declare.
No difficulty.
When you received the writ of summons?
27 January 2025.
27 January.
Paragraph
Yes,
4. Paragraph 4.
Paragraph 4 I've stated. And time expired on 26 February 2025. I've affirmed it on 11th March. I took leave from my lord to file it. In the
27
department.
January received.
Yes, my lord. I had time till
26 February over.
Yes.
And affidavit written statement affirmed.
Affirmed on 11th March 2025.
When suffering for the plaintiff, when suffering for the defendant. Police of the plaintiff has filed the present application being GA-Com 2 of 2025, praying for extension of time to file written statement. Sole defendant?
Yes, yes.
Counsel for the defendant submitted. The defendant has received the writ of summons on 27th of January 2025, and time to file written statement time to file it, 30 days for filing written statement expired on 26th of February 2025. Counsel for the defendant submit that the registered office of the defendant is situated at Mumbai. Only the regional office is situated at Kolkata. After the receipt of the writ of summons, to collect the document to prepare the written statement, the regional office and the registered office has been contacted, and for getting all the documents, 30 days for filing the written statement was over, but the defendant has prepared the written statement and affirmed the written statement on
11th March
11th March 2025. 2025. Also, counsel for the plaintiff submit that, defendant submit that, though the plaintiff has not, defendant has not filed the written statement within 30 days, but it has been filed within the outer period of 120 days. And he prays for acceptance of the written statement. Per contra, an advocate for the plaintiff submit that the defendant has not shown any cause as to why the defendant has not filed the written statement within 30 days, and he prays for rejection of the application. But the learned counsel for the respective parties perused the application, this court find that though the defendant has not filed the written statement within the prescribed period of 30 days, but has affirmed the written statement within the outer period of 20 days, and has also taken leave from this court to file the written statement in the department, and it was filed on
13th March
13th
2025.
of March 2025. Considering the above, this court finds that the defendant has filed the written statement within the outer period of 120 days and has explained the delay as to why the defendant could not file the written statement within the prescribed period of 30 days. Considering the above, this court finds that the defendant has this court finds that one opportunity should be given to the defendant to file written statement subject to payment of cost of rupees 2,000.
13 days is a public enterprise.
But law says 2,000 within a week to the State Legal Service Authority, and the defendant is directed to produce the evidence before this court after a week to show that the defendant has paid the cost to the State Legal Service Authority. Police stop. GA number and the police. The department is directed to accept the written statement subject to scrutiny. Copy served.
It's annexed with the application itself.
As the written statement of the defendant is accepted and is also served to the learned counsel for the plaintiff, the parties are directed to complete the discovery and inspection of the document within 2 weeks, 3 weeks, within 3 weeks, affidavit of admission and denial of the document be filed within a week thereafter. In the meantime, the parties are also directed to exchange the suggested issues. This is the matter. 3 weeks on it. This is the matter on 22nd of April 2025 for framing of issues. GA number to dispose. Yeah, lucky man.
Very lucky. I told the juniors, keep a watch, the 2 o'clock meal, but nobody is concerned. But luckily, it is our
saw in the video
good fortune.
It was ex parte matter which was going higher. So I thought it will not go. ওটাই দেখে আমি বেরিয়েছিল।
Lord, yesterday I had shown your lordship, my lord, the principles laid down by this honorable court and the Supreme Court on all the 38 principle, the injunction principle, and thereafter, my lord, I also took your lordship through the prayers in the suit, the prayers in the injunction application, the injunction that we are suffering. And what I did not show before your lordship is, I will show it later, my lord, the appeal court's order, and then why. Now we are post affidavit. Now, my lord, the moment an interlocutory application is being considered by the court post affidavit, well, the situation that was there at the ad interim stage is diametrically very different. Diametrically opposite may not be the right thing to say, but the consideration of the prayer for temporary injunction post affidavit is entirely different from that what is there at the time of at the threshold stage, at the ad interim stage. So that at that relevant point of time, your lordship was considering the case made out in the interlocutory application, on the basis of which your lordship was pleased to file. Now my affidavits are here. Now, my lord, before I proceed any further, my lord, we have made the compilation of what has been addressed by my learned friend on behalf of the plaintiff. কোথায় গেল বড়টা কোথায় গেল নোটটা কোথায়
Yes.
হ্যাঁ তোমার সাবমিশনটা একটা পুরো নোট করে সব দেখিয়ে well, thanks to the YouTube recording. So, well, submission wise, the entire note is there. I will.
like the transcript we have abroad, my lord. In UK and other courts, we have transcripts of. Yes. But I don't know, my lord. But he can give me a copy. At least I can understand.
In one case, what has happened?
My junior, without even asking me, just hand it over to Mr.
Very.
This is the impression Mr. Thakkar carries with him.
You know, my submissions, he should give me copy first. I have copyright over this. This is infringement. He's handing over without my permission. Mr. Bose is taking steps.
Am I not handing over? This is for my consideration.
Why did you hand over to the honorable court?
I did not. Who handed over
honorable
to the court?
It has given here. Yeah, your junior is distributed to all.
Like the telegraph which comes in the morning goes everywhere.
I'll be careful from now on. All I did was I was trying to praise the juniors for the dedicated work that they have done. That doesn't mean it should have been shared with the judge or the other side.
In one case, what has happened? In the arbitration matter, the department, I was appearing for the department. Department has sent the parawise comment and all these things, brief history and all these things, internal. So I told my junior, okay, you keep it. What he has done, he has mailed to the other side. So I send.
Well, I am presently in the identical situation.
Thank you.
Hey, তুমি তো শুনিস
Yes.
Devangshi কোথায়? Are you in this matter? Please go back. Thank you. My lord, before I go any further, my lord, there are certain paragraphs which were shown by Mr. Thakkar from the interrogatory application. My lord, I'll just trouble your lordship with some of those paragraphs. Kindly first take, my lord, paragraph 12 of GA1. This, your lordship will find this at page 11.
Yeah.
Well, the plaintiff was not obligated to make any further payment to defendant number 1 in terms of the first contract, clearly such and such. Then, my lord, the next sentence. However, as the plaintiff was in urgent need of goods and the defendant number 1 represented that it had already made part payment to the defendant number 6, the plaintiff authorized its bank to remit an aggregate of such and such in 2 tranches. Now, my lord, so these 2 tranches is being given based on the representation made by the defendant number 1. This is his own case.
Correct.
And this payment as per the bank receipts, which is part of the interrogatory application, is payment made by the plaintiff to defendant number 1. Sometime in the first week of June, plaintiff entered into discussions with the defendant number 6 for purchase of bulk quantities of 1,000 metric tons and above of carbon ferro such and such through a common acquaintance, Pratik Batra. The plaintiff was informed by Mr. Batra that the defendant number 6 had quoted a price of $900 for supply of bulk quantities. The plaintiff was surprised to receive this offer as the defendant number 1 was supplying a lesser quantity of the same product manufactured by defendant number 6 at a price of $795 under the first contract. The price of high carbon ferromanganese is substantially discounted when purchased in bulk quantities. The market price of the product had also fallen and was in the range of 700. So through Batra, he says, Batra acquaintance, I made an offer. My clients made an offer 900.
Correct.
According to them, that is higher. Private contract. So now I have made 900, 9,000. He finds it higher. Why? Because under the first contract, defendant number 1 was selling it at less. Good. So you proceed continue to taking from defendant number 1. Then, my lord, in these circumstances, the plaintiff informed Mr. Batra that the price quoted by D6 was unrealistic. All the more reason. And that it was expecting a price in the range of 600. It transpired that Mr. Batra informed the counter offer of the plaintiff to the defendant number 6, which was responded by an email of 8th June to Mr. Batra, stating that it would rework its offer. Now, Lord, kindly pausing here for a moment and turn to page 149, where your lordship will find this email. Second
volume though?
Yes, second volume, 149.
Yes.
Just one sentence, and my lord, that should be sufficient for our purpose. Kindly see who sends it to whom.
Export sales.
Yes.
Shyam Group.
To Pratik Batra.
To Pratik Batra.
Now, my lord, what does it say? Subject is high carbon ferromanganese. Thanks for your email, such and such, such and such. Then, with reference to your email, so this is a response to an email to Pratik Batra, the third party broker. I am really glad that the buyer is ready to take this forward, and I thank you for all the extended support. Is this not usual commercial practice? So that means today, if I'm negotiating with the buyer, this is not a retail grocery store.
Yes.
These are how products are sold in the commercial market, which is worth thousands of crores.
Correct.
Hundreds of crores worth of materials are sold like this. So basically, this is negotiation. Coming to the pricing mechanism, I wish to inform you that if you see offer is almost now over 2 weeks old, and now the dynamics of our products prices keep changing a lot within days, and the same thing happened in this case as well. There has been some corrections, and we have surely such and such. Then, my lord, although we are sure that mention of 30% such and such, then it is very helpful for us if you can kindly check from them at the level of such and such. And then, my lord, then we say that let us know. Accordingly, we'll rework the entire thing and get back to you soonest. What will I rework? My pricing. Please also check if they're asking for quotes in Euro or USD. I look forward to hear from you. This is all.
Correct.
Now, Mala, how has this mail been sought to be interpreted? Now, Mala, kindly come back to paragraph 15 at page 13.
Yes.
Copy to them. Copy to them. Where is it? Oh, this is 9 June, 8 June. Mr. Batra replied to the defendant number 6 by his email of 9th June, which was also copied to the plaintiff. If Mr. Batra chooses to copy it to the PMO's office, it's not my lookout. He has chosen to copy it to him. So he was negotiating, if at all, on his behalf. So it is his party. He has forwarded to him and requested for a virtual meeting between the plaintiff and the defendant number 6. This virtual meeting, your lordship will find at para 16. Much has been said about this virtual meeting, the Skype meeting, as if, my lord, this effectively is a representation or some kind of a commitment that I have made to supply. Now, my lord, kindly see what is the virtual meeting and what is being pleaded at para 16. A virtual meeting on the Skype platform was held on 10 June between the plaintiff's director, Ali Muhammad Ali Mahabadi, Mr. Ali Shayan Chatterjee, Senior Sales Manager of the defendant number 6, and Mr. Pratik Batra. In course of such meeting, it was represented by Shayan Chatterjee. The defendant number 6 was a part of the Sham group of companies, which included D10, and Sham Metallics and Energy Limited, Shayan Chatterjee claimed that D6 and 10 could single-handedly meet the plaintiff's requirement of all kinds of ferroalloys. The plaintiff parties discussed about the procurement of bulk quantities of diverse ferroalloys over a long term. So even the plaintiff's case is discussions. In course of negotiation, D6 stated that it was aware that the plaintiff had brought a consignment. So D6 says that he is aware that the plaintiff had bought a consignment of 216 metric ton of carbon such and such, manufactured by the defendant number 6 through the defendant number 1 at a price of 875. So this, who has said this, by not, even if I assume for the sake of argument that what they've said is correct, though I have denied that in my opposition. So once I deny that in the opposition, and he says, because he said, like, everything I've said is false. Like that, like whatever he has said is true and whatever I have said is false. It's like the OMR sheets. All I have said is false. So he says this. Now, how do you say what I have said is false?
So you mean to say there's a matter prior?
You have made a statement and there is nothing to support your statement.
Okay.
So now let us examine this, my lord. Now your lordship will kindly see 200. He says that D6 was aware that the material supplied by us to defendant number 1 has been sold by defendant number 1 to plaintiff, which is a quantity of 216 at a rate of 875.
Correct.
My lord, assuming that I was aware, what turns on that? Does that give them the right to sue me for damages or have a money claim against me for breach on the part of the defendant number 1? Or he has extended the breach to me.
Yes.
Now, your lordship will see, however, the defendant number C declined to disclose the price at which the defendant number 1 was purchasing the materials from the defendant number 6. So, I have declined to disclose my price. The defendant number 6 also declined to reduce its offer. However, the defendant number 6 confirmed and assured the plaintiff and the defendant number that the defendant number 1 was associated with the defendant number 6 and 10, and the said defendants would perform and deliver all the orders placed by the plaintiff on the defendant number 1, provided they received full payment before loading of containers. One, I have denied. B, even assuming if your lordship considers this to be correct. So this is provided I receive full payment before loading of the containers. So even the case made out by him, so it was a conditional offer that I made, yes. Even his own case. My lord, assume for the sake of argument, there is no affidavit. Would he still be entitled to an injunction as against me, let alone a attachment order? So it says, provided they receive full payment. I did not receive full payment. So far as his materials are concerned, he is paid to defendant number 1. I did not receive the payment. If the defendant number, say, assuming if the defendant number received the entire payment, there is no evidence on record that I received the payment from defendant number 1. That case has also not been made out by him.
Yes.
The defendant number 6 further represented that as a special case, defendant number 6 had commenced loading containers arranged by plaintiff before receipt of full payment only by the request of such and such, as the plaintiff was a potential major client. However, in future, cargo would be loaded in the containers only against receipt of full payment. The defendant number 6 stated, Mala, the previous sentence, the commencement of loading of containers, is your lordship recollects, Mala, that SGS report and the 3 containers which they linked to the defendant number 1's affidavit, and they said that these are my containers which went to the factory of the defendant number 6, and I had given the bags, my bags, photographs. See, they have loaded in their container, so I am liable.
Yes.
The defendant number 6 stated that the last sentence at page 14,
Yes.
the defendant
Could
number
not
6
offer the
stated that it could not offer the discounted rates to the plaintiff, which it offered to use the defendant number 1 because of its long-term association with the defendant number 1. So it is his own case. In these circumstances, the negotiation with the defendant number 7 did not fructify. I am sure, my lord, your lordship has made a note of that.
Yes.
Phrase did not fructify. Except for, one is did not fructify, then except for assurances and promise.
Yes.
By the defendant number 6 that all contracts placed by the plaintiff on the defendant number 1 for goods to be supplied by D6 and D10 would be duly performed. So on the basis of this assurance and promise, he says that he is entitled to an injunction against me.
Yes.
And as also attachment. So this is his case.
Yes.
Now, my lord, your lordship will see. Now, my lord, kindly take para 18 once. Then he says, solely on the assurance and promise made by the defendant number 6, in course of meetings held on 10 June, the plaintiff authorized his bank to remit such and such to defendant number 1. Lordship will kindly appreciate the absurdity. He doesn't have a privity with me. There were negotiations which he agreed that the offer made by him was not acceptable, counter offer made by him was not acceptable to me. So, the negotiations did not fructify, but I gave assurance. So, based on that assurance of mine, crores and crores of rupees of deal, and my lord, look at the value of the contract. This amount which is paid, the total value of the contract is much in excess of 30-40 crores. So based on these assurances that one make, in course of a meeting, he has paid to defendant number 1.
Yes.
And now he says defendant number 1 is only a trader. No case made out in the plaint anywhere. So you have chosen to enter into contracts with a trader knowing that I am the manufacturer. You have chosen not kindly appreciate this situation. He is aware, conscious that I am the manufacturer. He is also conscious of the fact that the D10 is the manufacturer. So instead of entering into a contract with either of the manufacturers, you go to a trader. Because the trader is offering you a better price. The manufacturer, now it should be the other way around. But commercially doesn't make much logic. A manufacturer is offering higher price than the trader. So that means the trader has no margin. We'll sell at a loss. It's usually the other way around.
No, that's why he has pleaded here, na?
Yeah.
Because his defendant numbers, he has mentioned somewhere that because he is having the business relationship with the defendant number.
So I will, because of business, long-term business association, I will sell at a loss.
No, that's why they have taken the plea in the return, in the plane.
So that's why I'm telling your lordship, if your lordship will try to connect the dots, they don't connect.
Yes.
So there is an oblique motive. This is a complete illusory cause of action.
Okay.
So the objective is not to impede defendant number 6 because he is a proper and necessary party. Because I am neither a necessary nor a proper party in this proceeding, because his entire cause of action, if at all, is against the first defendant. His claim, his breach, his damages, his refund of money, loss of profit is entirely against the defendant number 1. So he has impleaded me with a malafide motive and intent, which will only, because I am not a necessary party, I have said, wholly unconnected. Now, this can only, at best, at the time of trial, he'll be able to prove why. Now, one reason I have already indicated to your lordship to circumvent the arbitration agreement. So now he keeps negotiating with, suppose your lordship will kindly appreciate that. If I keep negotiating, there is no limit to negotiations.
Continue. Yes.
Now, my lord, one more paragraph.
No,
But
so
he has,
as per your submission,
yes.
even we go with the pleading also, there is no concluded contact with you, there is no privity of contact with you. Whatever they have stated, that is with regard to the defendant.
He has also not made out a case of privity.
Correct.
He accepts that there is no contract with me.
Correct. That's why.
He proceeds on
the assurance.
right.
It is only the assurance.
Well, at the ad interim stage, you are saying privity. Now, privity, he accepts there is no privity. He says assurance, promise.
As per this assurance, but
Yes.
the paragraph which you have given, but as per the case made out by the argument made by Mr. Thakkar is telling that there is a contract between the dependent number 6 also with regard to the supply of the materials.
That was the, if your lordship, this was the argument advanced by Mr. Thakkar that it's a collateral contract. No, my lord, from the pleadings, apart from assurance and promise, my lord, there is nothing. I will stand corrected if there is any paragraph shown which says that otherwise a case of collateral contract not made out. That's what I said on the other day.
Yes, that I
This was from the bar.
Yes.
This is no case made out anywhere in the plaint. Apart from assurance and promise in the paragraph I have shown, there is nothing as against the sixth defendant.
Okay. Yes.
And your lordship, my junior rightly points out, your lordship will find their contracts with the defendant number 1 has been disclosed. Kindly take any one. There are 8 of them. Kindly take any one. Well, at the first one, your lordship will find that or let us take a contract of which part performance have been made. Now, your lordship will see that paragraph that we shown to your lordship, my lord. There is a reference to, my lord, at paragraph 71, page 71, there is a reference to a contract. I'll show your lordship that contract. Any one contract, my lord. It has reference to the third contract. This is the third contract. No, this is para 117 is which contract? The third contract. My lord, allow me, my lord, just to take out my iPad. I have it all out there here. Barcode just taken. Give it to me. Give it to me. Give it to me. Nah. If your lordship take the second volume once, page 174 of the second volume. Kindly see. Lord, I am addressing the issue of collateral contract. A, no pleading, not a whisper in anywhere in the plaint or the interlocutory application.
Yes.
Buyer, seller. Your lordship has that, my lord?
Yes.
Buyer, seller. Hereinafter party, then kindly see goods.
Yes.
Subject to terms agreed in this contract, seller shall deliver 3,000 ferro-silicon manganese to the buyer. Description of goods. Kindly take now, my lord, 1.4 at page 175.
Yes.
Inspection of goods.
Yes.
Then your lordship will see price. Then, my lord, if your lordship kindly takes page 179, there's a clause which says entire agreement. It says, my lord, at page 179.11, then 11.1, the contract sets out the entire agreement between the parties. Neither party has entered into this contract in reliance upon any representation, warranty or undertaking of the other party that is not expressly set out or referred to in this contract. This article shall not exclude any liability for fraudulent misrepresentation. No case made out, no reference to any manufacturer, or that procurement would be made from manufacturers. He is a trader. So his contract, his pleadings are at variance with submissions made.
Okay.
Then, my lord, at the bottom of that same page, your lordship will see dispute resolution procedure, clause 13, arbitration clause. So this is exactly what he's trying to circumvent. Disputes arising out of.
Why you are agitating with regard to the? It is in Rome. It is a good place to visit.
I can't go. I'm not a party.
Yes.
Now, your lordship will kindly come back to one paragraph দেখাচ্ছিলাম.
Suppose you agree, we'll make your party. All of us will go.
Yeah. Make me. Let the injunction get vacated, then you make me party. I'll go with you. I'll happily go with you.
17.
Sure. I'm good. I'm agreeable to that. He says, vacate the injunction, then he'll add me, take me to Rome, make a file a section 17 there. I will contest it.
He misunderstood, my lord. Let this order continue till the section 17 is disposed of in Rome. Only for that limited purpose. It's usual.
Then my clients will.
Cake and eat it too. It's usual. I am in Rome. I've come from Rome to Calcutta. Kindly imagine.
He wants the jam, jelly, butter, bread, both. Everything.
That is the main food in the Rome.
That
you cannot find
pizza. So number of the difficulty is that Mr. Thakkar is a pure vegetarian.
I will not go, man. My client is in Rome. He'll have English lawyers. Mr. Bose will go from here.
No, they will not send me to Rome. They'll send me to Ranchi. And continue.
Yes.
Well, kindly once take 65.
Page 65.
Page 38, para 65. আবার নোটটা দিয়ে দিল জানো আমি বললাম ওদের অ্যাপ্রিশিয়েট করার জন্য নোটটা সাইড থেকে দিয়ে দিল ভালো ছেলে ইনডিড মনে রাখে এটা যেন মনে থাকে হ্যাঁ আছে My lord, what has been submitted based on 65 is, I'll tell you, lordship, not kindly take 165. Thereafter, in about the third week of January, Mr. Ali was taken to the factory of the defendant number 10 at Durgapur. Then, my lord, aforesaid, I am not D10. At the factory of D10, the defendant number 7 introduced himself as a director of D6. And 10, Mr. Ali also made Mr. Such and such, introduced such and such happened, placed an order. Then, my lord, this last sentence. The defendant number 7 informed the plaintiff that the defendant number 1 had placed an order of 1500 metric ton and negotiated rates for another consignment of 4500 metric tons. The defendant number 7 also confirmed that the defendant number 1 had placed an order of such and such on defendant number 6, for which part of the consideration had been received by the defendant number 6. Para denier, para bar kore. the defendant number 7 requested Mr. Ali to make payment in advance to the defendant number 1 in case the plaintiff placed an order on defendant number 1 for supply of 4,500 metric tons of such and such, so that the defendant number 1 could forward the same to the defendant number 10, and on receipt of such advance, the defendant number 10 would give delivery of the goods to the plaintiff through defendant number 1. The defendant also assured the plaintiff that defendant number 6 would give balance delivery of such and such. So I am restricted to 189. My here, according to his case, the substantial portion will be given by 10. The balance will be given by 189. Now, my lord, your lordship will kindly make a note of one sentence towards the middle of this page 39 of this paragraph. There was a sentence which says, about 5 lines from the top, it says, defendant requested Mr. Ali to make payment in advance to D1 in case the plaintiff placed an order on D1 for supply of 4,500, so that the defendant number 1 could forward the same to D10.
Yes.
So, my lord, no supporting documents?
Yes.
Now, my lord, so everything is happening verbal. And my lord, your lordship will only see the value of 4,500 metric ton is approximately 1,500 and 4,500, that is 6,000 metric ton. The value, I'll just give your lordship the value. So then your lordship can correlate that whether such a negotiation can only proceed on the basis of oral understanding in the commercial world. 700 crore. My God, 700 into 6. 42. So 4,000. কত ইউরো হচ্ছে বলুন? It would be about euro. It should be about 42,000 euros. No, 4,20,000 euros. I'll just calculate. Well, 6,000.
6,390.
No, can't be. I'll just calculate. It's a huge figure which runs into almost, I think, should be about more than 100 crores.
Total.
And act a simple maths. Just kindly give me a moment.
Good mathematician is by your side. Why you're not taking the help?
They cannot calculate.
Not in my note. That is why I can't say.
They can't calculate a simple thing. 6,000 into 700. চুপ করো অনেক হয়েছে। মানে 42 lakh euros. 42 lakhs euros. Into 100, your lordship will simple do 100. So that's about 42 crores. So, my lord, this entire transaction is this, and para 65 I have denied. Your lordship will take the note. Take a note. We specifically denied para 65 at para 34, page 30 of the opposition. And my lord, there's one more relevant, very relevant fact which we have denied. That defendant number 7, well, surprisingly, good that I read out this paragraph. Well, this injunction, your lordship will surprise, is continuous against the defendant number 7, who's an individual.
It is 7 also.
Yes. So, but how is the 7 suffering an injunction and attachment? He's an individual. Well, they have implemented him as if he's a director of 6 and 10. Factually incorrect. That's another aspect altogether.
Because B7 in prayer
B7
in the prayer B,
yes,
7
madam.
is there.
Yes.
And
so that personal injunction and attachment against the director.
G and H also, yes.
So even assuming the case made out, assurance was given by even director on behalf of the company
So at best the company is liable. So the injunction, he's paid for the injunction, say injunction on that individual also, because he's a director, though he's not a director. It's factually incorrect. We've specifically made that statement at para 34 of the opposition, that the defendant number 7 is not the director of the respondent number 10. He's only the director of respondent number 6. My company's director.
Yes.
So, but they have implemented now. The moment he is not a director of 10, now if your lordship reads 65, so 4,500 and 1,500 metric ton is not there. That means he could not have made any representation on behalf of the defendant respondent number 10 or the defendant number 10 here, because he's not a director of defendant number 10.
Correct.
There's no document to show that, and I have made a specific statement that is wholly unconnected with the 10th defendant.
Yes.
So then, now if your lordship come back to para 66, so the representation made that 4,500 metric ton and the 1,500 metric ton, if the plaintiff places the order and pays to the defendant number 1, will be supplied by 10. Balance will be supplied by 6. And the balance amount, your lordship will see 189. 189. So the remaining obligation was of 10. And 7 could not have represented 10 because 7 is unconnected with 10.
Yes.
So factually also, the allegation which has been made, bold reckless allegation, unsubstantiated allegation, is otherwise also factually unconnected and otherwise false. Since now, my lord, one more contention has been made by them in their reply affidavit. Now, this is really interesting. Mal, if your lordship will kindly take my argument once. There is argument para II, so 7. If your lordship will kindly take in the para 7 of the page 7 of the note which was prepared, my lord, it will be easier for us to understand. Well, this was the submission made by my learned friend. Fraud. Now, who has committed fraud on whom? Now, they are trying to say that, well, I have sold goods to the defendant number 1. He's complaining of that. My sale to defendant number 1, he is complaining. And what is the complaint? The price at which I have sold it. No, my lord, it's a threshold, my lord. Private sale, private parties. Now, whether I have sold it at 1 rupee or 100 rupee, there is no bar in law. If today I have sold 100 rupees good for 10 rupees, well, at best income tax or at best GST. So I have to pay the GST at the sale point when I raise my invoice. Now, what case he is made out? He is saying the rate that I have sold based on the government available rates, because these are meant for export, he has made out something called the index price.
Correct.
And he said based on that index, but there is no indexation. It is a fiction. It's a creation. The indexation is his creation. I will show from the document. There is nothing called indexation. What the government does is the total export made, because there is documented, all exports made from the country is documented. So there's a volume and the value of the export. Suppose, my lord, in the month of March 2025, 2,000 metric tons have been exported out of the country, this particular material. So that has a value. So that is what is, my lord, uploaded in the government websites. That this particular material has been exported in this month. This is the total value. So he's taken those values, he's averaged them and has found an indexation price. So there is no bar in law that I cannot sell it at a lower or a higher price.
Okay. Yes.
Now, my lord, if your lordship will kindly take once his reply, page 52 of the reply. আমাকে একবার reply-টা দেবে?
Reply.
Page 52. Your lordship will find this is the Ministry of Commerce, Department of Commerce. So his submission was that the value of the transaction or the rate at which
was supplementary?
No, my lord.
Supplementary affidavit?
Reply. Affidavit in reply of the plaintiff. This was
to the 1, 2, and 3, and 4.
No,
Affidavit
6
reply
and
to
7.
6 and 7.
6 and 7. 6 and 7.
ये तो नहीं, ये supplementary. Page
50, 52 onwards.
$52.
Yes, my lord.
Yes.
So, my lord, their submission is based on this document that I have sold, that there is a government price. First submission is there is a government price. And that I have sold it below the government price.
That's price, yes.
And that according to them amounts to fraud.
Which you can't.
Yes. Higher than the government price. Higher. Not lower, higher than the government. So that's a fraud. Now, my lord, kindly have a look at this. What is this document? Department of Commerce, System of India's monthly trade. Man, kindly make a note of that on top, my lord. System on India's monthly trade. Harmonized classification of commodities export wise. So, my lord, this is, if your lordship will see, it's a little illegible. The commodity name is there, your lordship will see.
Yes.
Now, your lordship will see month wise it is given, if your lordship will see.
Yes, April.
আমি তো দেখতেই পাচ্ছি না না এইটা দেখুন 10 11 না এটা 19 20 then your lordship will see that then there is a figure just below the under the commodity column India's total export. Then your lordship will kindly turn there's a date on top, then your lordship will see value in lakhs.
Yes.
So, my lord, ferromanganese, this is the manner in which ferromanganese have been exported. So, my lord, this is basically a data available with the government to indicate how much of export is being made.
Yes.
It's a platform which records the data.
Yes.
Well, that would be available. I mean, the fact that this is nothing but statistics, which includes data, if your lordship will find the website right on top. If your lordship, I am not been able to read myself. How will I assist your lordship? It says tradestat.commerce.gov.in. On top, your lordship will find the name of the website.
Yes.
ওটা করো না একটা ওয়েবসাইটটা আছে আইপ্যাডে মেরে দেখুন these are screenshots. They've done a better job. Well, they've got screenshots of that, my lord. If I may just, for your lordship better understanding, because it's illegible. Well, this is the website, Government of Ministry of Commerce. So if your lordship looks into this, this is what happened. Monthly export-import data bank, export-import data bank, foreign trade performance analysis. So this is how the government policy, whether in this financial year there has been good export, then similarly import is also there. So the development of the way we are progressing, the way this country is progressing, it has to be judged. These are the data analysis which is available. So now, my lord, this has been converted into indexation. Now, my lord, your lordship will also not find this. Now, this data is available on the, now he has used this data. Now, this was the submissions made, no case made out, that there is a rate based on the total volume of sale. He has derived a rate, and he says that the rate at which I have sold to D1, which is based on the invoices that I have disclosed in my opposition, it is higher. Now let's assume for the sake of argument it is higher. Though this is not an indexation, it is higher. What turns on that? Does that mean that I have committed fraud? No case made out anywhere in the petition though. So he says that from my opposition he's been able to ascertain this. Because I have disclosed the invoices, I have come clean. I could not have, there was no requirement for me to disclose the fact that I am transacting or I have doing business with the defendant number one. Not required.
Yes.
But we chose to bring it on record to show that we have independent and separate transactions with the defendant number one. So based on the tax invoices, similar, if I have sold it, my materials at a price. So if there is no bar in law to sell a particular, this is not controlled goods under the Essential Commodities Act. This is not sugar or any controlled goods that you cannot sell, or jute that you cannot sell in the market.
Yes.
Apart from the quantity which you have to first sell it to the government. In excess you can sell, and you can, if you sell to the government will give you only that rate. This is not a controlled product, does not fall under the Essential Commodities Act.
Yes.
So where is the bar?
Yes.
And unlike gold, there is no indexation that today the rate of gold is so much. So, my lord, assuming for the sake of argument, today the rate of gold is say 84. I go to a jeweler, he is willing to give it to me for 80. Is he committing a fraud? He maybe he has excess stock. He has less sales. Unlike the other gold merchants, he has less sale. He sells me the gold at 80 rupees or 80,000 rupees per 10 grams. When the market rate of gold is 84, is there a bar in law that he cannot sell it to me at 80? He is giving me a discount of 10, 15, 20%.
But you are liable to give answer to the authority.
Why?
If it is index price is there.
Correct.
If it is index price is there, then you are liable to give the answer to the authority.
No, now liable to answer like index pricing. Well, now there is indexation in real estate. Everywhere when you buy or sell property, area wise there is the indexation. Price, market price of this area is say 10,000 rupees per square foot. I sell it for, when there is less, there is a problem. More, there is no problem. Suppose I sell it for 7,000. So what is required? So all I have to do is that pay for the remaining 3,000 rupees per square foot. That will be charged, and I will be taxed on that. Nothing more than that. So there is no fraud. There is no fraud. So what I am trying to say is that A, there is no indexation on this particular item. Number one, there is no document on record to suggest that there is any indexation on this particular item. Number two, even if I have sold, because there is no pricing mechanism in the on this item. So the question at what rate I sold is utterly immaterial, and it is a private sale governed under the Sale of Goods Act. I have sold, whether at whatever price, it is irrelevant.
Okay. How much time you will take further?
15 minutes.
I knew this was coming. I knew this was coming. I knew this was coming. No further commitment, my lord. Your lordship will just give me a date.
Census and suffering for the plaintiff. Record कर लेना. Census and suffering for the plaintiff, census and suffering for the defendant 1, 2, 3, and 5. Census and suffering for the defendant number 6 and 7. Census and suffering for the defendant number 10, and census and suffering for the defendant number 11 and 12. Counsel for the defendant number 6 and 7 are argued less, but due to positive time, hearing could not be completed. Let the matter appear on 21st March 2020 under the same heading. 21st.
Oh, my lord, we are in some difficulty. My colleagues will not be there on 21st.
You're not there.
Online we utilize that time to complete our submissions in that event. Subject to their
25th कर दे.
25th again, I am not there.
25th you are not there. Then 28.
28. 28.
Interim order be extended.
28.
Interim order till up till.
Is still 21st, my lord. Interim order is till 21st, my lord.
Counsel for the plaintiff submit that interim order granted is going to be expired on 21st of March 2025. Accordingly, prays for extension of the interim order. In view of the submission made by the counsel for the plaintiff, interim order is extended till 8th of April 2025 or until further.
28 March.
Well, it will appear, it will retain its position.
Lordship, I appear for the plaintiff in this matter. Lordship, as per Lordship's last order on 24 January, Lordship had directed us to file the judge's brief of documents and the affidavit of evidence in a particular time period, although that is, Lordship, today ready, but not filed in the department, Lordship. If I may just allow to be handled.
Witness is present?
Yes, Lordship, my witness is present.
Bring.
You speak English?
आज पहली बार गवाही देने आएगा मेरे साथ बोलिए मैं कसम खाता हूँ जो कुछ बयान दूंगा वो सच होगा मेरे बयान में कुछ झूठ नहीं होगा ईश्वर मेरी सहायता करेंगे आपका नाम
अरुण कुमार लक्कड़
अरुण ए लक्कड़ LAKKAR
LACKAR
फादर्स नेम पिताजी का नाम बताइए
भूरामल लक्कड़
स्पेलिंग बताइए
BHURAMAL LACKAR
आपकी उम्र
मेरी 58
इयर्स क्या करते हैं आप
मैं सर्विस करता हूँ
सर्विस कहाँ रहते हैं घर का पता बताइए धीरे धीरे से
7 नंबर बेचाराम चौधरी लेन
नंबर 7 बेचाराम चौधरी लेन
हावड़ा
पिन कोड
771 71101
71101
101.
101 7111.
Is already numbered.
Yes.
Yes, madam.
Affidavit of evidence. I'm showing you this document. Kindly tell my lord what is this document.
ये डॉक्यूमेंट देखिए और माय लॉर्ड को बोलिए ये क्या है।
ये मैंने जो क्लाइंट के अगेंस्ट में फाइल किया था वो पेपर है।
या क्या बोल रहे हैं आप?
बोलिए फिर से क्या बोले आपने?
ये एफिडेविट ऑफ चीफ फाइलिंग प्लान।
This is my affidavit on
Chief
evidence.
filing.
Chief, which was filed by me.
Yes.
Under whose instructions has this affidavit been prepared?
ये एफिडेविट किसके निर्देश पे किया गया है, प्रस्तुत किया गया है?
ये मेरे निर्देश पे किया हो गया।
This affidavit of evidence has been prepared under my instruction.
Are the contents of this affidavit true and correct?
इस एफिडेविट में जो कुछ भी लिखा हुआ है क्या वो सच और सही है?
सच और सही है।
Yes, true and correct.
Kindly come to page 10 of the affidavit and tell my lord who has signed this affidavit.
10 नंबर पन्ने पर इसका सिग्नेचर है।
मेरा सिग्नेचर है।
This is my signature.
Can you encircle it?
इस आपकी सिग्नेचर को ब्लू पेंसिल से बोल कीजिए। Blue. The witness encircled. Yes. The witness encircled his signature appearing at page number 10 of the said document with blue pencil.
Where have you signed this affidavit?
ये कमिश्नर के सामने किया होगा।
In front of the commissioner. I signed it. I put my signature on the document in front of the commissioner.
So she will show the documents and get it exhibited. The documents, Lord Shubhal. Kindly see this document and tell my lord what is this document. This is appearing
Refer
at
the
page 1 of the judge's brief of documents.
इस डॉक्यूमेंट को देखिए और माय लॉर्ड को बोलिए कि ये डॉक्यूमेंट क्या है। क्या है ये डॉक्यूमेंट?
ये बोर्ड ऑफ रेगुलेशन है।
दिस इज द बोर्ड ऑफ रेजोल्यूशन
जो मेरे को अथॉरिटी दिया गया है।
बाय व्हिच आई वाज ऑथराइज्ड। इसलिए अथॉरिटी दिया गया
सुप्रीम फेट पेरियर दीपक अग्रवाल के अगेंस्ट।
by which I have been authorized to depose this matter by instant suit करो।
Who has given you this document?
ये डॉक्यूमेंट आपको किसने दिया है?
मेरे को किशन कहार ने दिया, डायरेक्टर।
This document was given to me by Krishna Kahar, director.
Overseer Enterprise.
Director of
Overseer Enterprise
Private Limited. Director of Overseer Enterprises Private Limited.
Are the contents of this document true and correct?
This document, yes, true and correct.
Lordship, this may be marked as an exhibit.
Exhibit A.
Lordship, although just I want to point out this, that although the judge's brief of documents, it has been mentioned as 1, 2, 3, 4, Lordship, the exhibits.
Exhibit A. Yes, next.
Kindly see this document and tell my lord, what is this document? This is appearing at page 224 of the judge's brief of documents.
डॉक्यूमेंट देखिए माय लॉर्ड को बोलिए ये डॉक्यूमेंट किस बारे में है?
ये मेमोरेंडम आर्टिकल है ओवरसीयर इंटरप्राइज का।
This is the memorandum of article of Overseer Enterprises Private Limited.
How have you received this document?
आपको कैसे मिला ये डॉक्यूमेंट?
ये मेरे माने कंपनी का ओवरसीयर इंटरप्राइज का प्राइवेट लिमिटेड
आपका कंपनी का है, आपको मिला कैसे?
मेरे को डायरेक्टर ने दिया।
The director of the company has handed over me this document.
Are the contents of this document true and correct?
Yes, document
correct.
Yes, true and correct.
So this may be marked as an exhibit.
Exhibit B.
Rendering you another document which is appearing at page 3, sorry, page 25 of the judge's brief of documents. Kindly tell my lord, what is this document?
ये डॉक्यूमेंट क्या है माय लॉर्ड को बोलिए.
ये बोर्ड ऑफ मीटिंग रेगुलेशन है, डायरेक्टर ने किया था.
This is the extract of the minutes of the meeting of the board of directors. Extract of the minutes of the meetings of the board of directors of the company, namely Oversure Enterprises Private Limited.
ये सुप्रीम फेड मूवर दीपक अग्रवाल को 25 लाख रुपया 12% इंटरेस्ट के हिसाब से प्रोवाइड करना.
On that meeting, resolution was taken that the Supreme Freightway Carriers has to give an amount of rupees 25 lakhs bearing the interest 12% per annum.
No, it is going wrong. Supreme Freightway দেবে না. Resolution হচ্ছে ভুল বলেছো.
This resolution কেটে দে না পুরা. This resolution regarding providing loan to the Supreme Freightway Carriers for an amount of rupees 25 lakhs along with interest at the rate of 12% per annum through its proprietor Deepak Agrawal.
Who has provided you this document?
ये डॉक्यूमेंट आपको किसने दिया है?
राजा मुखर्जी एंड मंजू अग्रवाल, डायरेक्टर.
This document was given to me by Mr. Raja Mukherjee and Mrs. Manju Agarwal, director of the company.
Are the contents of this document true and correct?
Correct.
Manju Agarwal, the directors of the company. Are the documents, are the contents of the document true and correct? Answer yes.
May this be tendered as an exhibit.
D.
See her. But judge's brief of documents to dekha. Kindly come to page 26 of the judge's brief of documents. (26 to 31). Kindly tell my lord, what are these documents?
26 to 31. आप ये डॉक्यूमेंट देखिए 26 to 31 और माय लॉर्ड को बोलिए ये क्या है.
ये मैंने मेल से मेरे एडवोकेट ने निकाला था कि उसकी कहाँ का ऑफिस है, कहाँ का ब्रांच है.
उसका किसका?
सुपर फेड कैरियर.
This is the
सुप्रीम फेड कैरियर.
This is the extract of the mail.
मेल.
This is the extract of the mail.
इंटरनेट से.
Under my instruction, my advocate has taken an extract from the internet regarding the office address of the Supreme Freightway.
Supreme Freightway Carriers.
Freightway Carriers. This is the document.
According to this document, where are the offices of Supreme Freightway Carriers located?
इस डॉक्यूमेंट के मुताबिक सुप्रीम फ्रेटवे कैरियर्स का ऑफिस कहाँ पर है?
अहमदाबाद एंड मुंबई.
At Ahmedabad and Mumbai.
Are the contents of this document true and correct?
Correct.
Yes, true and correct.
Kindly, Lordship, may be tendered as an exhibit.
Have you obtained?
Lordship, he has already
From
stated.
which? क्या बोला?
Internet.
From which internet? आपने निकाला बोला ना? आपने जो इंटरनेट से निकाला, किसके कंप्यूटर से निकाला आपने?
मेरे एडवोकेट ने निकाला, मेरे कंसर्न से निकाला.
My advocate has printed out the said mail on my instruction. थ्री है ना? तीन है, कलेक्टिवली है.
Collectively. Showing you another document at page 32 of the judge's brief of documents. 32 of the judge's brief of documents. Kindly tell my lord, what is this document?
डॉक्यूमेंट को देखिए और माय लॉर्ड को बोलिए ये क्या है।
ये बैंक स्टेटमेंट है, मैंने जब उसको नेफ्ट किया था उसका स्टेटमेंट है, सुप्रीम कोर्ट।
This is the bank statement of the money which was given to me by the Supreme given by me to Supreme Transport Solutions Private Limited. This is the copy of
through NEFT.
No, it is, you're saying it wrong. He has said Supreme Freightway Carriers. Number 2. Kindly show him.
This is the bank statement. The bank statement of the money which was given by me to the Supreme Freightway Carriers.
Yeah, give. ये किसका बैंक स्टेटमेंट है?
ये ओवरसीयर का।
This is the bank statement of Overseas Enterprises Private Limited, maintained in the UCO Bank, Kolkata main branch, main retail, showing that an amount of rupees 25 lakhs has been transferred in the said account on 22nd of June 2016. This is the
23rd June. That should be the second number. The first
23rd June. 23rd June 2016.
From where have you received this document?
आपको ये डॉक्यूमेंट कहाँ से मिला?
ये मेरे को बैंक से मिला।
I obtained this document from the bank.
Why is there no sign or seal from the bank?
Not necessary.
Are the contents of this document true and correct?
क्या इस डॉक्यूमेंट में जो कुछ भी लिखा हुआ है वो सच और सही है? Yes, true and correct.
Lordship, this may be marked as an exhibit.
E.
I'm showing you another document appearing at page appearing at page 33 of the judge's brief of documents. Kindly tell my lord, what is this document?
ये डॉक्यूमेंट क्या है माय लॉर्ड को बोलिए।
ये डॉक्यूमेंट उसको मैंने 25 लाख रुपया दिया, उसका कंफर्मेशन।
This is the
confirmed by party.
This is the confirmation letter given by Supreme Private Carriers after receiving the amount that is 25 lakh.
Who has given this document?
ये डॉक्यूमेंट किसने दिया है?
ये दीपक अग्रवाल ने दिया, सुप्रीम फ्रेट कैरियर्स।
This document was provided by Mr. Deepak Agarwal from Supreme Freightway Carriers.
Is there any signature on this document?
क्या इस डॉक्यूमेंट में कोई सिग्नेचर है?
सिग्नेचर दीपक अग्रवाल का।
Yes, there is a signature of Mr. Deepak Agarwal.
Can you encircle it?
आप सिग्नेचर को ब्लू पेंसिल से एनसर्कल कीजिए।
पूरा कर दूं?
The witness encircled the signature of Mr. Deepak Agarwal appearing on the same document.
Do you recognize the signature of Deepak Agarwal?
क्या आप उनके सिग्नेचर को पहचानते हैं, जानते हैं? Yes, I know his signature.
Was this document signed in front of you?
क्या ये डॉक्यूमेंट आपके सामने साइन किया गया?
ना, मेरे सामने नहीं किया था।
No, it was not signed in front of me or in presence of me.
Are the contents of this document true and correct?
क्या इस डॉक्यूमेंट का जो कंटेंट्स है, जो लिखा हुआ है, वो सच और सही है?
सच।
Yes, true and correct.
Lordship, this may be marked as an exhibit.
F.
Kindly come to page 34 to 52 of the judge's brief of documents. It should be 51, I think. Not 50. No, no.
उसको एक काम
No, no, no. Not 50.
कल्याण पीछे में टेप लगाओ ना तो उड़ जाएगा जजमेंट
36. 34 to 36. 36. Lordship, this is collectively, I'll have to show in two different parts. 34 to 36. What are these documents?
ये TDS सर्टिफिकेट है उसने जो
these are the TDS certificates. बोलिए.
ये इनकम टैक्स में जो उसने मेरे ब्याह में इंटरेस्ट के अगेंस्ट में जो TDS काटा वो जमा दिया
के बिहाफ में मुझे समझ नहीं आया.
माने ओवरसीयर के ब्याह में जो उसने इंटरेस्ट दिया है उसका TDS काटा है उसका
उसने किसने?
This document shows that the interest paid by the defendant to the plaintiff against which the TDS has been deposited. That is that?
Yes. Against the interest component.
That's right. Interest, TDS upon the interest.
Lordship. From where have you received this document?
आपको ये डॉक्यूमेंट कहाँ से मिला?
ये मैंने इनकम टैक्स का सर्वर से निकाला
I have downloaded this document. I have downloaded and taken a printed out this document from the
Website of
website
the
of the
Income Tax Department.
Are the contents of this document true and correct?
Correct.
Yes.
Lordship, this may be tendered.
Exhibit-
Lordship, but there are other documents along with this.
Exhibit G collective. What are the documents?
Lordship, bank statements. Bank statements.
Along
I'll be
with
showing-
this?
Yes, Lordship.
No. The page number which you have mentioned.
Yes, I have mentioned only for the TDS. Thereafter, I'll be showing the bank statement.
TDS is page number
Is 34 to 36.
34 and 36 only.
I'm showing you another some more documents. Kindly tell my lord what are these
The
documents?
page number?
Appearing from page 33 to page 52 of the judge's brief of documents. To page 52 of the judge's brief of documents. What a double হয়ে গেছে actually. 36 হয়ে গেছে, that is one part. আর 37 থেকে যে 52 আছে সেটা আলাদা part. 33 to 36, তারপর 37 to 52.
আগেরটা কি মার্ক হবে ওটা?
ওটা একসাথে মার্ক হবে, collectively হবে. 34 to 36.
34 to 36 হলো। এবার 33 থেকে 50
না 33 না 37 থেকে 52.
57 থেকে ओके। ये देखो। ये डॉक्यूमेंट क्या है माय लॉर्ड को बोलिए।
ये बैंक स्टेटमेंट है ओवरश्योर एंटरप्राइज का।
These are the bank statement of oversure enterprise. Bank statements of oversure. किस period?
What does this bank statement represent?
25/10 से 16 से आपका 25/2/2019
This is a bank statement of oversure enterprise from 25th October 2016 to 25th February 2019.
What do these bank statements?
Yes.
What do these bank statements reflect?
ये बैंक स्टेटमेंट क्या दर्शाता है?
ये जो उसका जो इंटरेस्ट आया हुआ वो दिख रहा है इसमें।
On the statements of the document, the interest which has been provided to us is shown, is reflected.
Where have you got these documents from?
आपको ये डॉक्यूमेंट्स कहाँ से मिला?
बैंक से मिला।
I got this document from the bank.
From which bank?
कौन से बैंक से मिला?
यूको बैंक मेन ब्रांच।
From UCO Bank main
Are the
branch.
contents of this document true and correct?
Yeah, this
Correct.
document- Yes, true and correct.
Which may they be tendered together as an exhibit?
क्या था एग्जिबिट? कलेक्टिवली कर दें।
Kindly come to page 53 of the judge's brief of documents and tell my lord what is this document?
ये डॉक्यूमेंट देखिए और माय लॉर्ड को बोलिए ये क्या है?
ये सुप्रीम कैरियर का चेक है वो उन्होंने मेरे को चेक दिया था कि आप यदि माने
This is a check given by the Supreme
Freightway carriers.
carriers to us. बोलिए.
तो उन्होंने कहा था कि आप इसको माने मैं चेंज कर दूंगा, लेकिन उन्होंने चेंज किया नहीं.
They told us that they will change the check, but they didn't.
Why would they change the check?
क्यों वो लोग ये चेक चेंज करना चाहते थे?
ये टर्म्स ऑफ था 120 दिन के बाद इंटरेस्ट वाला चेक देने का.
There were terms that they would give the principal amount back with an interest of 12%. बोलिए.
ये प्रिंसिपल अमाउंट का चेक है.
They had given us this is a check of only the principal amount.
Did you deposit this check with the bank?
आपने क्या ये चेक बैंक में जमा किया था?
मैंने ये चेक जमा किया था बैंक में.
Yes, I have deposited this check on the bank.
और बैंक से रिटर्न आया.
कौन से बैंक में जमा किया था?
यूको बैंक मेन ब्रांच.
Wait a check now. Not that check.
I have deposited this check at the UCO branch. बोलिए.
मेन ब्रांच.
UCO बैंक मेन ब्रांच. रिटर्न हुआ कुछ कह रहे थे.
रिटर्न का ये मेमो है.
ওনাকি পেজ 53 দেখছেন তো? পেজ 53 দেখছেন তো নাকি
উনি 55 এ দেখছেন, দেখে
55 এ তো কোয়েশ্চেনই করিনি আমি. আপনি কেন চেঞ্জ করতে দিয়েছেন ওনাকে? Show him only page 53. I said judge's brief of documents page 53 only.
What was which document is shown? Which document is shown? Prior, before answer? 53? He is giving the answer to
a different paper altogether.
आप जो है ना, जो पेज आपको दिखाते हैं उसी में रहिए, पीछे वाला पेज में मत जाइए. आप 53 नंबर का पेज देखिए, वो क्या है?
ये डॉक्यूमेंट क्या है बोलिए.
वो उन्होंने मेरे को चेक दिया था, वो है प्रिंसिपल अमाउंट का.
This is a check of the principal amount which was given to us by them, that is Supreme Freightway Carriers.
What is the date of the check?
चेक का डेट क्या है?
1/4/2019.
The check is dated 1st April 2019.
Yes.
Do you have the original copy of this check?
क्या आपके पास इस चेक का ओरिजिनल कॉपी है?
हाँ है.
Yes.
नहीं है, नहीं है. इसका नहीं है. बाद में मेरे को दूसरा
पेज
चेक
में नहीं है
दिया.
सर. No, I do not.
इसका चेक नहीं है.
No, I do not have the original of this check. Original copy of this check.
Yes.
Are the contents of this check true and correct?
इस चेक का जो contents है वो true and correct है. Yes.
এর আগে একটা question হবে ঢুকবে. Is this check signed by who has signed this check?
चेक को किसने साइन किया है?
दीपक अग्रवाल.
The check
Supreme Freight Carrier.
The check was signed by Mr. Deepak Agarwal from Supreme Freightway Carriers.
Can you encircle his signature?
उनके सिग्नेचर को एनसर्कल कीजिए ब्लू. The witness signed the signature of Mr. Deepak Agarwal appearing on the.
This may be tendered as exhibit.
Xerox.
Other
Put the question. आपका ओरिजिनल कहाँ गया? आपके पास जेरॉक्स है. ओरिजिनल कहाँ गया इसका?
कहाँ पर है?
ओरिजिनल उनके पास है. मेरे
उनके पास किनके पास?
किनके पास?
ओरिजिनल ये उन्होंने चेंज करके ये चेक दिया दोबारा मेरे को.
Now he's talking.
चेक का ओरिजिनल किसके पास है?
ओरिजिनल तो मैंने पार्टी को दे दिया. पार्टी ने मेरे को नया चेक इशू करके दिया.
Original check has been returned to the defendant, and after receipt of the original check, the defendant has issued a fresh new check.
Applies document.
Yes.
Are the contents of this document true and correct?
Which one?
This check.
Yes.
No, not needed. Lordship, this may be marked as an exhibit.
X for identification. Yes, next.
I'm showing you another document appearing at page 54 to 56 of the judge's brief of documents. Kindly tell my lord, what are these documents?
डॉक्यूमेंट को देखिए और माइनर को बोलिए ये क्या है।
ये उसका चेक है। मैंने उसको यूको बैंक
आप उसका मत बोलिए, पार्टी का नाम बोलिए, किसने चेक दिया, किसके नाम पे दिया।
कैरियर दीपक अग्रवाल।
दिस इज द चेक इशूड बाय, कौन इशू किया?
सुप्रीम फेट कैरियर।
सुप्रीम फ्रेटवेट कैरियर्स।
इन फेवर ऑफ, किसके फेवर में?
ओवरश्योर एंटरप्राइज प्राइवेट लिमिटेड।
ओवरश्योर इंटरप्राइजेस प्राइवेट लिमिटेड।
कितने अमाउंट का है?
25 लाख, 25 लाख।
डेट क्या है?
डेट है 1/12/2019।
कौन सा बैंक का है?
HDFC बैंक।
HDFC बैंक।
यस।
अहमदाबाद।
अहमदाबाद।
Who has signed this check?
किसने साइन किया है ये चेक को?
दीपक अग्रवाल।
The check was signed by Mr. Deepak Agarwal.
Did you deposit this check to the bank?
आपने क्या इस चेक को बैंक में डिपॉजिट किया था?
यूको बैंक में डिपॉजिट किया था मैंने।
Yes, I have deposited this check on UCO branch, UCO bank.
Why is the check with you if you have deposited it with?
What has happened?
What has happened? After
आपने
you have
डिपॉजिट किया,
deposited,
उसके बाद क्या हुआ?
चेक रिटर्न हो गया, फंड नहीं है बोल के।
The check was returned.
The check was dishonored as there was no available fund, a sufficient fund for the.
With the reason insufficient fund. Yes.
third page था देखा?
Third page.
Third page था।
Yes.
What is this document?
बैंक स्टेटमेंट, चेक रिटर्न हुआ उसका।
एक थर्ड पेज बोल रहे।
Page number?
Page number 56 of the judge's brief of documents, which is together along.
उसी में है ना?
उसी में।
1 to कितना बोला था? कंटिन्यूअस है। Yes.
54 to 56.
क्या है ये डॉक्यूमेंट बोलिए?
बैंक स्टेटमेंट है, यूको बैंक का।
This is
तो क्या डॉक्यूमेंट है बताइए जल्दी, अब टाइम नहीं है यहाँ पे।
चेक रिटर्न हुआ उसका बैंक स्टेटमेंट है।
हाँ?
सुप्रीम फेट कैरियर का जो चेक रिटर्न हुआ,
हाँ।
हमारा बैंक का स्टेटमेंट है, यूको बैंक का।
This is the statement of account of my bank, which shows that the check issued by the defendant was dishonored.
Where have you received this document?
आपको ये डॉक्यूमेंट कैसे मिला?
बैंक से ले।
I got this document from the bank.
Are the contents of the document true and correct?
The document. Yes, true and correct.
Or should maybe tendered as an evidence?
The check को exhibit करो. First check. Exhibit G.
Lordship, the first check was X marked for identification.
No, this one.
Achha, this one.
H. Collectively करना।
Kindly come to page 57 to 84 of the judge's brief of documents.
They went to 84.
Yeah. What are these documents?
ये डॉक्यूमेंट देखिए और माइलॉट को बोलिए ये क्या है।
ये मेरे एडवोकेट से मैंने उनको क्लाइंट नोटिस भेजा था, उसके एड्रेस पे।
This is the notice which was sent by me to the defendant to my advocate by my advocate.
Original. These were the original documents which.
So why you are not showing the original to him? Why you are showing the Xerox copy from the judge's brief?
I'm showing you these documents. Kindly tell my lord, what are these documents which are appearing from page 57 to 84 of the judge's brief of documents? ये आगे तक क्वेश्चन तक केटे देखो।
ये डॉक्यूमेंट देखिए और माइलॉट को बोलिए ये डॉक्यूमेंट क्या है।
ये मेरे एडवोकेट से मैंने उनको नोटिस भेजा था, Demand notice.
These are the legal notice sent by the plaintiff to the defendant, calling upon the defendant for payment of the amount.
Through the advocate. It's through the advocate notice. Lordship, it's advocate.
Legal notice. Yes. What is the date of the notice?
तारीख क्या है?
27/1/2020.
The notice is dated 27 January 2020.
How it was sent to the defendant?
कैसे भेजा गया था defendant को?
अब मैंने उनको स्पीड पोस्ट से भेजा था.
The notices were sent by speed post.
उनको मिला था?
उनको एक नंबर मिला है खाली और 3 एड्रेस गलत बता रहे. एक एड्रेस गलत है.
In one address it was received by the defendant, and other 2 address it was written unserved. Yes.
Are the contents of the documents true and correct?
This document, yes, true and correct.
This may be marked as an exhibit.
The legal notice page number?
Lordship, page number 57 to 84.
ठीक है, exhibit कर लो.
Exhibit I.
I collective. Yes, next.
I'm showing you documents appearing from page 85 to 89 of the judge's brief of documents. Kindly tell my lord what are these documents.
ये document क्या है, my lord को बोलिए.
मैंने मेल से उनको डिमांड नोटिस भेजा था.
We also sent the demand notice by email. We also sent the demand notice by email to the defendant, that is Supreme Freightway Carriers. This is a copy of that mail.
Who had sent this mail?
किसने भेजा था ये mail?
मेल इंटरनेट से भेजा था.
किसने भेजा था?
मेरे एडवोकेट ने.
This mail was mailed by my advocate.
When was this mail sent?
कब भेजा गया था? तारीख बताइए.
24 जुलाई 2020.
The mail was sent on 24 July 2020 at 5:41 p.m.
To whom was this mail sent?
किसको भेजा गया था ये mail?
The Supreme Freight Carrier Deepak Agarwal.
The email was sent to Mr. Deepak Agarwal of Supreme Freight Carriers.
Are the contents of this document true and correct?
Correct.
Yes, true and correct.
Bishop, this may be marked as an exhibit.
Yes, my lord. Collectively?
Yeah, collectively. Yes, next.
Showing you another document. दिए दाओ ना. दिए दाओ. Okay, दिए दाओ. ताता होगा. Kindly tell my lord what are these documents which are appearing at page 90 to 103 of the judge's brief of documents.
ये document क्या है, my lord को बोलिए.
मैंने एक क्लाइंट भेजा था डिमांड नोटिस का मेरे एडवोकेट से.
These are the demand notice sent by me to the defendant, Mr. Deepak Agarwal, sole proprietor of Supreme Freightway Carriers.
Who had sent these notices?
किसने भेजा था ये notices?
ये मैंने भेजा था. मेरे एडवोकेट के थ्रू.
These notices were sent by me through my advocate or by my advocate.
When was this notice sent?
कब भेजा गया था?
7/1/2021.
This notice was sent on 7 January 2021.
What was the amount that was demanded by you By way of this notice?
इस नोटिस के चलते आपने कितने अमाउंट का
मैंने
पैसा अपने रिफंड मांगा था?
मैंने
Demand
25
किया था।
लाख प्लस इंटरेस्ट 31 लाख रुपया उससे रिफंड मांगा था 41 लाख
Along with the principal and the interest, I demanded an amount of rupees 31 lakh from him. That is Mr. Deepak Agarwal.
Okay, last page ta dekhan. Kindly show the last page of this demand notice. Page 83. Jodi judges before documents ta dekhan.
ওইটা उसमें ओरिजिनल है ना रिसिप्ट। आपने नोटिस कैसे भेजे?
नोटिस
ये नोटिस आपने कैसे भेजे थे उनको? ये जो नोटिस आपने भेजे थे ना?
कोरियर से भेजे थे।
By courier. I have sent this notice to Mr. Agarwal by courier.
Have they received these notices?
क्या उन्होंने रिसीव किया था ये नोटिस?
उन्होंने रिसीव नहीं किया था।
No, this notice was not received by him.
Yes.
Are the contents of the document true and correct?
83 में जो डॉक्यूमेंट देख रहे हैं आप, इसकी ये क्या सच और सही है?
सही।
Yes, true and correct.
So this may be marked as an exhibit.
आपने बोला ना नोटिस को नहीं मिला, तो फिर नोटिस का हुआ क्या? आपके पास वापस आया? You persons are bringing the witness without tutoring.
Worship,
You're not taking the class of the witness in your chamber.
he's too nervous.
नोटिस पर वापस आया है ये।
माइक में बोलिए आप।
ये नोटिस वापस आया है ये।
कहाँ से?
हाँ?
The notice has written unserved to me.
Yes. कहाँ से आया?
अहमदाबाद से। अहमदाबाद और मुंबई से।
From Ahmedabad and Mumbai.
This may be marked as
Exhibit करना. Collectively. Yes, next.
kindly.
How many documents are there? Many documents?
No, Lordship, 6 documents.
Because my other matter is fixed.
6.
Come on the next day. Come with ready.
Okay. Now we want to get ready.
So and so appearing for the plaintiff. Plaintiff witness is present. During the examination in chief of the evidence of the plaintiff witness, documents were exhibited, being exhibit A to exhibit K. Due to paucity of time, examination chief could not be completed. Accordingly, examination chief is deferred. Police, please the matter on. Give the date. क्या करेगा? नहीं है कोई 345 में है? कोई 345 में है?
कब? कभी दिच्छो? Okay.
16th April at 3:45 for further examination on the plaintiff witness.
Obliged, Lordship.
Next.
Commercial item number 18.
Lordship, only if the The judge's brief and the evidence be recorded.
The counsel for the
Filed in court.
plaintiff has filed affidavit examination in chief of affidavit of evidence and the judge's brief of document. Let the same be proceeded to court.
I'm just telling her that it would have been better if she had declared her own witness hostile. Then could have asked the right questions because
That's why I'm asking.
They were telling us that.
At times.
You take the certified copy and give it to the director. Your witness.
I have to do that.
Yes, next.
This is that matter, my lord, where there was in a application for revocation, my lord, of leave under section 92 and my lord.
Achha.
Well, I had more or less finished on the facts. Was just give a small recap, 5 minutes, my lord, because the process of collecting money, you know. And whoever is coming into the room is asking me till 4:30, then we can leave. So, my lord, I have a lot of responsibility on myself today.
If you continue, then you tell.
On the clause that if I continue till 4:30, they will treat me properly. But what I had submitted, my lord, first point was the easier points. I'm just taking it, my lord. First point was that no leave under clause 12 taken. I had pointed out that the office was within, and I had read, my lord, section 92, which says any part. I'll support it with judgments, but I'm just saying on the facts. Then, my lord, I had specifically shown to your lordship from the deed, my lord, clauses which provided for giving grants to the poor, then running of dharmashalas. So I had shown that the object was as I was saying, my lord, dharmashalas and other works which are public in nature. Then, my lord, my learned friend had taken the point that you will have to go through the deed and there is no pleading in the plaint that it is a public charitable trust. But I have specifically shown in the plaint the specific averments that it was charitable in nature. That's clause section paragraph 9, and I've shown that.
Clause 9.
Clause 9. Then, my lord, I had taken a point that I should be allowed to read his case for revocation, and I will only answer that which he has made in his application, because his application was primarily based on the question of fraud. I'd placed those paragraphs, and I said it's a question of trial. You cannot say it's fraud or not fraud, whatever it is. It's a question of trial. Next, I also said, my lord, whether it's a public charitable trust or not, at this moment, it's a prima facie finding of your lordship. From the deed, we can safely conclude that it had some public and charitable works in it. If they want to, they can obviously, my lord, take the point and then, my lord, quoting, my lord, to a certain extent, Justice Shonji Banerjee, as his lordship then was, said you can add more flesh at the time of the trial to prove your point. At this point, because they're restricted only to my plaint. So therefore, my lord, this was another point which I had dealt with. Then, my lord, I also pointed out that there is no application for revocation of the plaint. It's only restricted to section 92, and that is it. So cause of action, whatever I have pleaded, my lord, that may not be
the total cause.
Yes. It has to be restricted to 92 pleadings. Then, my lord, I had also made a submission before your lordship, because I've gone through the cases which Mr. Ghosh had referred to. I had specifically pointed out and requested your lordship to take note of that there were no prayers which were personal in nature for the plaintiffs. They never said that substitute me as the trustee or give this property to me. Rather, the plaintiff said, you do not work, make a scheme of the court and the court will decide. So I said that this in itself brings out the flavor of the sections and the subsections of section 92. Now, my lord, these are the points which I met. Now, one thing, my lord, will kindly see, my lord, in my plaint, if your lordship kindly takes the plaint, my lord, plaint or the petition, my lord, GA1, whichever.
Yes, it is here.
My lord kindly sees the case is that there was a trust which was created pursuant to a decree of this Honorable High Court. And thereafter, my lord, the family members who were the litigants in the partition suit from where this trust was created had also formulated a scheme subsequently, because there was no provision for appointment of any further trustees. So an instrument was prepared. Now that instrument, your lordship will kindly find, that starts at page 32 onwards. Two things your lordship will kindly note, and that is to be noted, that they are signatories. The person who has come before your lordship challenge saying that it should be revoked on the ground of that it is not public in nature, they have themselves signed this document. Your lordship will kindly see, very interesting, I'll only show one clause, my lord. Kindly takes page 40. Income tax code.
Yes.
80G5. Well, I will kindly see Roman 9, small Roman 4 at page 40.
Page 40.
But your lordship is with GA1.
Of the GA.
Mine has GA2, I believe. I'm sorry. Recap in the first point.
Yes, GA.
And kindly takes page 40, my lord.
Yes.
The trustees will always act in such a way the trust estate always retains the status of such a trust to which provisions of 80G and 12A of the Income Tax Act and provisions of Money Laundering Act shall apply. But I am on 80G.
Page 40.
40, my lord.
The trustees are always in such way
that the trust estate always retains the status of such a trust to which provisions of 80G and 12A. So, my lord, I am on 80G and 12A. So the trust decides that it has a status which provides them this 80G, my lord, protection, or rather the assessees who make donations will have an exemption. And what are these kinds of, my lord, bodies? These are all public charitable trusts. My lord, kindly sees, my lord, 80G to them. C no G. G.
Income tax act.
ऐसा कुछ
Income tax यहाँ नहीं है.
We have a copy.
Yes.
And it kindly comes to (80G) subsection 5.
Yes.
This section applies to donations to institutions or funds referred to in subclause 4 of clause A of subsection 2, established in India for a charitable purpose, and if it fulfills the following conditions. So, my lord, when they mention 80G, my lord, they fall under this clause. If your lordship reads it with, my lord, section 80G, subsection 2 and subsection small 4. This talks about the various bodies to which 80G applies. It reads as any other fund or any institution to which this section applies.
Any other fund or any institution?
To which this section applies.
Yes.
Application. Like the instrument it is instrument. Now, my lord, what I am on is kindly seize this document, my lord.
আমি জিজ্ঞেস করে নিচ্ছি
এই তো এটা সেকেন্ড যে অ্যাডেন্ডামটা সেটার ক্লোজ
অ্যাডেন্ডামের
Oh, yeah. I mean, I'll also show 12A, my lord, at one go, my lord, may I just show. Yes, my conditions for applicability of sections 11 and 12. Your lordship had seen 80G 5.1 spoke about 11 and 12. And this is the condition.
Yes.
12A2.
Provisions of 11 and 12.
The provisions of section 11 and 12 shall not apply in relation to the income of any trust or institution unless the following conditions are fulfilled.
Correct.
Now, my lord will first come to first takes section 12, subsection 2. It says provisions of section 11 and 12 shall not apply. Now, your lordship kindly sees 12.2. The value of any has your lordship got it?
Yes.
The value of any service,
yes,
being medical, educational, made available in charitable or religious trust,
yes,
running a hospital or medical institution or education to any person referred in clause A or clause B or C, shall be deemed to be income of such trust or institution derived from property held under trust wholly for charitable or religious purpose.
Correct.
During the previous year in which such service are so provided.
Correct.
So, my lord, here I have shown that this was also for educational purpose. Pathshala.
Pathshala is there. No, it is there, but you are running the Pathshala.
Yes, it is there. Again, my lord, may I just now point out, my lord, this is the question. Absolutely, my lord, they will be in a position to run their evidence. I am not on that, what I am running. I am only on this provision, my lord. This document has been signed by the person who has brought an application before your lordship. Now, that document has not yet been challenged. So, my lord, it tantamounts to an admission that this is a charitable organization. They have signed this document. My lord, kindly see page 41. Chief Kumar to the mission. Kindly see the signatures at page 41. All the defendants are signed on the right, my lord. All the defendants বলছি তো হ্যাঁ ঠিক আছে ললিত শিব চেতন ঋষভ ঋষভ
Chetan Roya. BK Roya, who is the BK Roya?
BK is my lord. Bimal Kumar Ruya, that's the plaintiff.
Plaintiff one.
Topmost is Shiv Kumar Ruya.
Correct.
But we'll see the parties, my lord. I think that will explain it.
Yes, I am saying because Shiv Kumar Roya is the D2.
Yes.
Correct.
Yes, my lord.
And second is whose signature? Shiv Kumar.
This first is Shiv Kumar. Second is my lord.
D2.
Shiv Kumar.
Second is we don't know, and BK Ruya plaintiff one.
Must be one of the plaintiffs, my lord. I'll just see, my lord. Just give me a second, my lord.
Then Rishabh.
Lolit hobe.
Rishabh is D4.
D4. He's there. Chetan is there, my lord.
Chetan, where is the Chetan?
The last one, it seems like it's
Last one is the
Chetan.
Chetan. D3. So D1.
Second one looks like Lalit. Well, I'm not too sure. But the point is, this document, the signature thereof, subject to correction, has not been disputed. That is what I'm on.
So D1 is not there.
You want to take it?
Where is the name of the fund?
Lalit. Well, second was Lalit.
Second is not Lalit. Lalit?
Well, I'll just give you a moment, Malat.
শিব ললিত বিকে এটা হচ্ছে ঋষভ আর এটা চেতন
এখান থেকে ছবি থেকে দেখি না দেখি এটা কি
শিব
এটা
নবীন
মানে kindly takes page 42 মানে first is এটা শিব তো না বিকে এটা
শিব
না না এটা Shiv. First is Shiv. Second is Lalit. Third is Chetan at page 42. Fourth is এটা Rishi naki.
BK Ruya.
Rishabh. On page 42.
Page 42.
Last one, Rishabh.
Last one, Rishabh. And 43, BK. Yes.
So, Malat, the point remains, they are not disputing the signature nor the document. They are saying it cannot be a part of the trust deed. What I've understood from my learned friend's submission. Well, whatever it is, Malat, it is a document by which, Malat, trustees, and as a matter of fact, they were also appointed. Now, in that document, it refers to 80G and 12A. So, under these circumstances, I say that they've already admitted that this is a charitable trust, carrying out charitable purpose. Or, Malat, they would have had to give an explanation. I'm not on that. I'm only on the deed because I have to show your lordship from the deed. I'm showing from the deed and the addendum from which they have been appointed that this is what it says. Now, at this stage, at the point of asking for revocation, what will be the impression in your lordship's mind? That is what I have to try and ascertain that no, this clearly shows that even if you want to prove, then you have to prove it, that it's not a charitable organization, charitable trust. Then, Malat, now your lordship will kindly take the judgments which my learned friend has shown, and then I will place my judgments. First, let me deal with his judgments.
So J1 is yours.
J1 is my application for receiver and injunction.
Correct.
I'll come to that because I'll be moving it after this, Malat.
And J3 is the revocation.
J3 is the revocation.
Revocation of section 92.
Malat, may I just, yes, Malat, absolutely, Malat, may I just once kindly, Malat, show the prayers, Malat. Right. কি করবো 90, Malat, kindly takes page 10. Revoking leave under section 92(1). And, Malat, vacating and dismissing the suit. Then vacating of the ad interim order and stay. That is what has been played for. And I had shown, my lord, in their pleadings, my lord, they had said, my lord, paragraph 12, my lord, kindly, I'll just read it out to your lordship. Leave, if any, granted under section 92 in the institution of the institute is thus liable to be revoked and instant suit is liable to be dismissed. This is most so since no leave under clause 12 has been sought or obtained, and by unduly applying under section 92, the plaintiff has illegally bypassed. So the case of my learned friend is that by getting leave under section 92, I was not required to take leave under clause 12. This is their pleading, my lord.
No, their case in terms of this, they wanted, yes, 92.
This couldn't be a 92. You should have made a suit.
You have bypassed the 12. You have not obtained the 12.
Yes, so I bypassed.
Bypassed or you are not? Yes.
Bypassed.
Take that also.
If it's bypass means, my lord, I have taken another route. Eastern Metropolitan Bypass. I have reached the destination by a separate route. It's not mandatory. That's why I said, what has been pleaded, I am on that. I will meet his case, even if it's not pleaded, my lord, that whether, if 92 is given, whether I still need clause 12 leave. Now, my lord, after the let's seize the CPC once more, my lord. Section 92. The 92(1). Let's start from the middle, my lord. Leave of the court may institute a suit, if your lordship has gone there. Whether contentious or not in the principal civil court of original jurisdiction or in any other court imparted in that way by the state government within the local limits of whose jurisdiction the whole or any part of the subject matter of the trust is situated. Now, my lord, let us take this situation, my lord. I take leave under section 92. My office is within. Now, my lord, I have not sought for any, my lord, prayer on the land specifically. Clause 12 leave is for the cause of action, or, my lord, it would be for the land, if there are parts of land within and outside partitions, basically. But, my lord, 92 leave is something, my lord, which is special for a public charity. Because once I take leave under 92, it only provides that part or whole of the subject matter of trust is within.
Correct. That's why. So some of the cause of action should be within the court.
And some is outside. Correct. My main registered office is within. I've shown that on the last occasion, my lord.
You have shown.
The trust is functioning from that office. Okay. There are also properties of Clive Road and other places, my lord. Those are within. The pleadings are there. My lord, the point is, my lord, are we today only dealing with the property where I have found that they are not acting in terms of the trust, or we are dealing with the entire trust and all its properties? I say all its properties because my prayer is for a scheme. And my lord will not find any prayer which, my lord, relates to any title or possession or interest in a landed property, because the trust deed.
So what injunction you have prayed for?
That they should not function or deal with the trust properties. My main prayer is for their removal, but I have said do not deal with the properties of the trust. That is what I have sought for. And I will also seek for receiver for the accounts. And it is not personal in nature. I am not asking, I am not getting any benefit out of it. I am on the only sole reasoning that you provide the object, or rather run it on the object of the trust. Now, my lord, kindly appreciates. I'm on the 92 and 12, my lord. Let us say I take the leave under 92. My lord, on what will I take a leave for clause 12 on? Because I have come before your lordship under section 92. It will be the same leave. It encompasses the entire thing. It does not remain a suit for land or a separate cause of action. This is a cause of action under the CPC.
What is the stage of the suit?
No written statement filed.
Filed.
Entered appearance, no written statement filed.
Writ of summons served.
Entered appearance, my lord. Writ of summons not served.
Writ of summons service হয় বাস চেক করে দাও
দেখো আমি তো জানি হয়েছে
সার্ভিস করেছো এর অ্যাপিয়ারেন্স করলে হয় না সামানটা সব করতে হবে হয়েছে কিনা দেখে দেখিয়ে দাও
I don't know. I'm not to do that the procedure, my lord, but if you do not, if you are not served with a writ of summons, I don't know whether you can enter appearance. Enter appearance in a petition is a separate thing.
They filed an application.
There's an application and the suit below. Application I have entered appearance.
No, that's what I'm on. Whether it's we have, as far as my instruction goes, they've entered appearance as suit. That's what they're saying. Yes, well, served on CS service. Well, I've got the report. Served on 23rd December 2022. On defendant number 4 for self and on behalf of defendant number 3 and also upon defendant number 2. As per stamped endorsed on the original writ of summons. And the sheriff has given a report. This is the report of the sheriff. If your lordship wants, I can show your lordship. And my lord, with regard to expect to the chinta nahi. And there was undelivered packet marked as unclaimed. And postal letter has been received for defendant number 1. Saying that the defendant number 1 could not be served through the concerned court due to want of proper instruction. That's it. Whatever, that is the report. I cannot correct the sheriff. And that's what has been said. I'm reading it. So, Mala 2, 3, 4 has been served.
How to give the instruction to the postal authority also?
What instruction will I do?
Mala, I will. Your lordship queried. I am saying that yes, it has been served.
Okay.
I've got a sheriff report.
Okay.
If they want to challenge the sheriff, to let them. I don't have a problem. Nowadays, everything can be done. You can challenge anything. So, as I was saying, my lord, that is why I said, my lord, section 92 is a specific leave. Once that is granted, what does it show? That your lordships have given leave to institute a suit for subject matters within and outside. My lord, what are these subject matters? The properties of the trust. Then where is the question of leave under clause 12?
Property of the trust, that is the main property of the trust outside.
Within and outside, my lord. Kindly reads it again, my lord. Within the local limit of whose jurisdiction?
At 90 says that's in their contention is that
because my lord, they are limiting
trust property outside.
No, my lord. Why they are saying this? The main challenge or the main dispute where it arose from, that property was outside, you know? That Joshidi property is outside. But I have not come here for Joshidi property only. In my plain first paragraph, I have said that this the office of the trust is within. That was last year, and even my lord, para 32, I have also said subject matter trust includes the trust property situated 28 Clive Road within the jurisdiction and also includes certain property of Joshidi Bajar. They have got outside the jurisdiction.
Where?
Para 32 of Plaint. Para 1 and para 32.
Yes.
My lord, we had specifically shown it to your lordship, my lord.
Yes.
So once I am within the encompass of section 92, my lord, I say section 12, the clause 12 leave is not required anymore. It is not required because it's a specific suit under section 92.
Okay.
That's now, my lord, kindly sees, because the original side rules will not provide for it. If it was something in which both the fields were acting, then the original side rules will prevail. Here, my lord, for public charities, my lord, this is the only place where leave is required. Now, my lord, may I just take your lordship to the judgments which have been referred to by Mr. Ghosh. আমি লাস্টে দেখো বলেছি তোরগুলোকে ডিস্টিংগুইশ করো তারপর আমি দেখো দাও মালের কাছে আছে তোর দিয়েছিস কত মালেট ফার্স্ট মালেট মুল্লা গুলাম আলী দেখিছি তো মুল্লা গুলাম আলী no this is not sorry মালেট no sorry I'm getting it wrong এটা না নেই sorry Malat kindly sees AIR 1983 Calcutta 420. Apt. This is Justice Murari Mohan Datta and Justice Mukherjee.
Yes.
This is for suit for land. Malat here, Malat. Man will kindly take, I do not do this, but kindly takes the head note for once, Malat. Malat just after where your lordship will find it is in bold. The question whether out of, has your lordship, several reliefs in the plain, the claim for the grant of particular relief which does not relate to title to or possession, contra management lands or belonging other immovable property is the primary object of the suit or not has to be decided by applying the test whether such relief claimed to be the primary object of the suit can be granted to the plaintiff without the necessity of any adjudication on the question of title to any land or building or other immovable property or possession, control or management thereof. If the relief stands the test, the suit will not be a suit for the land or other immovable property within the meaning of clause 12. So this was the scope of the suit. There was a point of section 92 also involved in this judgment. But your lordship will kindly see, kindly comes to paragraph 15. The first paragraph 8, Malat, sorry, para 8.
Yes.
We are therefore concerned with the question as to whether the learned judge was justified in granting leave under clause 12 of the latest patent and section 90 of CPC. So far as the leave under section 92 is concerned, it will be stated here that such and such learned counsel appearing on behalf of the plaintiffs concedes that as no relief in terms of section 92 has been paid in the suit is not a suit under section 92. So, Malat, it did not fall as a question whether 92 coupled with it 12 is required or not. It straight away went into the question of clause 12, Malat. Your lordship will kindly find it at paragraph 15.
Yes.
Malat, as a matter of fact, I'll be relying on this part. Kindly sees, in our opinion, the question whether out of several in the plain, the claim for the grant of a particular relief which does not relate to title to or possession, control or management of land or buildings or other immovable property is the primary object of the suit or not has to be decided by applying the test. Whether such relief claimed to be the primary object of the suit can be granted the reliefs without the necessity of any adjudication on the question of title to any land or buildings or immovable property or possession, control or management thereof. If the relief stands the test, the suit will not be a suit for land or other immovable property within the meaning of clause 12, although grant of such relief may indirectly affect land or other immovable property. If, however, by applying the test it is found that such relief cannot be granted without deciding the question of title to or possession, control or management of land or other immovable property, the claim for grant cannot be the primary objective of the suit. But what ATCON has said in 2001, this was earlier said in 1983 itself. So this judgment, with humility I submit, my lord, is not on the point of that whether there is both the leaves are required to be taken at the same time, and rather it helps my case that in this suit I have not sought for any, my lord, relief towards possession, title or interest of any property or any adjudication of that.
Yes.
Next one, kindly see, this is Vidyodaya Trust and others versus Mohan Prasad, reported in 2006, 7 Supreme Court cases, 452.
Vidyodaya Trust was Mohan Prasad.
Yes, madam. 2006, 7 Supreme Court cases.
No.
Well, there are 2. This is the 6, 7. My lord, if your lordship wants 8, I'll deal with 8 first. Whichever your lordship has first.
Both are happening.
My lord, 8. I'm taking 8, my lord. 8 refers to 6. So, my lord, let me start with 8. My lord, this is 2008 4 SCC 115. My lord, will kindly see. My lord, kindly sees paragraph 4. This refers to 2006. Vidyodhara.
Yes.
Then your lordship will kindly see the facts in that case. My lord, it's within the quotation. My lord will kindly take placetum E. Rather, placetum D.
Of the next page.
Yes, my lord, para 4. Para 4, where, my lord, Vidyodhara 2006 has been quoted from Vidyodhara 2006, paragraph 3.
Correct.
Your lordship will kindly see placetum D.
Yes.
And just a sentence above, from the averments in the plaint. Has your lordship got that, my lord?
Yes.
Placetum D, my lord, just one line above that.
Yes.
From the averments in the plaint.
Correct.
And the relief sought for, it is clear that the plaintiffs were not suing to vindicate the rights of the public, and it has not been filed in the representative capacity. The plaintiffs, 4 in number, are trustees who instituted both the suits against other trustees for personal reliefs and as individuals, and seeking vindication of alleged individual rights and not as representative of the public. The finding itself. Therefore, the suit as framed is not maintained under section 92. The defendants therefore filed an application before the district judge for hearing it as a preliminary issue, the question of maintainability of the suit. On the basis of contentions raised by the plaintiff as well as the defendant, the court framed preliminary issue as to whether the suit as framed is maintainable or not. So it's post-malwritten statement as a preliminary issue. Now, my lord, kindly comes to paragraph 6. Protect the interest of the public trust, or whether they were airing only private and personal grievance. The High Court took the view that though there were certain personal reliefs claimed as evident from the prior portion, but that was not sufficient to hold the suit was not for protection of the interests of the public trust, but to claim and enforce private or personal rights. It is held that the insistence of law was only that the discretionary reliefs under section 92 shall not be granted, and the plaintiffs had no genuine interest or intention to protect the public right of the beneficiaries, but only using the forum provided by section 92 air private and personal grievance. Further held that there was prayers to supplement plaintiffs 1 to 3 in the school management committee. So, my lord, this was what was found, my lord, factually. Then, my lord, in RM Narayan Chettiar. Malad has got that, Malad?
Yes, yes.
Coming first to the, we may now discuss the main case relied on. Coming first to the cases relied upon by the learned counsel for the appellants, we find the first decision cited by him was the decision of this court in Swami Paramatmananda. In that case, it was held that to see whether the suit falls within the ambit of section 92, the allegations of the plaint should be looked into at the first instance. But after the evidence is taken, it is found that the breach of trust alleged has not been made on prayer for direction of the court is vague and is not based on any solid foundation of fact or reason, made only with a view to bring the suit under the section, then such a suit should be dismissed.
Yes.
Thereafter, Malad, paragraph 19.
Yes.
In the suit against public trust, if an analysis of the averments contained in the plaint, it transpires that the primary object behind the suit was the vindication of individuals or personal rights of some persons or action under the provisions does not apply. As noted in Swami Parmanath, I'll just skip that for some reason, tongue twister. A suit under section 92 is a suit of special nature which presupposes the existence of public trust. Presupposes of religious or charitable character, where the plaintiff do not sue to vindicate the rights of the public but seek a declaration of the individual or personal rights of any other person or persons in whom they are interested, section 92 has no implication. Then 20, it was held that it is only the allegation of the plaintiff that should be looked into in the first instance to see whether the suit falls within the ambit of section 92. But after evidence is taken, it's found that the breach of trust alleged has not been made out and the prayer for direction is vague. As I read out, Malad, that has been stated again. So, Malad, your Lordship will kindly see that's what I've been harping for the very first day, Malad. Where is the vindication of personal rights in this plaint? That is the question.
Yes.
I have sought for declarations against the person saying that they are not acting in terms of the object of the trust. Remove them, make a scheme. I'm not saying make me a trustee. But I'll come back next day, Malad. I'll finish next day, Malad. Okay.
Census when suffering for the plaintiff, census when suffering for the defendant. Counsel for the plaintiff is arbitrated, but due to paucity of time, hearing could not be completed. Is the matter?
And the interim order is still the 20th, Malad. If your Lordship is fixing it tomorrow, day after, Malad, or else one kindly extends, Malad.
It's a non-commercial, no?
It's a
non-commercial.
Trust.
He trusts in me for that, Malad. It's a trust.
Can't be commercial.
That's nice. $26. 26.
Not with there. I'm not here on 26, Malad. Anything 27th?
27? Or second? First or second? Or second?
Second, Malad. Second.
April.
Very grateful, Malad. I'm sorry, Malad. I may not be there on 20.
The counsel for the plaintiff submitted the interim order granted earlier is going to be expired on 20 March.
20th
March and prayed for extension of interim order. In view of the submission made by the counsel for the plaintiff, the interim order granted earlier is extended till 10th of April.
But at the same time,
further order, whichever is.
But at the same time, Malad.
Time is a problem.
Oh, time shall and then or else it will go. Well, I think fixes the time and gives you another date, Malad. I think if because
45 kitna kab hai?
Any date?
First
21st of April.
4th of April.
345, Malad. 345, 4th April.
4th of April, 345 कर दिया. इंटीरियम अगर कब तक दिया था?
Sorry, 10th, Malad. I'm sorry. Sorry, Malad. Sorry, excuse me, Malad. I spoke in Hindi, Malad. I'm sorry, Malad. I'm so sorry. Very grateful to your Lordship.
My Lord's kind leave to mention the matter that I had mentioned at the time of rising, Malad, man. I have My other side
The
is
other
here,
side.
my lord.
Yes, what has happened?
My lord, undefended suit, my lord. I have taken out an application for recall of the order and my lord, for leave to file written statement, which is affirmed and my lord ready, my lord, for filing. My lord, today, my lord, the witness action, my lord, had directed to be conducted through commission. My lord, that order was passed on 5th of February. It has not yet begun, but today, my lord, is the date. Now, if I file a written statement, if they want to disclose further documents, I do not want to stand in the way, my lord. Kindly, my lord, grants me leave and let the commissioner not conduct any witness action today, at least, my lord, because
Who is the commissioner?
Mr. Obhirup Chakraborty, 2nd of January, matter was made undefended. Immediately subsequent thereto, Mr. Chakraborty was appointed on my prayer as learned commissioner.
Correct.
Today is the date fixed. It is very incidental, if not coincidental. On the fag end, on the last day when the examination is fixed, they are coming with all these applications.
May I only indicate this, my lord?
And today on board, there is no application.
My lord, 5th of February, the commissioner was.
See, there are two ways. Correct. I am leaving upon both of you. If you want to continue, because till date the application is not on record. He wanted to leave to file. If this court grant also leave, then it will be listed and it is to then you will take an application. You will take time to file affidavit in opposition. Correct. If in that case, if your evidence will continue, and tomorrow if this written statement is accepted, then the total evidence will go.
Exactly.
The total evidence will go, then it has been again in the zero.
Same course will
follow. Correct. So it is up to you. If you want to continue, then he will file then you file when the application will be listed. If it is heard.
What falls from that side is the Bible, as Lordship knows. But one
Not Bible. I am telling it practical.
Yes, but
I am telling the practical
yes,
things.
my lord, yes, but one thing haunts me, my lord, that the suit was made due to their conduct of waiting for 1.5 years delay.
That's why that will be decided. That's why I'm telling. I am not making and I am not telling anything on the merit of the matter. I am only with regard to the practical difficulties. If the application is rejected, nothing. Then your plaint, whatever the evidence is, that will continue. If its application is allowed, then the whole procedure
Then my lord,
exercise will be in futile.
subject to leaving the entire thing to your lordship, I think the today's proceeding may stand over for a week.
So how soon you will file the affidavit?
Not yet served anything.
No, if it is served,
I'll give right now, my lord.
No, unaffirmed.
It is
affirmed. It is affirmed.
It is a commercial matter.
Non-commercial,
Non-commercial,
matter. Suit of 2023.
Non-commercial made undefended. So my lordship appreciated the
Correct.
extremely lackadaisical.
So that I have to see. That I have to see with regard to all those things. So let this application. I am not passing any judicial order. Tell the commissioner to lay his hand. Let your application come on Tuesday, Thursday.
Whenever it's a non-commercial matter, whenever.
Next week, next Monday, Thursday and Friday, some.
The non-commercial.
No, what I am telling, your junior will be there for expediting the matter.
Yes.
Let it come on Thursday. I am passing in a direction for affidavits. Let the affidavit be completed, and that will till that the commissioner may be stopped. So let I am giving the liberty to file and serve the copy. It will be listed on Thursday, and direction will be passed.
Otherwise,
If you file the application, if you not file, then I will decide on the same
Of
day.
course, we'll file it first thing.
Just to lose
The leave is granted. Leave is granted to the defendant to file the application by tomorrow. After serving the short service to the plaintiff. This is the matter on Thursday.
Leave it grants to defend number 3, my lord. I am
Leave is granted to the defend number 3 to file the application by tomorrow in the department and to be listed Thursday.
I'm extremely
with the
grateful
short
to
service. With a short.
I'm extremely grateful to man.
The cost aspect may be some.
I tried to explain, my lord.